Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm your host, Nipasa. And before we head on with today's discussion and request our guests to join us, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks out there, once again, a very warm welcome to Immigration Talk Show, and I'm really happy to be here. So, yes, this is where we break down, all the immigration trends, the latest ones, especially the policies and opportunities with the experts who know them best. And today, we are going to dive into this very interesting topic, EB3 Perm and L1A in 2025. And these are two critical pathways that, could shape the future of skilled workers out there, even multinational executives and aspiring professionals looking to build their career in the United States. So, to tackle this hot topic, we have two legal heavyweights in the house who are going to join us shortly. First up, we are going to have Rob Melvin, a 26-year veteran in the legal field and a licensed attorney by the Texas Supreme Court. Rob's career has spanned the courtroom, diplomacy, and high stakes immigration cases. He served as a Foreign Service Officer of the United States Department of State, adjudicating over 9,000 visas, managing security for top diplomats like Hillary Clinton and Mike Pompeo, and mastering the complexities of employment and investment based immigration. And joining him is none other than Philip Rodriguez, uh, an immigration powerhouse in his own right, a partner at Doss and Rodriguez PLLC. Philip has 13 years of experience navigating, everything from family-based petitions to removal defense. Armed with a Juris Doctor from St. Mary's University, he delivers customized legal strategies that change lives. So, without further ado, Rob and Philip, welcome to the show once again, and it's really great to have you with us today.
Sure. Well, thank you very much for having us, and thanks for that great intro.
Yeah, thank you, Napas. It's a pleasure to be here, and hopefully we'll have some useful information for your viewers today.
I'm already looking forward. So, as you already know the topic of discussion for today, EB3 Perm and L1A in 2025. So, what can folks out there, look for this year?
Yeah, I mean, the EB3 perm is kind of a similar unfortunate circumstance as far as the retrogression goes. The For India, it's currently at a 3-year delay in the availability of the visas and in the ability to change status. However, it can be used in conjunction with some other statuses that you may have in country, uh, if as long as you have an employer that's willing to kind of go the distance with you. So we'll kind of develop that later, but they are very retrogressed for India. So that's the unfortunate news. But we will talk about how, in conjunction with maybe some H1B status and some STEM OPT and other statuses, you can have the EB3 perm working in the background and still have an ability to be here in the U.S. While the EB3 perm whole process is pending. And we'll talk about some of the delays. The biggest delay really is besides the retrogression is with the Department of Labor and their labor certification process right now. So again, we can discuss that in more detail later if you want, but they're very far behind, and it's a critical component of this particular visa category.
Yeah. And then don't forget about the L1A visa, which we're going to get into today, which is also another way, a viable way for multinational managers and executives to obtain a visa to come to the U.S. Now, it's a little different in that it's a non-immigrant visa, but we're going to get into it a little bit later. today about how you can apply, or how you can, that can lead into a possible immigrant visa permanent resident route. But those two options, they're still very viable. Rob has just discussed, EB3 perm for India. It's a little bit bigger hill to climb, but we'll be happy to get into that as we go on.
Absolutely, and we hear a lot of changes. So, what's changed? I mean, what is changing this year? 2025 in for EB3 and L1A, and also, how can applicants be prepared for this change, and maybe what can they really do to maximize their chances of success? In short,
Well,
just
one
just for now.
the short summation is going to be higher scrutiny, which is kind of ironic because they are so far behind. USCIS is so far behind in keeping up with their workload. Um, Yet at the same time, they're going to have much more extensive documentation and detailed analysis requirements. So that's going to take them that much longer to adjudicate cases or send out RFEs for more information. But the biggest takeaway I would say is submit a super complete package. There's no more, just one or two liner, descriptions of jobs. Everything has to be laid out in extensive detail, and that includes like the financial capabilities of the companies involved, both the foreign and the domestic company, or the non-U.S. and the U.S. company. They are very much going to scrutinize the financials of those companies, particularly in the L1A arena, but then also in the EB3 perm ability, basically to pay for the employee that they're petitioning. So
Right,
higher
that's what I hear.
scrutiny.
I mean, it's sorry for interrupting.
Oh, you did it. Higher scrutiny, extremely more detail.
That's what I hear. That's what I hear. I mean, they say like it's going to be like a 2 to 3 years to 5 years or even more. So you need to have a real explanation of what is your job description really about. What are you going to do in these next 3 years or 5 years, right? So we will definitely get into all those details. Folks out there, stay with us. We are streaming live right now on YouTube, LinkedIn, Facebook, and on X. Please feel free to join us by participating, and that you can do by commenting. And also another good thing is that you can call us up in case you want to ask the questions yourself to the attorneys who are present here, Rob and Philip. So what you need to do is call us on this number for 435 436. Sorry, if we can have the number, please. So the access code is 425 436 6335, and the access code is 988 888. So you can note down this number and call us up. The number, once again, I repeat, is 425 436 6335, and the access code is 988 888. Please feel free to join us. And yes, so I think my next question will go out to Philip. So Philip, if you can tell us, the September 2024 visa bulletin, indicated, a significant retrogression in the EB3 category. So priority dates moving back by a year for several regions. And how do you think is this going to affect applicants from countries like India? And what are the implications for those countries who are currently, I mean, for those people who are currently in the process?
Sure. Well, that's the bad news that Rob was referring to a moment ago. Unfortunately, with the retrogression, the bottom line up front is, in our opinion, for India, applicants from India are looking at a 12 to 12 and a half year wait for EB3 visas. So, not good news. Um, I think that's kind of what we're seeing pretty much across the board with these employment-based visas. Now there's been a much higher demand um, for these types of visas. It's kind of a wait and see. But unfortunately, when it comes to India, specifically to India, it's a long wait right now.
It is, and I think for most of the categories for India is bad. I mean, I think EB2 is where they're not even accepted anymore, right?
Yeah,
Right.
there's one particular category, and we're going to talk a little bit later when we get to, you know, further down the list of questions that you all have for us. But the EB1C, which is basically the immigrant visa route, analogous to the L1A, and can be used in conjunction with the L1A. Um, as a multinational executive or manager, and that one is only 3 years retrogressed, essentially more or less 3 years retrogressed. So used in conjunction with an L1A, a proper L1A that's approved, um, really that is, in my opinion, the quickest route. It may be the quickest route for India overall.
Yeah.
You know,
Yeah.
In my opinion.
Yeah. I
Okay. Thank
echo
you.
that.
Thank you so much. Yeah.
Yeah. Yeah, it essentially what it comes down to is it's time to start looking at other options. It's time to be creative in the avenues of pursuit for any applicants from India, any applicants from China, anyone that has these extremely long wait times. It's essentially time to get creative and start thinking about other ways that, of course, that they qualify for and that would allow them to come to the U.S. to participate with an employer, the L1A, it's multinational managers and executives. Like Rob mentioned, that's one way to get someone into the U.S. to do their job, to help grow, help facilitate international growth, and seamless operations for whatever company they're with. And
Okay.
the L1A can lead to permanent residency in the U.S.
Right.
through
When you
through
use it,
the yeah.
a double play basically.
Right.
L1A and EB1C used in
Exactly.
conjunction. So then in that case, you'd be looking at about a 2 year Department of Labor process,
Mm-hmm.
and then the 3 year retrogression. So, which is good because on your L1A you'll still have 7 year, a 7 year limit to be in that status. So you
Mhm.
could complete it time, but you have to have the relationship with the companies, that are willing to go the distance with you, if you will.
Right. Right. Well, that conjunction sounds interesting. We would love to know more about that. But also, just another thought, with I mean, Trump hitting the office right now, and it's just been about 2 weeks. Do you think the relations that he's having with these countries, which are changing, by the way, with the United States, are going to affect these categories of visas by any chance?
Go ahead. I have my opinions. Um, I think that to the extent that they are STEM related companies and fields, he's going to have a lot of people putting pressure around him, his inner circle, if you will, in
Mhm.
order to draw more, hopefully, from overseas. Quite frankly, I think we just have a lack of talent within the United States. It sounds strange coming from a U.S. citizen, but the more talent that I see, and I think we see in our practice, uh, in the STEM type related fields, is all from overseas. Um, we have we have qualified people here in the United States, but I just don't think we have enough to fulfill the very ambitious goals of this president, for the short and long term, over his, which will be his last, time in office. He really wants to accomplish a lot, and I think that with his relationships with the companies, he's a businessman. He's going to want to see exponential business growth within the U.S., and the only way to have that is to have good talent. So, if we don't have that talent pool, I don't see how you can get around it. Um, we need folks from overseas, and especially from countries like India that are extremely intelligent, extremely hardworking, capable and qualified for these kind of jobs.
Yeah,
Well, that's a
and
really nice point of view. Yeah, Philip, go ahead, please.
I was just going to add to that, and is that of course, the current president's policymakers, I'm sure, are thinking about um, what's going on that's making the news. How is that going to affect that talent pool that Rob is referring to? And they have to consider whether or not this is going to scare people away from wanting to come to the U.S. and bring their talent. We need to policymakers, again, I know they're taking this into account, and I just hope that we start seeing that we need to attract those types of workers. We need to bring them in. We don't necessarily want to, and that we don't want what's going on right now in the immigration landscape for irregular immigration. We don't necessarily want to see that affect our business and employment based immigration, because again, I'll reiterate what Rob said, and we can't say it enough. I mean, a lot of this international talent, they want to come to the U.S., and we need that talent.
And they're two different worlds. What like the mainstream media, and you watch these shows, and we're getting the calls. I mean, quite frankly, we're getting waves and waves, tsunamis, if you will, of inquiries and calls, and people very scared, very concerned, and quite frankly, just freaking out. Um, but it's two different worlds: the business world of immigration and the people that are being spotlighted in the mainstream media. They don't. One has like very little to nothing to do with the other. Um, I don't see even, you know, just like even deportations and stuff. Now, granted, if you were here in one status and it expired and you overstayed, well, you guess what? You just switched over to the mainstream news kind of scare tactics propaganda that's going on right now, the hysteria, if you will. Understandable, um, but that world does not touch the employment based visa categories at all. Um, and I mean, if you want to get into, there's allegations of xenophobia and that kind of thing. Um, Again, to the extent that's true, if it's true at all, it has more to do with irregular immigration than with qualified professionals coming in for these jobs for the L1As, the EB3 perms, the EB2 NIWs, the EB1Cs, all these categories that bring a drained brain into the United States. I still think there's going to be a high demand, and hopefully we'll see some change in the high availability with Congress now, because the new Trump has got a lot of sway with Congress. Everybody seems to be wanting to please him. So if his advisors are telling him, hey, we need these workers, then he's going to be working Congress, and having his confidants working in Congress to try to improve the situation.
Absolutely. Well, those were very well put thoughts and perspectives. Thank you so much for sharing them with us. And, it's somewhat similar to what Dung Habe wants to know. So I would like to take this up. First off, hi to Sneha, Dung, and also Ajay for joining us with your comments. We will take them up. But since it's Dung's comment is a little almost similar to what we are speaking right now. Plus, we are almost in the second week of February where the visa bulletin is going to be out for March very soon. So, do you have any thoughts on the visa bulletin progressing faster under Trump? He's asking.
Gonna take that one.
It's tough to say. I mean, that's our hope. That's everyone's hope. But really, I don't know what. I guess the true question is, what is the what influence does Trump have on helping the visa bulletin progress a little further along? I
Mhm.
mean, that's based on how USCIS is processing these applications. That's based on the visa numbers available. Sure, if Trump comes out and allows certain categories to either recapture visas from another time period, or somehow miraculously broadens the amount, increases the number of visas available. I
Mhm.
don't know and my opinion is that I don't see much change to the visa bulletin um, with Trump in office, and that's not because it's Trump in office. It's and it to me, what I've seen in my experience, a new president doesn't necessarily have an effect on the visa bulletin timelines.
And I would just add, to the extent they do, if they have any, it's not an immediate deal. So I know everybody really tracks these month to month, and because they have a vested interest, there's not going to be a 1 month significant jump. I don't think. If anything, it will be gradual,
Mhm.
and hopefully, what my hope personally is to see substantial improvement by the end of the year. You know, month to month, it can change a year or two or a couple of years, but I don't see, like, dramatic changes between each visa bulletin publication. I could be
So
wrong.
true. So true. Well, thank you for that. And thank you, Dung, for joining us. Tell us where you're from and you can keep commenting. And we will take up more questions. But we were speaking about retrogression earlier, even for India. So maybe if you give out a few tips, maybe, or what steps can Indian applicants take to mitigate the effects of this retrogression?
Well, I mean, what we do with our clients is we try to look for alternate routes of status that they can, if they want to be in country, and which is mostly the case, right? They want to stay in country until a visa is available, so they can adjust status from within. That's usually the play that everybody wants to make. So what we do is we look for any, maximize any STEM OPT options that are available. If they have an employer and they're able to get into H1B status, especially for the non-capped categories, the universities and schools and those types of deals, something where they can stay in status for an extended period of time. Uh, those are lovely. And the L1A is another beautiful one because we don't have the prohibition on dual intent. So if they can maximize their 7 years, get in an L1A status, and maximize their 7 years, then they have just like they're getting closer to the finish line. So that's what our strategy is. We look for alternate viable routes for people to be able to maintain status while they are awaiting these lengthier processes, these lengthier categories for visas to become available.
All right. So my next question would go to Philip right now. And Philip, if you could tell us, especially that reports suggest that all available EB3 visas for fiscal year 2024 have been issued, rendering the category unavailable until the new fiscal year, which is this coming October. So how does the impact pending applications, and what should applicants anticipate as we move in fiscal year 2025?
Sure. Well, and that's a good question. I understand that's a major concern for a lot of people. Unfortunately, because the cap has been reached, there's going to be a pause. Those visas won't be processed up until the new visas commence for the next fiscal year, which begins on October 1st.
Okay. Well, thank you for that. And yes, ZQ also has a few questions. We will take them up, ZQ, if you don't mind waiting a bit. But coming back to our questions, also like this is another challenges which EB3 visa availability has given out, because the current challenges with EB3 is the availability. And what alternative immigration pathways might these applicants consider, to achieve their employment and residency goals in the United States?
Yeah, that's a great question, and that's what Rob was referring to a moment ago.
H1.
With our clients, we take a holistic approach. We consider every option available, and so as far as alternative immigration paths, you could look at something like the EB2 NIW. We've had a lot of success with those applications lately. You can also look at what Rob was referring to earlier, the EB1 visas. that's a much shorter wait. I think by our estimates, we were talking like a 3 year wait for under the EB1 category. So those are two of the alternative paths that someone can consider. When they look at the EB3 perm and look at this very long wait, and they think, well, what else is available? Those are two options that are available.
And I kind of misspoke earlier when I talked about labor certification in the context of the EB1. There's several different types of EB1s, and for I think three of the four, there's no labor cert required. I'll have to go back. I'd have to go back and review. But that is important because that helps cut off, which is the other big hindrance in the EB3 category, is this whole labor certification process. So anytime you can get to a visa that avoids the labor certification process, you're gaining ground. And any type of alternate non-immigrant status that doesn't prohibit dual intention, those are great options, like the L1A.
Very interesting. Thank you so much. Because I'm sure, folks out there are just looking out for their options. Well, if it's not this, then what is the other way to be in the US, right? And from what news has it, most people, most immigrants, or people who are, on the verge of coming to America, they're kind of scared, or as in like whether they should or they should not, at this point at least, to come to America. So, what do you suggest?
I mean, go ahead.
Well,
Should they be scared?
as
I
we all,
mean,
Yeah.
yeah,
yes, Philip.
no, yeah, no, we understand the uncertainty and possibly a little bit of fear and anxiety, but generally speaking, for the most part, it's always best to apply as soon as soon as you can.
Yeah.
Regarding of when is the best time, the best time is now. Um, well, the best time was yesterday. The next best time is today.
He's not.
Uh,
Okay.
and that I will say is that can apply to almost 99% of our cases. Certainly, business employment based cases. I don't know if Rob has anything to add to that.
Well, and there's another thing too that we really don't talk. We kind of like silo our conversations, but they really shouldn't be. Like we're talking about employment based today. A lot of what
Mhm.
we encounter are young professionals, recently graduated from college, or just in the time at the beginning part of their professional life, right? Well, a lot of them, if they come over and they're single, oftentimes end up getting married. If they end up getting married to a U.S. citizen, that absolutely is the fastest path because those that category is always available, and you can do what we call a one step, which is a petition along with an adjustment of status. You can have your work permit in a matter of a few months. You can get your green card in a matter of a few months to a year. Um, so for this single crowd, if you will, I mean, often as their life develops while they're here in another category, they may end up changing over to a family-based immigration, which if the spouse is an American citizen or U.S. citizen, um, they're really fast-tracked, quite frankly.
Very nice. So, single folks out there, I think yes. So why not? So learn to fall in love with America and maybe an American too. Cool. So nice. Well, we have Dung who's come back. So I think we should quickly take his one since he's here. Let's follow it up quickly. Do you think EB3 row will hit 2023 PDs by end of fiscal year? Currently at December 22, with a 14 plus day movement in 5 FBs. There's so many short forms in this with fiscal year and PD of 13 January 23. Greetings from UK, he says.
I'll, did you
Yeah,
catch it all? I actually didn't catch it all, so I was going to refer it to
yeah,
Rob.
that got pretty down into the weeds. I didn't.
Same here,
Is he talking?
because there are so many short forms he used, but okay, I could go slow. So, do
Yeah.
you think EB3 row will hit 2023 PDs by end of fiscal year?
Uh, from 23.
will hit 23 because it is currently at December 2022.
I I hope so. Is all I can say. I mean, there's
Yes,
it's
I mean, yes, Visa Bulletin. We all hope for the best. We really hope that there are more movements faster and quicker. And I mean, statuses become current as soon as possible,
yeah,
priority dates. But we will just have to wait up. Yes. And actually, I would appeal to Dung to call us. You can call us up on this number, maybe connect with us. It'll be easier. So the question is
yeah,
more clearer, maybe. So the number is
yeah.
425-436-6335, and the access code when they ask for it is 988-888. And yeah, please feel free to join us on call. All right, coming back to our questions. This is regarding L1A, so maybe I could ask Philip to answer this. Are there any recent or upcoming policy changes affecting the L1A visa category that applicants and employers should be aware of this year?
Yes, great question. The most significant change is going to be the revised Form I-129. It's significant because that's going to require or will require stricter documentation requirements. As Rob mentioned, the theme here going forward that we're going to see is more scrutiny, more scrutiny, more scrutiny. And the revised I-129 reflects that. They're asking for much more comprehensive information regarding the employee roles, detailed proof of control over the employee and their work responsibilities, and just an overall stricter criteria for executive and managerial roles. So I would say that to me, in my opinion, is the most significant change thus far, affecting the L1A visa category.
Thank you so much, Philip. And folks out there, whenever you are applying for any category, please make sure that you are using the latest forms, whichever category you are applying for, because there has been updates and, updates keep happening. So even the January 17 changes has occurred. So just keep all that in mind. And best of all, consult an expert, consult an attorney. Why not call Rob or Philip? Their details are scrolling on the screen as well. So control, if you can display them, please, it'll be great, so that folks
Yeah,
out there can note the numbers down.
I'm sorry.
Or
You,
yeah,
we've seen several forms change multiple times within 1 year. So it's
there you
I
go.
can't emphasize that enough or support your statement enough that like the day that you're shipping that file off overnight, you better make sure that form is good or it's going to get kicked back and it's just going to cost you more time, potentially more money, or a fight with USCIS over a premium processing fee refund. We've seen
Mhm.
those fights.
I mean,
And
has
then
it
on top
happened
of
that you sent something today and it changed maybe just that same day?
they usually give you, like a couple week or usually a couple month buffer.
Okay.
But I forget which one it was, but it was a very short time frame and was almost an immediate change this last year. So it's critical to make sure at least the day you're sending it in, uh, um, that you go to USCIS's website. It's very easy to do. You just get your category and you go to the bottom and they have drop downs and it'll say current edition. And then it'll talk about we accept this edition until this period of time. After that period
Mhm.
of time, we will accept this new edition that was published rather on a date certain.
Mm-hmm. Yeah, we can't stress
Right.
that enough, especially for those applicants who, makes me cringe to think about it. But those applicants that are trying to do this on their own, certain applications that don't require an employer, um, we see it all the time, that people try to do something on their own. They submit the wrong form. They submit a fee, an older fee rather than the updated fee, and then they come to us after the fact. And in some situations, that fee's gone, the form done. We have to redo everything all over again, and it just, as Rob mentioned, it delays the process. It's
Yeah.
an unnecessary expenditure of time and resources. So it's always best always best to use an immigration attorney.
And
Absolutely.
if you're talking like forms of like an extension of stay or change of status, it can be a deal killer.
Hmm.
Because if you're filing those at the last minute, but you're using the wrong form and it gets there, by the time you find out you used the wrong form, you may have passed your exit date. Uh, and so you're out of luck. You won't be able to extend your time or change your status. So
Yes.
just avoid, especially in time critical pieces like those
Yes.
situations.
Absolutely. So, folks, don't wait up till the last moment. At least have a little buffer time for yourself. Play safe, I would say. And yes, we should take up more questions from our audience as well. So, let's take up ZQ's. All right. How does the recent comments by President Trump about DEI individuals work in core areas of administration and in transportation, like the FAA, affect the professional scenario? Will it hamper workplaces like air travel, hospitals, medicals, etc., where people's lives are at stake? And are they in the correct mindset? Are they worthy to be hired? JD Vance called it a joke. He says,
Hmm.
any
I mean,
comments?
I think it's more benefit. I have a very personal opinion that there's an extremely qualified. So what we're really talking about is moving from social promotion to merit based decision making in these jobs. If we do that, I see nothing but benefit for the Indian population because, as far as merit based goes, the level of education, the level of professional accomplishment and capability are going to put people in that category, the merit based approach to filling these jobs, in a much better well positioned than if we're looking at we need X of this type of person, Y of this type of person, Z of this type of person. Um, uh, I think that works to the detriment of of a people group like from India or even China or wherever that have extremely qualified people and will come in stronger on a merit based. Um, I think they have a better shot at it outside of the DEI context. That's personal opinion. So.
Well, and then let's not forget the current employment based process. It is currently merit based. It's so I don't necessarily know. I appreciate the question and I appreciate the viewpoint, but I don't necessarily see how the two, the DEI conversation affects what's currently in place or with regard to employment based visas, right? It is we're trying to draw top talent, and for the EB3 perm, we're dealing with labor shortages, right? So we need people that can those jobs. I don't necessarily think that the DEI conversation, as controversial as it may be, has a direct influence on employment based visas.
Yeah,
Right.
almost that.
And you very, sorry, yes.
Oh, yeah.
Sorry, I'm sorry.
No, Rob, please go ahead, please. I'm sorry.
More as a domestic uh, conversation of people that are already here within the U.S. filling specific people categories, and I even hate to even say that,
Mhm.
into a certain percentage of each job. I don't see that as applying in the international immigration and visa, especially in employment context, like Philip just said. I mean, it's just kind of it's not a fit.
Right, right. But with that said, it's still merit based, and I think this is a little positive thing that it is creating, the spirit of competition, you can say, to be best at what they do, so that they could go to America and live their dream, right? So, and I mean, so also for the Americans out there who would want to prove that they are better. So, this, I think, the spirit of competitiveness is a little healthy, so to say. All right. So great point of views, and thank you, ZQ, for your question. Please keep commenting. It's very interesting. All right. So let's go on to our next question. What are the current best practices for L1A visa holders? Who are aiming to transition to permanent residency, considering the prevailing immigration landscape. Maybe Rob can take this.
Yeah, I mean, like I said, we've said a couple times now, I think the best play is if you already are in the L1A category, the best move is the EB1C. It's almost, entirely congruous with the L1A. It's an easy slide right in there. Um, and you have the premium processing available, and you have a 3-year wait versus these 12 and 13-year waits on visa availability under the visa bulletin. So, you stay in your L1A status for 3 years while you're waiting for the EB1C process to complete, and then you are good to go. Then you get your I-485 filed once your priority date is current, and you're in your period of authorized stay, and we're golden, as they say.
All right. So my next question is for you, Philip. If you can tell us, in January, of course, 2025, this year, President Trump issued several executive orders affecting immigration, including enhanced vetting procedures and changes to birthright citizenship, which is, still yet to be confirmed, by the way. So how might these orders influence the EB3 perm process and the L1A visa applications?
The theme of the day: higher scrutiny, more scrutiny, and I think more extensive documentation requirements. Just to put a nice bow on it, that's what we can expect to see, and we don't know what's coming either. We don't know what other tightening there may be on employment-based visas. We don't know if there's going to be loosening on employment-based visas. But as far as the executive orders um, taken in isolation, their effect on EB3 and PERM, I would say more scrutiny.
And if I can just add in, because I used to work for the Great Oz and I've seen behind the curtain, I think what you're going to see is a lot more administrative processing for specific countries, right? So what they're worried about basically is somebody maybe coming under a ruse of a employment-based visa for intelligence gathering purposes. So if you have some of our major, we have diplomatic ties, but I wouldn't exactly call us the best of friends with China, for example. You're going to probably see a lot longer vetting periods, which just means in the front facing to the layperson, uh, um, the administrative processing cycle. And what they're doing is they're running extensive databases through all of the agencies you can imagine, and all law enforcement, and through Interpol, and any background information that they have, even on open source, to determine whether this person is indeed a security risk. And I think you're going to see those admin processing times much longer, let's say, for maybe potentially a Chinese applicant than you would for India. Definitely for Iran. A lot of Middle Eastern people we see get caught up in a very lengthy administrative processing process. Was it the 213G?
I think that, yeah.
Yeah. So, as far as the heightened scrutiny or security by Trump as declared as part of his policy, that's going to translate into perhaps lengthier admin processing, which was really what they're doing is vetting any applicants or
Right.
petitioners.
Right, Rob. Very well put. And I think I will say to do your research properly and see what you need to do. Make sure your documents are right, and you will have to be patient for sure. Not giving up, even though how intense this vetting process might get. So I would say all the best to all you folks out there. And Rob and Philip, we have a few more questions, but we will address them. We also have some questions in our Facebook group. So, Control has put it up.
Okay.
And if you don't mind, just let's address them quickly. Let's take this first one. Philip, if you can go with this. How long does it take for a green card and EB3 skilled?
Well, what we've seen in the past, I mean, of course, that depends on a variety of factors. But what we've seen in the past, I think we've seen probably about was it 2 years?
2.5 right now, 2 to 2.5 years. But remember, the first year of that is the Department of labor certification process. Once you get past that and you have your labor cert, you can file the petition and you can utilize premium processing to get an answer very quickly. Then, as far as then you can adjust status or file your I-45 to adjust status. And you're probably looking at, we'd have to pull up their processing times, but you're probably looking at another year or two, maybe a little more over a year and a half at most, to receive the green card once you get to that point. The thing about their processing times, their published processing times, some are pretty scary, and they're scarier. But we haven't seen a correlation to reality in a lot of the categories that we file. In fact, we've seen a great discrepancy in what they're publishing, being, for instance, 50 months on one specific category, but yet we're getting the green cards in less than a year. So I'm not quite sure where the disconnect is at USCIS, or if they're just trying to CYA, by publishing these lengthy times. But I would say once for the entire EB3 perm process, again, this is not accounting for retrogression. It's about a 2 to 2.5 year process.
Okay. Thank you for taking that up. Control, if you can display the next question, please. So, how long it will take for EB3 skilled PD March 2024?
Hmm. Priority date 2024. 12 years. 12 years to adjust status.
Whoa, that
Yeah.
is insane.
Yeah, and 11,
I think you will just have
11
to look
years.
out for another option if you want to get into America quickly.
Yeah, it's a long time, very
A
long
dozen
time.
years. And that's
Yeah.
just for the first process. It could be longer, right, Rob?
Yeah, the problem is then, so you got to tack on some time if you're going to consular process. NVC probably take a month to 2 months, you think, Philip, to get documentarily qualified. Then it's up to post, and this can be crazy because depending on post's performance, quite frankly, in relation to the workload, the demand they have their own little retrogression. For instance, when I arrived at one post, there were 5,000 visas in the hole to NVC, as far as scheduling appointments. So we strategized, we got that corrected, and actually we got up 2,500. So we had 2,500 visa interview, more capacity than NVC could supply for us. That's very unusual. Usually, Post is way behind on being able to schedule an interview, if you're going to go that route. And you could be looking at, we have one particular case, they've been documentarily qualified waiting for an interview for a year and 4 months now, or a year and 5 months. It's awful. So if there's ever a way to adjust status, it's really the preferred route from within the U.S. Over consular processing, but it's just not always available to everybody in every circumstance.
Well, thank you for taking that up. It's crazy though. Let's go to the next question.
Yeah.
This is from an anonymous participant. I have already done the EB3 probably visa. So if I process the F1 visa now, my EB3 visa will be held. In the futures, in the future, issues may or may not occur. Okay, he's asking maybe if there will be any issues in the future.
Intent, a problem with that.
Well, yeah, we don't. As far as particular specified information, we obviously cannot give specific response or specific advice. As you know, there's no attorney client relationship created here. But I think Rob just brought up a good point, and that might possibly be an intent issue.
Mm-hmm. There might be under circumstances where you have a pending immigrant visa petition. If you're seeking any other non-immigrant visa category that prohibits dual intention, they're not going to issue you that non-immigrant visa because they already see you have immigrant intent. So your knees will be knocked out from underneath you right away. So that's really not a strategy that we use for our clients because we know how it's going to end up at the end of the day.
Right, right. So, folks, I would suggest you write to Rob or Philip. You can do so by emailing them because every case is different and they would need proper details to really get to be able to help you. So, why not email Rob? And you can email Rob at robmelvin@melvinlawgroup.com. It's there on the screen. You can note down the email address. And for Philip, if you want to email Philip, you can email him at philip@dosrodlaw.com. And you can also call on this number, 979 and definitely go visit www.dosrodlaw.com to get to know more about Philip, for sure. And yes, let's come back and take up another question. This is another anonymous participant. If a visitor visa is refused, can one apply for an EB3 visa? How would there be any difficulty? Also, if a child is 19 years old at the time of application and the EB3 process takes 3 to 4 years to complete, would the child also receive a visa since they were under 21 at the time of application? Please provide guidance.
There's a lot of moving parts to that question. What we can tell you, and Rob has firsthand experience of this, being a vice consul, is whenever there is a visa denial, everything after that is reviewed with a little closer eye, and depending on the basis for the denial or the refusal, it could have an effect on a future employment-based visa. I don't. You want to add anything to that, or?
No, other than like the denial of a B1, B2 is in very informal terms a nothing burger because they're so easy to deny. You actually begin in the B1, B2 category with the presumption that you will be denied. You then have to overcome that presumption with the vice consul to show them that you have sufficient ties to your home country, that they are reassured sufficiently that you will return to your home country at the end of your allowed stay in the United States. So the fact that you were denied, and I'm not giving you legal advice specifically on this case, but the fact that somebody was denied a B1, B2 in their past, really in the immigrant visa context, will have little to no implications unless there were some misrepresentations, anything that could give you what we call a hard hit and what those are ineligibilities that are entered into your record. And ineligibilities or inadmissibilities in the context of the application for the non-immigrant visa and that whole process.
Yes. And once again, I would say please save everyone, avoid any sort of misrepresentation whenever you have the chance to give them the info which you couldn't provide earlier. You might as well do it when you get a chance. All right. So I think with that, we should wrap up the questions from our audience. But this question goes out to both of you, Rob and Philip. If you have any interesting case that has come up that you are dealing with right now, with reference to EB3 or L1A, especially after Trump has joined office, and you would like to share, you know, any note, it'll be really interesting to get to know.
Yeah, I mean, the most interesting note is not even a case from India. It's from another case that's not retrogress,
Okay.
and it's been going for what, working on 2 years now. Uh, Actually, they and we're still don't even have the labor certification yet. So it was shocking to me personally to see in that case, you got the prevailing wage determination. You know, took much longer than I thought. Okay, and much longer than they were publishing at the time. It took 9 months, so that was good compared to today. And then we did the reasonable recruitment process, so that was another 6 weeks to 2 months. Uh, then so now it's in the labor certification phase, and I check it, a couple times a month, and it's still just pending. So it makes you crazy because it's like this whole other hurdle you got to get to before you ever get to the starting line. Um, the Department of Labor is really a challenge in this particular visa category. Anytime you need a labor certification, uh, not talking about the LCAs for for H2Bs or anything like that, but a labor cert for the EB2 or EB3 perm. Department of Labor is just a mess right now, in my opinion. I'm sure they love hearing that from me, but
Well,
I challenge somebody to explain to me how they're not a mess.
yes, I really hope this just gets untangled as soon as possible. And Philip, any last notes, maybe, to folks out there who are watching us right now? Anything you want to say?
Well, sure. I just want to reiterate that I know it sounds like there's a lot of doom and gloom, but if your goal is to come to the U.S. and whether it's the professional route or any other route, speak with a knowledgeable immigration attorney who can do a holistic analysis of your situation, can look for any type of visas you may be eligible for or any type of immigration relief that you may be eligible for. Just go to a trusted immigration attorney that can figure your situation out and give you at least three. What we like to do is give 2 to 3 viable immigration options, and then ultimately it's on the applicant, it's on the viewers for them to make their decision. But again, I know there's bad news in the EB3 perm category for Indian applicants from India, but it's not all doom and gloom. Okay.
Okay. At least that's a good, positive point to end today. So I would say thank you to both of you, Rob and Philip, for joining us. It was such an insightful session, really, and we learned so much about the current situation, what's going on. But always great, to consult with an expert, an immigration attorney, and they should definitely be Rob and Melvin. So go check them out, and their contact details are as follows. So this is for Philip. This is you can call him up on his number 979-776-1325, and you can email Philip, Philip at dosrodlaw.com, and go visit www.dosrodlaw.com to get to know more about Philip. And you can also call and contact Rob. And you can email Rob at robmelvin@melvinlawgroup.com. And you can even call Rob in his number control, if you can please display. Rob's number is 512-293-3023. And once again, his email address is robmelvin@melvinlawgroup.com. And go visit www.melvinlawgroup.com to get to know more about Rob Melvin. So both of you, thank you so much for joining us once again. And I'm really looking forward for more great sessions with you.
Sure. Well, thank you very much. Quick note on those contact numbers for both Rob and I. They are available on WhatsApp for a lot of our international clients that use that channel, communication channel. So again, thanks for having us. We're happy to answer any questions that your viewers may have, and you've put up our contact information. They can all feel free to send us an email, give us a call, or shoot us a text on WhatsApp.
And it's Philip with one L, not two. Phil.
Yeah.
Nice.
Yeah. No, thank you, Pasa, for having us. It's always a pleasure. I know it's not, the news people want, but we shoot straight and we're transparent. So
Yes.
we're just going to tell you the how it really is on the ground, and we're going to tell you what the best alternate options are for everybody. So we're always willing to share the information that we have, that we're privy to.
Thank you, Rob. And really, thank you for joining us, both of you, today. So, folks out there, Rob and Philip, for you, do go and contact them and maybe have a one on one discussion. You can even let them know that you saw them here on Immigration Talk Show. They would be really happy to help you. And have a great day, both of you. And also to all you folks out there, thank you so much for joining us. You can also contact me. In fact, my number is 408-335-6444, and my email address is nipa@staffingly.com. You can even WhatsApp me in this number. And if you have any questions for Rob and Philip, I could even direct those messages to them directly. So thank you once again, everyone, for joining us. Have a great day ahead and a splendid week ahead. Bye bye.
Take care. Thank you for.
Thank you.
Bye-bye.
Hi everyone, welcome to Immigration Talk Show. I'm your host Rajni Bharara, and before I move ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to Immigration Talk Show. I'm Rajni Bharara, your host, and today we tackle a topic that is at the crossroads of opportunity and controversy. The H1B Visa program. Is it a catalyst of economic growth and innovation, or does it pose a threat to American jobs? Well, we are going to talk about that with our guest today, who is none other than attorney Aaron Green. He's not just an immigration attorney, but also an H1B visa expert. So we are glad to have Aaron on our show again. So now, without any further ado, because I have a lot of questions that I would like to ask from Aaron, so I would not like to waste any more time and directly, welcome him to the show. So, Aaron, welcome to Immigration Talk Show once again.
Thank you. Good to be here. Thanks for having me.
It's a pleasure having you. And, I was so excited for you to come back so that we can talk about this topic, because this topic in particular, everybody is talking about it, and people are so much curious to know about what's been happening. And because every now and then, just yesterday we got an update on uscis.gov about H1B visa, and every now and then we are getting so much information about this particular visa. So, before we talk about H1B visa, or whether it is good for the economy or whether it is posing a threat to American jobs, I would actually like to know from you, like from the time President Trump has taken the office, a lot of people are always having a debate about whether it is good for the immigrants, especially, or whether it is bad for the immigrants. And now that the deportation is going on, people are having so much to talk about. Some are in favor, some are against. I mean, celebrities are crying and making a video and posting that on their social media. So I would like to know from you, with all that have happened, what do you think about it? Is it like, with whatever that is happening and whatever that Trump administration is doing, do you think it is benefiting the immigrants, or is it going against the immigrants?
Yeah, I think what Trump's doing is benefiting legal immigrants, people who come here in categories like H1B, L1B, TNs, people who abide by the laws of the country, people who do not for a second want to have any kind of violation, even if it's an overstay of an I-94 or anything. So it's a good thing that when people break the law, that it's taken care of. I can't believe it's even a debate, especially at this stage. They're removing criminals right now, and hardened criminals, some of the worst. I can't believe that's a debate. But as they remove all the criminals, yes, they need to look at, for example, those who have been given asylum hearings and don't show up, when they're called, which is probably 90 to 98% of people who are given asylum hearings just don't show up to their hearing years down the road. That shows you how much of a scam the asylum entry that's been going on for years, and especially the last 4 years, where it's been elevated to a degree that no one can believe. So yes, what's going on now is what Trump promised. Those who are criminals and here illegally are being removed from the country. It's going to take a long time. But yes, illegal immigration is bad for legal immigration.
Right.
H1Bs wait years and years to do everything right. They so-called wait in line, quote. They wait in line, they pay fees, they make sure everything is right, they stress out, they do it the right way. We're the most generous country in the world. We offer the most legal green cards in the world by far. And especially when it comes to work visas and work green cards, we offer the most in the world by far. So there's a mechanism to get here. The fact that we cannot take on the entire world's poor people, even though we have a heart for poor people, but you can't just allow people to come in the country just because they're poor and tell them, just claim asylum and then you're in and you can get everything you want right away. That's not how the system should work. That's a broken system. And yes, it does affect those in the legal immigration community, like our H1B workers.
Right, very well said. But then, Erin, I would also like to know from you, all these influential celebrities who have so much influence on people, and because, people do look up to them. So, I mean, they are not directly involved with all these things, but when it comes to all these, controversies, they do share their opinions and viewpoints on what they think. So why do you think these people are, if I can say, like, crying for these people who are being deported and posting the videos and coming in favor of them, though they know that, that the path that they chose and how they came to the country was not the legal way. But then why do you think, this is also happening on the other side?
The problem is that celebrities are ignorant and or stupid. So that combination can be very influential when they have millions of followers or fans that like them just because they can sing a song or act in Hollywood or Bollywood, but here it's Hollywood. It's ridiculous. Those who follow these people are probably and believe in their opinions and what they say are probably the most ignorant people in our society, unfortunately, and not the brightest. And unfortunately, a country of 330 million will have a lot of folks who never read anything about immigration or any topic, but they get a little feed on their Twitter or Instagram or whatever they use, and some celebrity is posting that, and now they think they understand the topic. They don't. It's misinformation. It's terrible. These celebrities are the worst. If they could just do what they are paid to do or what they are famous for, which is either sports or, acting or singing or whatever, then everything would be a lot better for the rest of us. But they have to now chime in on every social topic or legal topic that they know nothing about. It's unfortunate. For your listeners, I would not pay attention to any of them. None of them are experts. None of them know what they're talking about. And, everyone has sympathy for poor people. I don't have to be a celebrity to say, I feel bad for poor people. I like them to come and have an opportunity, but you have to do it in a systematic legal way that's fair to everyone. Right. I've said for many years, if they could increase the H1B program, this is a little bit off topic. The H1B program is for non-degree workers. It's different than the H1Bs where you have to require a degree, right? A 4-year degree or equivalent. H2Bs are your farm workers, people who work in hotels. They come in seasonally, and it's great. They're usually people looking for a little bit of a better job, more money in their job, and this was established for that and to fill a need in the U.S. The problem with the H2B program is that there's not a lot of them given out. I don't know the actual number, but again, like the H1B, there's a cap in the lottery for that, and companies applies for those, and it's great. The people are vetted thoroughly. They come seasonally, they go back, they bring the money back to help their families in different countries, and then they can come back again. If we could expand that program, we could help a lot more of the world's poor. But by doing what they've been doing for the past 4 years, especially, and before, with this phony asylum claiming sham, scam, and just allowing people to come in willy-nilly from anywhere, it almost blows your mind. Right. And that's an educated opinion. I've been reading and lurking into this for years and years. Plus, I'm an immigration lawyer. But just by being an immigration lawyer doesn't mean anything. Because I know a lot of immigration lawyers, very well-respected immigration lawyers, who take the opposite approach, who think, no, all these people should be coming in and should have an asylum hearing. It makes no sense. These people don't qualify for asylum. They know it. And they're just trying to substitute some kind of logic in there to bring in masses of people. Some of these lawyers profit off them, obviously, and others are just ideologically backwards.
Right. So, but Erin, do you think, because if immigration attorneys themselves, if they, come in favor of these people and also celebrities, them being so influential and they have so much influence on people and people's mind, and also by the political parties, they are also called for campaign promotions, right? When they are going out for campaigns, these celebrities are also called. So, do you think if they make these statements, do you think it creates any kind of influence or like the government also creates this or also have decisions or makes decision based on what these people are saying?
Not this government. No.
Okay.
Traditionally, when you talk about these celebrities, they have been in our country, they've been 80 to 90, even higher left wing, meaning Democrat, very liberal left wing. We're seeing a shift now as the country saw in the last election how it had been destroyed for the past 4 years and how these folks are just preaching nonsense. We've seen a shift in a lot of voters to say, you know what, this is ridiculous. We've gone too far. These celebrities have lost most of their influence, in my opinion. And the fact that there's a rise of celebrities that are actually posing another opinion now without the threat of being canceled or, fired, which is what had happened. They use fear in their industry to hold a grip on one political position and opinion. And if you disagreed with them, well, you weren't going to get your next acting job or your next music job, etc. So now there's a big shift. If I'm an H1B worker, and I see these yo-yos screaming because we're enforcing the law, finally, I wouldn't pay any attention to them. And so that's my advice to anyone out there who's not American or who thinks these celebrities have some kind of influence. They don't, especially not on this administration that's just been elected overwhelmingly.
Yeah, glad, really glad, right?
Yeah, I can't imagine if the other side would have won, how this immigration mess would have continued and gotten worse. Who knows
Yeah.
what would have happened, leading to the destruction of our laws and our country. Who knows? But now it's time for law and order to restore the destruction that has been done over the past 4 years. And they're doing it now. They're starting on day one and they're getting going and they're just starting.
Mhm. But do you think this mess will be, I mean, all this mess that the government is or the administration is trying to clean or that they're trying to accomplish, do you think they will be able to do this in these 4 years?
In terms of stopping the ridiculous, everyone come in, we'll let you into the country, we'll even fly you in program, that's already been stopped. So it's like a drain with water. That's been shut off. Now, what has come in the last 4 years, we don't know. Is it 10 million? Is it 12 million? Is it 8 million? A lot of them came in, just over the border, and there's been no, they didn't have enough resources, and they didn't want to have enough resources to catch them. So the challenge will be how to remove a lot of the illegals that came in the past 4 years, and I don't know how long that will take. But they need to start somewhere. You start with criminals, you have a record of them, you know where they are. I think they'll move on to people who have not showed up for their asylum hearings, which is the whole reason why they were allowed here in the first place. Then they'll go after them, and but that's a whole different topic. That's not something I'm an expert in, but I certainly am very fluent in it, watching what's been going on the last 4 years in that arena and how our border we don't have a border. So now we need to build a border, and that's what we're trying to do.
Right. Okay. Now let's come back to our topic, H1B. So I would also like to know from you, Erin, that how do H1B actually impact American job markets? Because, some people are saying that it is posing threat to American jobs. So would you say that it is posing threat to American jobs? Or because we have, also heard conflicting reports about whether these visas create jobs or they reduce the job opportunities for American people?
I really think they create jobs. Look, if we had an abundance of American students who want to get computer engineering degrees and electrical engineering and mechanical engineering sometimes, and all these other related degrees, STEM, if we had an abundance of that in the computer field alone, then you can make the argument that, yeah, the H-1B is not needed, and you would see companies would not utilize the H-1B like they do now. But because we have a shortage in school of American students not taking these particular majors, they simply don't want to do coding. They find it boring. We have a great need for foreign talent. H-1Bs fill the gap immensely, and we could use even more. You can see the numbers of H-1B applications in the lottery every year. Last year was over 700,000, I believe, if I'm correct. And that doesn't even include all the existing H-1Bs that are in the country who've already made the lottery. And they're all employed. None of them are unemployed, very few. So, and you can look at these big companies' web pages, you can see all their career openings, and there's just tons of openings in these positions everywhere. So I believe that it does not hurt the American worker at all. In fact, American workers who are in the field are at a prime. Companies do not need to spend thousands and thousands of dollars on green cards and H-1Bs and extensions. If they have a talented American worker at the same level, they'll simply hire the American just by economics. So my answer is no. I don't think it hurts American workers at all right now.
Okay. All right. So also, guys, if you're enjoying this conversation and if you're getting information out of this conversation, make sure to subscribe to Immigration Talk Show and like the video, share with your friends and family who you think needs to hear this. So yes. And coming back to you, Erin, I would also like to know if you can give provide some examples of maybe some companies or sectors where you think, hiring H-1B workers has led to significant job creation.
So most H-1Bs, as you know, are computers and computer-related jobs. Now expanding into AI, which involves obviously computers, data engineering, software, anything from software to even project management, anything related to the STEM field of computers and computing. That's the biggest use of H1B. It still is. You can see the LCA data statistics. So what exactly is the question? How do these H1Bs contribute to growth in companies?
I was saying if you can provide some examples of some companies or maybe some sectors where you felt that, this hiring H1B workers have created significant job creation for, US workers. Has led to
So the IT sector. So for example, if you don't have talented folks here and you need an abundance from overseas, well, what comes with that is very innovative people. Some of them will go on to start new companies after they leave their company. They'll start startups. They'll make new products. The H1Bs who are working for existing IT companies, even if they're big companies, they can develop things within their H1B role that will lead to new products, new platforms, new algorithms. These will turn into new services and products, which will need additional employees to support them. So there can be a lot of growth, not just from the H1B worker, but from other workers. Let me give you an example. When I was the head of immigration at Infosys, I used to go to all the client sites, which were all mostly Fortune 500 companies. And I met with all the managers and we talked to all the employees and answered their immigration questions. They were all mostly H1Bs and L1s. And at the time in California, there was a big controversy over one of the clients removing their H1B department and replacing it with Infosys, for example, and another contracting company, and basically taking over the whole IT function. So when I talked to some of the managers, I said, they're removing the IT department that's there, and they're bringing you guys in. So 3 things. Number one, in a lot of these situations where the IT department is removed, they offer the jobs to the folks that are already there. In a lot of these cases, I know they did at Harley Davidson. That was one that I worked on. The electric company in California. I'm not sure about that, but going further, the managers would tell me that when they come in and bring in a specialist like, an Infosys or another company similar to that, they save them a lot of money because what they're doing is very innovative. They save them money. And I'm not talking about just saving them salaries. They know how to do things better and faster, leading to a better product that saves them money. And in turn, by saving the money, the company can hire a lot of other employees in different fields. And those are majority, obviously, American employees. So it can be a win-win approach when a lot of H1Bs come in and innovate. And that's what it leads to. Again, I mentioned entrepreneurship as some folks leave and start their own businesses or move. But yeah, I think it's a positive. I know fear mongers out there will say, yeah, but Americans are losing jobs. I don't know about that. There's so many jobs out there that if an American did lose a job, let's say because they replaced the IT department at that person's company, well, they could easily find another job. Also, some of those workers, let's face it, are not that great. Okay, so these companies have old IT departments. They're not doing very well. They come in and innovate. You can see right now, like with the government, what they're doing. They're going into all these government agencies and they're cleaning out the pork. People who either don't come to work, they're lazy, they're getting rid of them. They want efficiency. So a lot of that happens when you utilize either a big IT subcontractor, or just, you're hiring H1Bs in general.
Right. Thank you so much again for answering the question, Erin. We have started receiving a lot of questions from the viewers, which we are going to take in a bit. But before that, I would like to come back to President Trump, and I would like to ask you that, very recently, he changed his stance on H1B visa. Earlier, he said it's very, very, very bad, if you remember, and then later he said, he came in favor of it and he supported the H1B visa. What do you think? Why do you think, that sudden change of stance happened? And, what do you think actually influenced that?
Okay, first of all, he never said he was against H1B visas. In fact, I can remember during his first 4 years in office, he was very supportive of them and made statements to that effect. So if we go back in the record, I guarantee you I can find you that. If he said anything negative about it, he changes his mind. When he gets educated on a topic, he's the type of person that seems to listen to people and can change his mind. So if he did say something where he doesn't support look, he runs the Trump organization. They use H1Bs. They probably use a lot of H2Bs as well. That's, but what I've seen is that he's very supportive of H1Bs. He realizes the value in them, the need for that labor force, the professional labor force as it is. So I question those people who say he was very negative on it. And if you can send me some links of stuff he said, I could probably find you. I know I can, because I remember I can send you other links where he said the exact opposite. So I wouldn't put too much stock in something in the past. And also, if you want to look at the past history of the 4 years where he was president, H1Bs did not decline in any way. And in fact, the wait times were much less. So we're hoping to get back to less wait times, which is frustrating our whole firm and probably every other lawyer out there. It's become crazy how long you have to wait. Yeah, you can pay premium, but premium is now close to $3,000, which is crazy. It's a big expense, especially for small companies. So I think things will only get better. I wouldn't put any stock in fear mongering, which is what people like to do when it comes to Trump, just because for some reason they don't like him, and then they start making up things.
Again, thank you so much for answering the question, Erin. Let me quickly.
And I don't know where that very, very bad shift comes from. I'd like to see that in writing, where it comes from, because I don't think that's what he said at all.
Okay, all right, but thank you so much again for answering the question, Erin. Maybe if I get it, so I'll also try to share that link with you if I get that, if I see that. But for now, let me quickly take the viewer's question. But you answered it very well. But again, I would like to take the viewers' questions, and because we have been getting many, so let me very quickly take Sahil's question for now. Sahil says, as an H1B visa holder with several years of experience in the US, I have begun to question the program's impact. Do you think the H1B program genuinely contributes to job creation and economic growth, or does it primarily create competition for American workers? And I think you already have answered this, but still, if you would like to take it and answer again.
I mean, in general, I think it's good. Again, I work with recruiters all day long, my clients. I work with HR departments, legal departments, recruiting departments. But when I get to talk to the recruiters and I can see what they're doing, it's just basic common sense. If you have an American worker and you have an H1B worker and they're both applying for a role, which has a salary band, sometimes has a salary band, obviously they can go from here to here. But my point is, why would the employer want to hire an H1B worker when you have an equally qualified American worker and take on thousands and thousands and thousands of dollars and time and a little bit of unknown? Things can get denied, when they can just take the American worker, is what I'm saying. So if anything, I don't think it hurts the American worker in dealing with recruiters all day and seeing how they recruit. And yes, in some cases, they're going to need the H1B employee because there simply aren't enough Americans who have applied, or, it's some kind of niche skill and this person has it and they just happen to need sponsorship. So no, I don't think the H1Bs damage the American IT workers. I think American IT workers are some of the best off, most well-paid workers that we have.
Right. And, you're not just an immigration attorney with that, you're also an H1B visa expert, right? And if it genuinely hurts, you would know, right? More than anybody, I think you would at least know. So
typically what happens is there's a case. There's a case, someone complains because he's an American, he feels he's been wronged by his company, he files a lawsuit, and then the issue is, well, I was replaced simply by someone else because I'm American and I'm not, and that's why they replaced me. That's usually not the case. Those are far and few. I remember years ago when I was working there, when I was the head of immigration at Infosys, I remember we dealt with a lot of these cases when we were contracted to come in and perform a lot of work for some of these big companies. So there are cases here and there, but if you break it down, it's not a lot of people who are complaining. And in a lot of cases, that person simply was there for many, many years and was basically not contributing, not innovating, not doing a good job. We have at-will employment in the United States. You can fire anyone for any reason. That's how our laws work. So, but those tend to make the headlines. Something like that, it's juicy. You know, there's an element of racism in it, maybe. So those make the headlines. News reporters love to pick that up and make a whole story, and then that gets out, and people think that's happening everywhere. It's not.
Okay, so Sahil, I hope you have got your answer. Thank you for your question. And guys, if you have any more questions related to this topic that you'd like to know answer of, so what you can do is you can also give us a call on the number 425-436-6335, and you can also put the access code, which is 988888. Yes, you can ask your questions by also calling us. You can give us a call and ask your questions by dialing the number 425-436-6335. And don't forget to put the access code. The access code is 988888. Yes, and make sure to subscribe to the channel, and also like the video and share the video with anyone you feel should know and watch this episode. And for now, let me quickly take RK's question. And RK says, do you think the problem with us immigration is the employers? H2A is uncapped, yet so many undocumented agriculture workers. Had the Bracero program employers abuse the workers? Okay, I think.
Is you talking about H2B?
Yeah.
I'm not familiar with H2A. To be honest with you, our firm doesn't handle, we don't handle H2B, we don't handle H2A. So I'm not really an expert on that. I don't know if I can give a comment on that. There are definitely a lot of undocumented agricultural workers here. Is there a need for them? Maybe. Do Americans, the old argument is, well, Americans don't want to do these jobs, so we need to bring them in from, South America and now from everywhere. I mean, if that's the argument, then you got to expand the H2B program or the H2A program, which I don't know much about. And if you do that, maybe you can bring a lot more people in legally, and it would benefit everyone. That's a win-win. But Congress needs to do that. It's not something the president can do. H2B numbers, like H1B numbers, can only go up through an act of Congress. The president can't sign a presidential executive order and say, okay, we want more or less. This is set by Congress. That's why we have 80,000 right now.
Right. And, he goes on to say that layoff FYI show that between 2022 to 2024, 580K IT workers, 580,000 IT workers got laid off. Why does Congress not restrict level 1 and 2 H1B workers when mass layoffs? Keep level 3 and 4. They create jobs for H1B and USC. What do you have to say?
Well, Congress can do whatever it wants. If Congress comes together and passes a law that says you can only get H1B if you're level 3 or level 4, that will become the law. So Congress can do that. The problem with Congress is they never will pass. They haven't, I don't know in how many years, they're never going to pass a comprehensive immigration bill, either because they don't want to, they like the status quo, both sides, or they just can't agree, obviously, both sides, or because these bills are filled with so many things that they get crazy. I remember, I think it was 2012 when the Gang of Eight, when they were going to pass, I did a lot of lobbying for my company in DC, and they were close to passing an immigration bill, but it didn't happen. And then if you do pass an immigration bill, you can make some changes. You can, like what he says, maybe let's get rid of level 1 and level 2 H1B workers and just keep it at level 3 and level 4. Okay, you can do that. I don't know what effect that would have on the IT industry, because a lot of level 1 and level 2 workers are very vital. Some of them are students who finish their master's or their undergrad, and then they're working for a nice company, and they need that H1B to continue. They only have 3 years on their OPT and their STEM OPT. So who knows what the impact on that would be. I think they should create more numbers personally. We have 80,000 now. I think they should get back to like maybe 200,000 a year would be a solid number. That's just my opinion. I think judging by the cap numbers, we certainly need that, if not more. So those statistics don't lie, the number of applications.
Okay. Okay. So RK, I hope you have got your answer. In case you want to know more, continue posting your follow-ups, and you can also give us a call on the given number. And yes, but thank you so much again for answering the question, Erin. We still have a lot of other questions. Okay, Skywild Designs is here and says, hello, any news on H2B program, since it feels like employers are not proceeding with out of country recruitments? What do you have to say, Erin?
Again, I don't deal with the H2B program. I know about it. It can be very useful. It can employ a lot of good people who might not have an opportunity in their country or just want to come here and work and bring the money back to their family without necessarily moving the whole family here. It's a good program. They do a lot of jobs that we so-called may have a shortage in America on. For example, landscaping, hotel industry, agriculture, as you say, things like that. If Congress can look at expanding these programs, we could have a lot more opportunity for people who want to work, who maybe don't have the opportunity in their home country because it's a poor country or whatever.
Okay, looks like I have a slight technical problem, but I'm trying to resolve it. But meanwhile, let's go for a short break. So let's take a short break and come back quickly. And welcome back, everyone, to Immigration Talk Show. I'm Rajni Bharara, and I'm so sorry about that technical glitch that happened before the break. But now we are all sorted. And welcome back, Erin. I'm so sorry about it. And we had to take a short break, but now it's all good, and we can continue the show. And Erin, I would again like to move to the viewers' question. Because we had so many, and so I hope Designs, you got your answer. Thank you so much for your question. And let me take Empire's question. Empire says, why do groups try to remove H4EAD? Why do they keep litigating in the courts to have it removed? As well, it was on the regulator agenda in the past by the Trump administration to remove it. Why? What do you have to say?
Well, in the past, L2s and H4s were not allowed to work for many years. When I started working as an immigration lawyer, there was no work option for an L2 or an H4. And then they changed that because they figured, the spouses come here for long periods of time and are very hamstrung and handcuffed. They can't do anything. So they changed it And then L2s could work. And then for the H4s, as you know, they could work as well if the spouse had if the H1B had an approved I-140. So it's a little bit different than the L2. There's just groups now in that situation, you can make a stronger argument because an H4 can work anywhere for anyone in any position, that could impact American workers. If you think about it, it could be any job. So there are a lot of groups out there, lobby groups and whatnot, who don't want the H4s working. And they could make an argument that it does affect the American worker, as I said, because it can be in any industry at any level. So theoretically, you could just simply be taking a job, as opposed to my argument with the H1Bs, where we have an industry that we really don't have enough people in our own country. So it's a little bit of a different argument, and that's why it's constantly being challenged by groups and in the courts.
Okay. Empire, I hope you have got your answer. If you have a follow-up, please continue posting your follow-up. Meanwhile, let me come back to my questions and let me ask, the question that I prepared for you, Erin. So, Erin, recently, the new H1B visa reforms, starting January 17th, it was said that these reforms are aimed to improve fairness, right? So, what do you think? What are the most significant changes that workers and employers should know about?
I think you're referring to reforms about the lottery program. A lot of what you mentioned, a lot of what's in that January 17th has to do with cleaning up the CAP registration program so there's less fraud. That was a big part of it. There was a little bit about CAP exempt employers. As you know, if you're an employer that's not a regular employer, let's say you're like a government institution or sometimes educational entities, sometimes nonprofits, they can get H1Bs year round, so they're not subject to the cap. There was something about, making that a little bit friendlier. Otherwise, then something about how they define the specialty occupation itself, maybe when they're going to look at petitions. That could make adjudications a little bit easier for H1B. Right now, I don't see much of a problem in the H1B field. We file, I can't even tell you how many H1Bs we do every day. But so we see responses, we see the levels of RFEs. We can get pretty good statistics even internally. And right now, H1Bs do not seem to be issuing a lot of needless RFEs like they have in the past. I can remember about I think 5 years ago, we just saw, it comes in waves. So there's got to be some internal directives. We all of a sudden be quiet, and then every other H1B was getting RFE'd with the same RFE. So no method to the madness. But right now, I think it's pretty good. We file H1Bs. The wait times are a little bit annoying, but we're not seeing too many RFEs, what we call the boilerplate RFE, where you get a 10-page RFE, and then you can see they haven't even looked at it, and they just print it out and send it to you. In addition, I can see lately that with H1Bs and some other categories, they're getting a little bit better with their RFEs. I think that's internally they've been instructed to do a little bit more on asking for very specific things. So maybe you'll get a shorter RFE, but it's looking for something very specific. We're seeing a lot of that trending lately. That's good because they can focus on something that actually is a legitimate issue, and you don't have to send them a response to 10 pages of nonsense when you've already provided everything there. So, yeah, I hope that answered the question adequately.
Right. It does. Thank you so much for answering the question, Erin. Erin, with that, I would also like to know from you about, with India providing the majority number of H1B visa holders, right? So, how do you think these recent policy changes are specifically going to impact Indian tech professionals?
Well, anything that's done in the H1B program will impact any H1Bs. It doesn't matter if they're an IT professional from India or a chef from China or an accountant from Brazil. It doesn't matter. Whatever they implement, it affects them across the board. So there's no specific cutout for, let's go target. They can't do that. They can target the H1B program. They can make some changes. maybe some beneficial, maybe some negative changes. But yeah, so to answer your question, Indians specifically will not be hurt any more than anyone else who has an H1B.
Okay.
Indians and Chinese do make up the vast majority of H1B users. That is true. Sometimes they get a bad rap for it because when people are criticizing H1Bs, in a sense, they could be criticizing Indians because Indians use the most, let's say. And it's just it's an unfair criticism. I work with Indians. As you know, I was the head of immigration for Infosys for over 5 years. I've been to India a lot. I live in an Indian community in Texas. 80% of my neighbors are Indian. This happens to be an Indian community. I can tell you the Indian population is the type of immigrants we want here. I can tell you the crime rate for Indians is almost zero. There might be a little bit here and there. Very good students, very good parents. They want their kids to get a good education. These are the role models for the types of immigrants and H1B workers we want in the country. So maybe sometimes Indians get a bad rap because they're using the H1B so much, but at the end of the day, these are the types of new Americans that you want here eventually.
Right. Okay. Thank you so much again for answering the question, Erin. Let me quickly take Empire's question again. Empire is back with this question. He says, if the 580K layoff is okay, I think we already have taken this. Maybe let's take Yuri's question. Yuri says, I'm on vacation in India and was laid off effective Feb 1st, 2025 with a half-month severance. I'm on H1B exempt visa since June 2023 with stamping valid until June 2026. My return flight is on February 17th. What are my options for safe re-entry into the US?
Well, if you're no longer employed by the company on your H1B visa, you should not enter with that visa unless you have a new H1B approval for a new employer. And then you could use the visa plus the new H1B to enter. But if not, technically, you shouldn't make an entry back into the US on that H1B visa because you're not working for them. You're not on their payroll. You're separated from the company. So that technically would be illegal.
Okay. So Yuri, I hope you have got your answer. In case you have a follow-up, continue posting it in the comments below. And
if Yuri can enter on a B visa, he could come in and look for jobs while he's here. Obviously, he's not working. And then if somebody wanted to hire him, he could change status from B to H1B while he's in the US. He could do that.
Okay. Okay, Yuri, I hope you have got your answer. And let me quickly take Amarjeet's question also. So he says, my wife is on H4 here in New Jersey and also have Canada open work permit. She's planning to visit Canada as a tourist. Is it allowed on open work permit or need to apply visitor visa? What do you have to say to Amarjeet?
To enter Canada? Okay, so I'm not a Canadian immigration lawyer. I have colleagues who do rest of the world. I do US only. But an H4 can travel to Canada. I believe Indians have to get a visa to get to Canada. Oh, she said you have a Canada open work permit. So the H4 could enter Canada legally. She's planning to visit as a tourist. Okay. Yeah, I'm not familiar with what Indians need to travel to Canada. If I recall correctly, they need a Canadian tourist visa to enter as an Indian, I think. So in that case, yeah, you can't use visas and be deceptive about your entry. So if you're coming in for one purpose and not to work as a tourist, you shouldn't be using your Canadian open work permit. Same thing goes for the US.
Okay. Okay. So Amarjeet, I hope you have got your answer.
I get the Canadian visa. Yes.
Okay, but guys, Erin is not just an immigration attorney, but also an H1B visa expert. So if you want to get a detailed consultation with Erin, and if you have any case regarding H1B, you can directly get in touch with him and contact him on his number 469-459-1771. I would like to repeat the number 469-459-1771. You can also email him. His email ID is erin@eeglawgroup.com. Yes, you can also email him and also visit his website, which is www.eeglawgroup.com. So make sure to get in touch with him for a detailed consultation regarding your H1B cases or any immigration case that you are looking to looking for help or looking for a consultation. But for now, let me quickly take Rag's question also. Erin, Rag is here and he actually wants to know, okay, we have also we have people posting on Facebook groups questions related to H1B, which we would like to take, but I think we will take them in a bit. But right now we have another viewer, Rag, and it's not related to H1B, but he wants to have your guidance on L1A. So if you have anything for him.
L1A, in order to qualify for an L1A, you have to work for a company outside the U.S. that's related to the future U.S. employer. It can be a parent, subsidiary, they're affiliated companies owned by another company. There has to be a relationship. You have to work there for at least a year. And to qualify for the L1A, you have to be a manager or an executive. So if you're a manager abroad or an executive abroad and you're coming into the U.S. to fulfill a manager or executive role, then that's the most straightforward way to do an L1A. You can also do a hybrid L1A where you're a specialized knowledge person abroad and you're coming in, or vice versa. But most L1As, they're a manager in their current job, they're coming to be a manager in the US, and they've worked outside for at least a year. And those are the best cases for the L1A visa. There's no cap on the L1A. The L2 spouse can work right away as soon as you enter. You don't even need an EAD card anymore. So the L1 is a good tool or mechanism for companies who need to move their workers to the U.S. And yes, if I'm an expert, if there's one thing I'm more of an expert on than H1Bs, it's L1s. So those two are pretty much my bread and butter. I've been doing that for over 20, I don't know how many years, but yeah, solid visa. Your company will obviously have to sponsor you just like an H1B. But if you want to reach out to me, a lot of our clients are companies. Most of our clients are companies, and they do a plethora of L1s or H1Bs.
Great. So maybe Rag, you can directly get in touch with Erin. You have the details right on screen. You can note down his phone number, his email, and you can also visit his website.
Oh, one thing about L1s, I get people calling me a lot, and they're like, "Well, I don't have a company." We're a law firm, so if you have a company that you're employed with and they're thinking about moving you, yes, call me. I can speak to your company. We can explain how it works. I can talk to you. That's great. But if you're just asking about L1s, the first thing you need to do before you come to me is have a company that you work for. Same thing with an H1B. Have a company that's going to sponsor you. So once you get that company, then yes, I can talk to you and answer your questions, and we can move from there and facilitate how we're going to do an H1, an L1, whatever the work visa is.
Okay, so he's back and he says, thanks, Erin. What are the latest trends for L1A?
Trends, they've been pretty consistent over the past 8 to 10 years. The trending L1As have gotten much harder over the last 8 to 10 years. When we used to do them 20 years ago, it was very simple, very small application. You just put an org chart and you didn't need much more. But now, even an L1A, which, as I mentioned, you just need to be a manager overseeing professionals. Our applications are like this. I mean, because, there's been a big shift into attacking these. So we don't just put org charts in. We want to show them that you're overseeing people. We want emails. We want resumes of the professionals you oversee. We want examples of you calling a meeting, making a decision. Maybe you have budgetary authority. So there's no right or wrong. But when we do an L1A, the support letter can be 18 to 25 pages, if you can believe it. whereas years ago it was 2 to 3 pages. So they've come a long way with L1As and L1Bs in terms of making you prove it. Really, that's the big trend over the last 8 to 10, maybe 15 years, I'd say.
Okay, great. So thank you so much again, Rag, for posting your questions. If you have more, continue posting them. We will try to take as many as we can. Okay, so I think Skywell is again here, and Skywell says, thank you for answering that. I would like to know if you need a petitioner to acquire the H1B, and does it only get tied to Silicon Valley companies only? What do you have to say, Erin?
Number one, you do need a petitioner, but it doesn't have to be an IT company or Silicon Valley company. I'm doing a H1B for a construction company that needs a project manager, for example. I have another client that's a social working group in New York. They're like social workers, and they're hiring an H1B. As long as the job requires a 4-year degree. So if you say, well, I want this restaurant to hire me as a waiter, that's not going to work for an H1B degree. I can tell you I've done an H1B for an executive chef years ago, which was a tough one because a lot of chefs at that level traditionally don't require a 4-year degree. So we really had to prove that this role did. Not easy. But most occupations that require a 4-year degree, it can be in IT and it can be in accounting, it can be in construction, it can be really anything. As long as the role is it's a specialty occupation requiring a 4-year degree within the industry and within the company generally. And you can show that, then you can go ahead and pursue the H1B category.
Okay, so Skywell, I hope you have got your answer. Thank you so much for your question. If you have another follow-up, please continue posting it. And Rag says, thanks, Erin and Rajni. You're most welcome, Rag. And make sure, I'm sure you must have already by now, but if you're not, please make sure that you subscribe to the channel, and all of our viewers, please make sure that you subscribe to the channel, like the video, and if you think your friends who needs to know the information about H1B, please do share this episode with them. And let me take Miss K's question. And Miss K says, why would the birthright citizenship EO include work visa and students? Administration asks individuals to do it right away, but I think the executive order would punish H1B workers. Why would the administration do that? Also, why the uptick in 221G at the embassy? What do you have to, I mean, it's not related to H1B. So, I mean, if only you would like to answer, Erin.
No, I can answer the first question. The reason why they put out that executive order is because they want this issue to finally go to the Supreme Court. It's not because they want to hurt H1Bs, people here legally. They want the Supreme Court to decide who should benefit for birthright citizenship. As you know, there's not many countries in the world that have blanket full birthright citizenship that we do. So it's a very novel idea. When it was introduced in the States, the purpose of it was to give freed slaves and their children citizenship at the time, and it served a useful purpose. Since then, there hasn't been much debate about it. It's just always been the law, and it's been abused. I can tell you they've busted Chinese and other rings where they would bring in these rich folks, rich Chinese people. They put them in a very fancy hotel just to have their babies, so the kids could one day, the kids would be citizens and they could come back and then they would go back to China, for example. They busted a lot of those rings up. So me personally, I feel, yes, the Supreme Court should take a look at this and decide. And the reason why they worded the executive order that way is because they knew the next day it would be challenged. Mm-hmm. Okay, they knew that nothing was going to change, and then it will be appealed until it gets to the Supreme Court. The Supreme Court will eventually have to decide this case. My personal opinion, I think H1Bs and L1s and people who come legally should definitely maintain the birthright citizenship. I think that's a good idea. On the other, I don't think anyone who comes illegally should benefit from birthright citizenship. I just think it's just a tool, a wrongful reward for people breaking the law. I don't believe that. Now you might ask, well, what about tourists? Someone who's here not too long, like a B. That's a little bit of a gray area. I'm not sure about that. there's a lot of tourists that come in. There's more Bs that come in than any other category. So do we want to maintain the birthright citizen? That's something that's an interesting question that should be decided. There's a lot of people who feel that birthright citizenship was for a specific purpose and not for the way it's been used for hundreds of years. So we'll see. But to answer your question, Trump wasn't attacking birthright citizenships for Ls or H1Bs or people here legally. He just knows that it's going to be attacked, so he wants to get the issue out there, and then they want to debate it and have a final decision eventually about it.
Right.
What was the second question?
Also, why the uptick in 221G at the embassy?
I don't know if I can report an uptick. I have a lot of L blankets all over the world. I have a lot of you can imagine the amount of people processing. I don't report an uptick, but if you see an uptick, I don't know. I don't think there's an uptick. I just think, different embassies are harder than other embassies. For example, I do a lot of E2s. This is a little bit off topic, but E2s India doesn't have an E2 treaty, but E1s and E2s are per treaty, and most countries have them. I can tell you, for example, E2s in Canada or other countries are pretty straightforward, whereas if you try to get one in Tokyo, it can be very hard, and they're very strict. So, different consulates have different people working there and different protocols and different ways in which they decide cases, and probably the same thing for 221G. I don't know if there's an uptick now. I haven't seen anything about it.
Okay. Thank you so much for answering the question, Erin and Ms. K. I hope you have got your answer to both your questions. And if you have any more, you can continue posting your follow-ups. Even if the show is over, we will try to, share your question with Erin. We'll try to get an answer from him. But thank you for asking your question. And now, Erin, I would like to move to the Facebook questions that are posted by the people and the viewers in the Facebook group. So Control, please, if you can share the screen. And yes, so one of the viewer has said, hello, my H1B extension was approved on January 23rd at the Texas Center. So when can I expect the approval notice?
Yeah, so unfortunately, it can take, we're seeing anything. This is something that has trended downwards. It can take at least a week, 2 weeks before you'll get the approval notice. I assume you looked online based on your receipt notice, or was a premium case and you haven't received the approval yet. Either way, yeah, they can take time. I'm going to say anywhere between 7 to 13 days from when you can see that it was approved. You should have your receipt notices. That's what we're running right now, approximately.
Okay. Let's move to our next question. So the next question that we have is from this anonymous member who says, what is the current processing time for H1B approval notice to be released for master's court?
So if you're talking about the master's cap lottery, that is done on the same day as the regular lottery or the day after. They used to do that one first. They used to do that one second. Now I believe they're doing that one second. Yes, to give the Masters people a better chance of winning the lottery. They switched that about 2 years ago. I'm not sure the processing time. Processing, you mean just to get an approval notice after being approved, like the last question? It would be the same answer. I don't. This is kind of a vague question.
Okay. Maybe let's move on to our next question. So because not much details are there in this question, so let's move to our next question. So this anonymous member says, hi all, my H1B transfer has just been submitted to USCIS, but my wife and my son have to travel on family emergency to India. Is it okay for dependents to travel while petition is filed with USCIS?
Yeah, so H1B transfer, also known as an H1B portability, is when a worker finds a new employer who files an H1B and they call it an H1B transfer. everyone should know that if you wanted to, you could start working when the case is filed for H1B transfers. You don't have to wait for the approval notice, which is great. Although a lot of employees, they want to wait until the approval is in hand before they jump ship, just to make sure, give them some peace of mind. The question is, yes. So the I-539 H4 for the wife and son were filed together with the H1B, and now you need to travel. Well, look, if you have a visa that's still valid and you can travel back in, then I would say you could travel. You're going to need that visa anyway, because you're not coming back without a valid H4 visa. Sometimes what will happen is when that's filed, they will notice that the person has left the country, and they may cancel the I-539 application. It's possible. So just be wary of that. But if you have to go and you have an H4 visa to return, you can certainly do that. And in most cases, you should be okay.
Okay. Thank you so much again for answering the question, Erin. I know it's 5 o'clock, but we have completed an hour. But if you have like few more minutes, I would like to take maybe 2-3 more questions. If you're like.
Yeah, sure. I have time. That's fine.
Thank you so much. Thank
Go
you
ahead.
so much.
Yeah.
Okay, let's move on to our next question. So the next question that we have is. Control, can we please move to, okay. Anonymous member says, hello, I just came to United States on H1B in the end of December. It was finalized that employer will pay me 180,000 annually. Now he's saying to pay 150,000 USD per annum. So there will be change in petition. Is it an issue or is it normal? Please advise.
Normally, H1B employers don't lower the salary, but they certainly have the right to. But before they pay you the lower salary, they must submit what's called an H1B amendment, which tells the government that we're paying less than what we stated on the original H1B. So it looks like here they're going to file a new petition with an H1B amendment, and then they will be able to change the terms of the H1B that you're currently under. If they don't file an H1B amendment, then you're entitled to the 180,000, which should be noted on the I-129 and in the support letter, and they must pay you that. They cannot pay you less unless they file an H1B amendment.
Okay. Thank you again for taking that up. Let's quickly move to our next question. So the next question that we have says, hi everyone, sorry, this is not related to H1B. Last night I had an accident. The person in front stopped in the middle of the road. My insurance expired recently and yet to renew it. Her insurance company called me today and said the blame is on me for everything, but I can dispute it. Please, what should I do, and will it affect my green card application? How can I get a lawyer? Thank you for your help and suggestions. What do you have to say, Erin, to this person?
It won't affect your green card application. This was an accident in the road. Everybody thinks the other person is at fault. If you have an insurance company, you should have an insurance company, car insurance company they're using. I would speak to them and explain to them the situation and see what they say, because they're supposed to represent you in this situation. And then based on whatever their suggestion or their guidance is, you may get a lawyer or not. But I think if you talk to your insurance company, they will tell you what to do. Yeah. If you don't have insurance, then I would hire a lawyer. You can go online and there's a million lawyers who do personal injury. This is what this is. Just put your city, put personal injury lawyer, and you'll have 100 coming up. And you can call them. Yeah, that's what I would do.
Okay. I think now let's quickly move to our next question. Okay, this is from Yogeshwara, and Yogeshwara says, visa process for family. Hello, I'm currently on H1B and wife is on H4. We are planning to start the visa process for my parents, sister, and brother-in-law. I have a few questions on the process. Can mother, father, sister, and brother-in-law go for the visa interview together or separately? Let's take one by one. What do you have to say about this?
Okay, first of all, you have an H1B, your wife has an H4. Your mother, your father, your sister, and brother-in-law are not entitled to any category visa. So maybe he's referring to them coming to visit on a B visa. That happens a lot. Indians in the U.S. like to bring their parents here, and they come. Sometimes they'll come for up to 6 months at a time. So if you're doing that and they're going to get B visa interviews to visit you, that's perfectly fine. Your mother and father could technically go at the same time. Remember, each person needs to fill out their own DS-160 online and schedule an interview. So I think the mother and father can go together, and the brother-in-law and sister would go together separately, but together. The process for a B visa is the same, whether they're a parent or a brother or a friend who wants to visit you. And what are the documents needed? Well, for the B visa, you want to show that you have ties to, I assume you're from India, you want to show you have ties to the home country. So, maybe you get a letter from your employer. If you have an employer, your last pay statements, bring a bank statement. If you're renting an apartment, bring your last few rental payments, even the contract, the lease of your apartment. If you own a home that you live in, you can bring that. I've counseled clients sometimes to bring a gym membership to show that that's still active. There's a lot of stuff you can bring, but those are the most popular ones. And you have to convince the officer that you're going to the U.S., but you have a life to return to, and that you're not just going to stay in the U.S. forever and ignore your I-94. So, yes, I think he means getting a B. So I answered it in that context.
Okay. All right. Let's move to our next question. I hope Yogeshwara, he got all his answers. Let's quickly move to our next question. So next question says, me and my wife have upcoming travel to India for stamping. We have booked our tickets, but lately we are feeling very anxious to travel, fearing what would happen if 221G is issued, which may take weeks to months to resolve. Having said that, I'm reaching out to understand your experience. If you or your friends have traveled to India or stamping in last 2 weeks, how, they are talking about this anxiety. They want to know how people are dealing with it. How are you dealing with this anxiety if you are planning to visit for stamping in coming weeks? There is a lot on stake here with the kids' school and mortgage in US, and hence want to understand how is everyone. Okay, so this is more about, I think they just want to hear from other people, but as an immigration attorney and an H1B visa expert, what would you like to say? I mean, what would you like to tell this person?
So the first thing is when you're going abroad to get your new visa, plan ahead. You obviously want to have the appointment already scheduled while you're in the U.S. and usually schedule it for the beginning of your trip abroad, not the end. So you can have your interview at the beginning, and then you'll get your passport back, and everything will be smooth, and then you can enjoy the rest of your trip. In some categories, you can use the Dropbox. So if you've already had that visa already before, you may be entitled to use the Dropbox where you don't need an interview. Nevertheless, my advice to anyone is if you're traveling abroad and you're going to need a visa to come back and get the stamping, when you're in the U.S. a few months before, secure your interview date already, do your DS-160 and secure your interview date from here, have it all set up, and then plan your trip around that date. That would give you the least amount of anxiety because at least you have it early. Maybe there's a week or two delay. You're still good because you're there for 2 or 3 weeks, but try not to schedule your appointment towards the end of your vacation or your trip because, you got to get your passport back. And sometimes there are delays and they're out of your control.
Right.
I mean, that's the best advice I can offer.
Ms. K also has an advice to offer to this person, and Ms. K says, I don't think the child should be punished for the actions of their parents, but should remove the ability to sponsor that parent for a green card. Let's see. Well, I don't know. But let's move to another question, maybe, if we are left with any. So
That had to do with, I think that was from birthright citizenship, but go ahead.
okay, I think that's it. For the questions from Facebook, but we still have one question which is not related to H1B. Erin, this RK actually has asked this question, and only if you want to answer this. RK says, don't you think the federal government has jurisdiction over undocumented immigrants, given that they can arrest and detain them for deportation?
Yes, I do. The federal government has jurisdiction over them. If they're here breaking the law, they can certainly arrest them. Coming in illegally is breaking the law, so you can arrest somebody for that if you're here illegally. I just came from the Bahamas 2 days ago, and I went through customs. In this case, it was in the Bahamas. It was pre-clearance. But can you imagine if I just ran through there? What would happen to me? And I'm an American. I would be tackled, number one. I would be held in secondary. I probably would be arrested, just for starters. I don't know when I would get into the U.S. I don't know what would happen. But yeah, so obviously the federal government is charged with overseeing our immigration laws, not the states, the federal government. And they have the power to arrest and to, to make the laws, obviously, to enforce the laws or not enforce the laws, as we've seen. So, yeah, that's a pretty basic question.
Okay, I think that's it. Thank you so much to all the viewers for asking these amazing questions. And thank you so much, Erin, for answering all these questions in so much detail. And we really, really loved your insightful answers. And, honestly, I would love for you to come back for another episode. And guys, if you want to get in touch with Erin for a detailed consultation, make sure you give him a call on the number 469-459-1771. I would like to repeat the number 469-459-1771. You can also email him. His email ID is erin@eeglawgroup.com. You can also visit his website, which is www.eeglawgroup.com. So make sure you get in touch with him and his team. And thank you so much, Erin, for being here. Really, really, a great episode. And I really would love for you to come back. So I'll get in touch with you. I'll share an email maybe whenever you're available. So we can do another episode on H1B or maybe L1A, right? So
yeah, we could do L1As for an hour. There's a lot to talk about there. If you have a lot of L1 folks and listeners, that could be a good one. Green cards are always interesting. Yeah, so thank you for having me. I love talking to you, Regina. You're a great host. You're very smooth. I think I should see you on the TV here soon. If you're going to go into journalism, you'd be good. You could ask some great questions. So, but yeah, thank you. Yeah, I look forward to any time. I like talking.
Thank you so much, Erin, for your kind words. Really hoping to see you very soon, and we'll decide on the topic. I'm going to frame a topic and share it with you. But for now, thank you so much for being here. And guys, thank you so much for your questions and for joining the session. We'll see you again very, very soon. We have another show coming up, Daily Immigration Dose. So make that you are tuned in on that. But for now, I'll have to take your leave. Make sure that you like this video, share this video, and also subscribe to Immigration Talk Show. I'm Rajni Bharara signing off for now. Take care and bye. Hi everyone, welcome to Immigration Talk Show. I'm Rajni Bharara, your host, and before I move ahead, let me read out this very important disclaimer, which is here on the screen. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back, everyone. I'm Rajni Bharara, your host, and you're watching Immigration Talk Show. And today, we have another very insightful episode where we break down the most pressing immigration issues. So, without any further ado, I would like to talk to you about the topic that we are going to discuss today. So, the topic for today's discussion is asylum and deportation, which are making headlines and sparking debates and leaving many people with a lot of questions about their rights and also about their future. What happens after deportation? Can you ever return to the US? How do new immigration policies affect asylum seekers? To help us understand these crucial issues, we have a very special guest, Ruby L. Powers, a top immigration attorney and founder of Powers Law Group with nearly 2 decades of experience. She has been at the forefront of immigration law, advocating for countless individuals and families. So if you know someone who's facing immigration challenges. So stay tuned with us. You can also share this episode with anyone who's facing deportation issues, asylum issues, or any immigration challenge so that they can help themselves with all the information. But now, without any further ado, let's dive into today's topic and let's welcome Ruby once again to Immigration Talk Show. Hi, Ruby. Once again, welcome to Immigration Talk Show. How are you?
Oh, I'm great. How are you doing? Thanks for having me again. Appreciate it. Good to see everybody.
Thank you so much for your time. Thank you so much for coming back. It's always a pleasure hosting you. And Ruby, we have today a very important topic that we are going to discuss: deportation. A lot of controversy and a lot of things been happening around deportation and also on with asylum too. So now, if you can please go ahead with your presentation that you have prepared for our audiences.
Yeah, love to do that. So, there's lots of changes over time, and we here at Powers Law Group have represented individuals from 43 different countries, maybe more. I just have to update that list from all over the world for asylum here in the United States. But we're also talking about removal, deportation matters as well. And so, what's important to note about that is that the laws, the policies, the interpretations, the memos, things have changed over time, but a lot of things have changed even in the last couple of weeks since the new administration went into effect and into office. And so we're going to give some highlights about that, but I'd love to just be a resource. And I will say, like you sort of mentioned, is like, this isn't legal advice, and this is an opportunity to give some general ideas and just sort of like a big picture. But really, every case deserves its own consultation where an attorney can evaluate, review documents, and give you a tailored strategy for your case. And so I am board certified in immigration here in Texas, and it's federal, so I can help individuals around the world on U.S. immigration matters. So one thing people get a little mixed up is the difference between the word like refugee or an asylee and all these types of things. A refugee is someone who's already been, in terms of our U.S. laws, has been deemed a refugee and waited for their visa. Their resettlement in another country, and is once they are here, can soon apply for legal permanent residency. They're not applying for it when they get here in terms of their refugee status. They already have the refugee status by the time they arrive. And one thing to note, as I'm mentioning updates and changes, is that under Trump's first administration, and like this one now, it reduced the number to, I think, nearly zero of those who could be resettled here for refugees. But going to asylum, this is a series of a lot of law from many years ago, but then it's also a lot of case law and things like that. And then an individual applies for it when they're in the U.S. This does get confusing, though, because of something that was created under the first Trump administration called the Remain in Mexico, or the Migrant Protection Protocol, where individuals would apply outside and wait outside. So anyway, I just want to give a little understanding about that. So overall, like big picture, an individual needs to prove that they have fear of past persecution or fear of future persecution. on account of one of the 5 protected grounds: race, religion, nationality, political opinion, or a membership in a particular social group. So sometimes with race and nationality, we get into things about like ethnic groups and tribes and things like that. So it's and a lot of times these things can be very intertwined with things like religion as well. So it really takes an experienced attorney to go and walk you through the process and really get to understand your situation. A lot of times they call this political asylum or asilo político in Spanish, but it doesn't have to be because of your political opinion. That's just one of 5 prongs. And the membership in particular social group is something that can be sort of like crafted to the particular situation. But there is a lot of case law about how it needs to be identifiable. Like for sometimes it could be, I'm just throwing an idea out there of like women who cannot leave their partner due to domestic violence. And there was some case law along those lines because sometimes the women weren't necessarily married to the individual, but they so that was like matter of ARCG, I believe that was. But anyway, those case law can come and go, and so it's important to know what's the most updated case law for the particular case. There is a high burden to prove, and sometimes people are detained while they are trying to put on their case. There's not a lot of legal aid or low-cost immigration services with nonprofits. In fact, even just recently, there's been a lot of cuts to funding, including just for things like Know Your Rights. And there has been a lot of backlog. And in fact, under the Biden administration, they reduced a lot of the backlog by dismissing or terminating cases that were not a top priority. But what we're seeing is that there's a renewed sense of wanting to put people in immigration court, and we're also seeing things like having some hiring freeze and cuts with immigration judges just recently. So we'll continue to monitor that. But I think some of the process in which the new administration is trying to move things along is with an expedited removal, which has just recently got expanded to include people who've been here for less than 2 years. Before it was 2 weeks. And those who were within 100 miles of a border international airport, but now it's within 2 years, which does encompass a lot of people. When people do what was happening for a while was that people who wanted to come in through, I guess, a regular entry, if you will, or not a irregular entry, is that they could apply for the CBP1 app and wait their turn to have an interview and be legally paroled in at the border. This was a really great way to have people safely enter and to be processed in the system. And they still would be able to apply for work authorization while they were working on preparing their case in court. But unfortunately, on January 20th, CBP1 was discontinued for this purpose. And so many people are still remaining in Mexico waiting to know what to do because they had sold other things when about one-way tickets were waiting for their interview appointment. So now we're in a sort of a new space the last few weeks of what the new normal is going to be. I actually was at the border last week, and a lot of the nonprofits who were talking about losing their funding, they were talking about how it was a lot quieter because people weren't able to come in through the CBP1 app, and then just a lot of what work had been done over the last few years. So that was something I was able to see, but a lot of the activity now is happening on the Mexican side, where they're building detention facilities and getting ready for more deportations and remain in Mexico. So there's more detention in the works, especially after some mention of using Guantanamo Bay. I'm not exactly sure what the plan is there, but there is talk of like people have more serious crimes. There's also, when people apply or get in court, there could be applications for other opportunities, but for the most part, constantly these things are starting to reduce the options that people have. What we're also seeing is more ICE raids and detentions the last couple of weeks. Not sure if that's going to slow down soon, but we did see some of that reports, especially in cities that have been more immigrant friendly and have higher concentration of immigrants. And certain parole programs have been discontinued, like the one for the Cubans, Nicaraguans, Haitians, and Venezuelans. In addition to that, they decided to discontinue the TPS for Venezuela from the 2023 version, which will expire in early April. And like we mentioned, the expedited removal is being expanded, as well as Remain in Mexico is going to be coming back. There's concerns about workplace raids and arrests, and there are some websites where people are posting where they're hearing about raids. And we're also, because of those expedited removals, if an individual is pulled over or found, interacts with ICE, and does not have proof that they've been here 2 years or more, it can lead to an expedited removal, which means you don't see a judge and you could be quickly processed to return to your home country. So that is really important to note. One of the things we're saying to people is to make sure you have proof of your status and that you've been here 2 years or more, if that's the case. We'll also tell people to make sure you have a consultation with an experienced immigration attorney so that you know your strategy. We're seeing some people concerned and even preparing to leave on their own, but we see that I think it was initially the administration's intent. And I think one of the questions you mentioned is like, can you come back? Well, if a person has been here unlawfully at some point, they could potentially, by leaving, trigger a 3, 10-year, or a permanent bar. And so that gets really technical. The other thing is, if you leave on a deportation, you would need a waiver to return in less than 10 years. If you leave on an expedited removal, you would need a waiver to return in under 5 years. So depending on the terms in which you had inadmissibility or how you leave, it can affect how we try to get someone to come back. There are a lot of mixed status homes here in the U.S. where that means is that maybe the kid is American and the mom and dad is DACA, and then the other parent or something doesn't have a status. And so that's really where we see a lot of the issue right now of that. So because of that, it's causing a lot of families to want to stay at home and make plans and be really concerned. We also heard word this last few weeks about places that were normally deemed safe under the Biden administration, like hospitals and churches and places of worship and schools. Now, ICE doesn't necessarily deem them as a safe place, but that they couldn't go. We've only heard reports of a couple of schools that were, that we know of, that the ICE visited. But I think just the thought of it has caused so much unnecessary stress for families and we hear reports of people wanting to just withdraw their kids altogether. But it is allowed to go to school regardless of your immigration status. And I think this is really just more of a scare tactic. And I really would suggest for kids to stay in school as much as they can. This really does break down the community. I did a speech last night in a local community and people were afraid to come out, but we were able to do it over live social media. And but basically we did hear reports of people who did come out to telling us how much they were afraid. And even we were hearing reports of people saying, just stay home and try to avoid interacting and going out. It almost felt like the pandemic in a way where people couldn't leave. It seems like that's what's happening. And we're also hearing of people just like not going to work, not driving, not shopping, not, being out there on top of the not wanting to send their kids to school. We also had the concern about birthright citizenship, but that's been challenged. We don't really feel too concerned about that, but it has been another thing that's scared people. We did talk about the EB1A program being canceled. And, really a big part of all of this is just going to be the disruption in labor with people not able to come into work or ICE raid fears, and just also a lot of fear about mass deportation and humanitarian risks. So, generally when one is in court, there's asylum, withholding of removal, U visas, but even a U visa is not a reason to allow somebody to stay while they're in immigration court. So that was another update recently as well. And that was something that Trump 1.0 did as well. Cancellation of removal in some cases, if you've been here 10 years or more and you have extreme and unusual hardship to U.S. citizen, legal permanent resident, spouse, a parent, or child, and good moral character. We've also been hearing, and I don't know if this is out there in the world yet, but this part is out there, is that ICE will start going to immigration court. And so now there's more concern about people wanting to go to court. I'm also seeing some trends of WebEx to be able to attend hearings over WebEx being denied. I've seen that twice this week alone, not just with myself, but another colleague. And so that means that people are going to have a harder time getting representation. So I think just overall, we're really letting people know about knowing your rights. You don't have to open the door for ICE without them having a signed warrant by a judge. Ask them to send it underneath the door, put it in a window so that you can see it. But it has to say like the name, the date, signed by a judge. If you just Google the difference between like a ICE warrant with the judge signature versus administrative warrant, you can see that they vary differently. And we've heard reports that ICE was trying to use an administrative warrant not signed by a judge to have people open the door. Make sure you keep your documents organized and have a trusted guardian for children. And again, we can't overemphasize having an attorney who knows your case and is prepared. If you've ever heard of the concept notice to appear, that's like a summons to going to immigration court. And that is really what puts a person in immigration court jurisdiction. And it's important to know and to adhere to any dates and times that they ask you to come. Order of supervision is when a person is under sort of custody, if you will, in a way, by ICE and checking in on a regular basis on different conditions, like ankle monitor, phone, or just checking in. Final order removal is pretty much the final deportation order. But if you, in a hearing, if you are denied, you are allowed to appeal, but you have a short period of time, 30 days to file that appeal. So it's important to pay attention, to have an attorney, be prepared, and have help. There's a lot of different organizations out there. I'm a part of the American Immigration Lawyers Association. They have different list of attorneys, but for the most part, it's important to be prepared and know the difference between a judicial warrant, not provide information unnecessarily, don't sign anything you don't know, and have a plan in place and have that consultation with an attorney. So these are just some high-level key points I wanted to share. We are seeing a lot of changes right now, and that can open up lots of questions. So, and one thing I want to say that's sort of related to all of this is a new law came out last week called the Lake and Riley Act. And one of the big things to take away with that is that you have to, basically, even with a simple arrest of shoplifting $100, then an individual could be mandatorily detained, which is a huge, stark, complete difference from before, because an arrest doesn't necessarily mean it's a conviction. What arrest means is that someone they think there's something there, but you're still presumed innocent until proven guilty. But the fact that you could now be mandatorily detained is almost as if it's saying, hey, you're guilty. And that's not the way things have been. And that I don't think that's fair. I think we're going to still see some litigation about that. But unfortunately, it's out there. And there's another component about considering whether or not it's retroactive, which I think a lot of lawyers, including myself, think that would be challenged, because when people pled to things, they didn't know that this law was going to exist. And there's other case examples where it was deemed unconstitutional for it to be retroactive if you didn't know the consequences. But anyway, what I would say overall is don't be at the wrong place at the wrong time, and make sure that you have some funds available to know to hire an attorney. Try not to scamp out on this, because if you just sign stuff and you're like, yeah, I'll just be deported, like it could take years, it could take thousands of dollars, and it might not even be possible to come back, and you could be separated from your family. So this is really some serious stakes here, and we just want to make sure these types of things. And before we open up for questions, like, we're providing a lot of information on our social media, trying to get videos and webinars and different info out as it comes out, including our newsletter. But really, just knowledge is power, and so lean into that. And those are sort of the highlights of what's going on the last few weeks, and just in general in asylum.
I'm sure it really helped our audiences a lot. Thank you so much for that detailed and amazing presentation. But before we take up these questions from the viewers, I would like to actually ask you, because I'm sure a lot of people must be right now in the fear of being deported. I mean, because you already know that the Trump administration has said that they are going to deport people in millions, right? So I actually would like to know from you that the people who must be thinking, what if next is their number? What if they get deported? So what are the reasons, or what actions could lead to someone actually being deported from the US? If you can also talk about that.
Well, we've got different scenarios. Okay. So if a person is been here less than 2 years and hasn't filed anything, then they're very likely going to be, if they were to interact with immigration ICE, it really could be that they get pulled over for something, and the police call ICE. Okay, that could be another example. So if somehow an individual interacts with ICE, and they've been here less than 2 years, and they haven't submitted or filed anything, it's very likely that they'll be expeditedly removed, which means you don't see a judge, it moves fast, and you're pretty much put on the next bus or plane with individuals from your country out of the U.S. We've heard reports of people not having proof of their time here, and therefore it almost moved really fast. And I mean, I think the thing is that the people that are being expeditiously removed, I don't think they either have an attorney in some cases, or the attorney can't jump in fast enough, or they're not having documents on them. There's very few stories that we're hearing about what really can be remedied, or it didn't happen before they just are already gone. That's one thing. The other thing is that the people who already had a deportation order have been a focus as well, especially those who've been doing order of supervision check-ins. That's what we heard was like that first weekend's primary focus. If you've already had a deportation order, really your options are trying to reopen the case and to do a stay of deportation. So those are different things. If you're in court, I think even what we're concerned about is that if you have been here less than 2 years and you haven't filed anything, you want to be careful, because we're not really sure how aggressive they're going to be on this expedited removal process. Some of the language is very vague, but let's go to like maybe more plain vanilla type of cases, which are like they're in immigration court, they've been here for a while. Normally, when you in that situation, you tell the judge what we call form of relief is, like asylum, withholding, convention against torture, and you wait for your day in court, which could be another year, 2 years. You put on the whole of form of relief and your defense, and then if the judge says approved or for whichever form of relief, then that wonderful, right? But if they say denied on everything, let's say, then you would have 30 days to do an appeal. We are hearing reports. I don't know if this is true or not, so I don't know if I should say it, but I think things are going to get a little more aggressive potentially with ICE in the courts, and trying to challenge people not to doing appeals. So this is where we're getting really a little concerned, even as advocates, what might be going forward in the future. So I think at a very minimum is sometimes people file things with, I don't know, a friend or someone who says, I can fill out a form. But one thing I'm going to say is, like, especially when people try to do that for asylum, when the attorney has to clean up the mess and go into court and say, like, why the judge is like, why did this application say this and this application said this? Or this statement, we get it's so hard because the judge starts putting doubt in their mind. The discrepancies put doubt in the mind and of the judge, and then really the veracity of their story is truly on trial. Is really just can the judge believe them or not? And so when people try to do things like cheap, and I get it, like there's not a lot of funds and you're trying to like recoup and build a new life. I get it. I understand. But it really can hurt their chances on a case that otherwise could have gotten approved. So I just want to say that because I've seen a lot of consults recently and from my prior work and just, trying to clean up some messes like that. But they're generally, if you have a decent case, then you can put and you're good on the stand and you can do the best you can. It really also depends on where is your case being heard in the case law, the judge, the trial attorney, you on the stand, your attorney, and the facts. I mean, it's a lot of different factors.
Right. I'm sure. And guys, if you are liking this conversation, make sure to like this video, share this video with anyone who might need help regarding their asylum cases or deportation cases. And also make sure that you subscribe to the channel. And Ruby, we are getting a lot of questions actually from the viewers. Thank you so much for answering the previous one. Gagan is also here. Hi, Gagan. We would like to take your questions, but I would like to take your questions maybe after my question. So, but Ruby, I would also like to know from you that if like someone's immigration case is already going on, right, and then they are being detained, so what rights do they have? What can they do at the moment?
So they're detained, or you said, well, it sort of depends on what provision that they're being detained under. So for the most part, if you're not in expedited removal and you're being detained, for the most part, you're still given an opportunity. It also depends on did you have an expedited removal or not. So let's say you don't have an expedited removal, and for the most part, you can still have you still have an opportunity, maybe for a bond or parole. It depends on what provision you're being detained under. Most people want to go that route to try to get out and to fight their case outside of detention. That's always better to be outside of detention. It is always better because you have more time and it's less stressed and focused. But when some people cannot get out of detention because they're mandatory detained or what have you, and when you win, sometimes that's awesome because you get the hearing done really quickly and then you can move on with your life. So we've seen that happen as well. But you're going to be able, and I say for the most part because the things are changing a lot in the different provisions, but you generally are able to tell the judge what you're going to be applying for, submit your applications by the deadline, and if you cannot get out on bond or parole, you have to do your hearing inside detention. Now, this is like a typical case, but if you had an expedited removal, you're not going to see a judge. If you had a credible fear interview and there was a negative, you can see a judge for a evaluation, but even some of these things are starting to be changed. So I would say that if someone is thinking that they're going to be detained, whether they're outside the country or inside the country, to try to team up with an immigration attorney that you trust and knows your case and could be prepared if necessary.
Okay. Thank you so much again for answering the question, Ruby. I would like to come back to my questions, but I think I can give my questions rest for a bit. Let me take viewers' questions now. Maybe Gagan's question first. So Gagan says, do you think affirmative asylum backlog will come down? What do you have to say?
Well, I'm not sure. I would love that. But okay, lots of different factors. I think that the federal employees have had a lot of overwhelm this last few weeks, including with some of them being told they have to come into the office, and that's a huge change from what they were doing before. So I think that's going to impact some of the decision making and the process. I think the other thing is that those who are in the country, okay, let's talk about the Venezuelans from TPS about to end. If some of those individuals haven't applied for asylum yet and affirmatively and are eligible, then that's going to create more of a backlog there. I looked at statistics even just recently, and I don't think the backlog's going to go away unless they put a whole lot more officers on the process, and maybe change some of the process in some way. So I really don't think so. I think I don't think it's really sustainable, unfortunately. And we've been filing mandamuses for cases that have been pending more than a few years, and that's how we've been able to get some interviews.
Okay. Okay, so Gagan, I hope you have got your answer. In case you're looking for more, please continue posting your follow-ups. We'll be more than happy to take them. Next, let me quickly take Kunal's question maybe. So Kunal says, I've been in the US for a few years under a tourist visa. Now my visa is expiring. Should I apply for asylum before it expires, or will that look suspicious to immigration authorities? What do you have to say, Ruby, to this?
Well, okay, so let's just say that you're normally supposed to apply, if you're going to apply for asylum, within 1 year of entry. There are some exceptions with change circumstances and exceptional circumstances. But normally, if an individual is here on a tourist visa, normally it's only good for 6 months at a time. So I'm curious as to, did you come and go, and where did you go? Because if you went back to the country that you may be going to apply asylum from, then that can look bad. So those are some of my questions. But let's just pretend that you entered and you had maybe 6 months and you're still here. It's ideal if you're going to file for asylum to file before your status expires, or while you're in the status, so there's no unlawful presence time. But it's definitely ideal to apply within 1 year if you're going to apply and you qualify, so that you don't have an issue about the 1 year filing deadline. But if you are in a status like, let's say, F1 or E2 or TN or something, I don't know, something like that. No, TN is probably not that likely. But then if you're still in a status, even though it's been for a few years, then you still can meet one of those exceptions for the 1 year filing deadline. So that's more of the concern. The looking suspicious, I think, is the question is why did you wait until when you did? That's really where when they sit down and they get the luxury of seeing everything play by play in the retrospectively, then they question things like, why did you do what you did? So anyway, that's just a short answer, I guess.
Right. Thank you so much for your answer, Ruby, and thank you so much for your question, Kunal. I hope you have got your answer. In case you're looking for more, continue posting your follow-up. But Ruby, here I would also like to know from you that, after getting deported, so is it like common for deported individuals to have their passports, maybe taken away upon returning to their home country?
They normally are given back their passports when they return, and sometimes when the U.S. has an agreement with the country, they might not even need it to go back to their country. So I think it can depend on a lot of different circumstances. It used to be that would cause the delay while the individual was detained, waiting for the consulate to work with the government and to get that passport. But I think there's being some changes in that process.
Okay, and let's say if their passports are confiscated, so how can they retrieve them?
Well, that's always been a question of mine, because the passport is of the government of the country that the individual is from. It's not a U.S. government document, and I don't really understand where they get the power to take that away from the individual. Mm-hmm. But normally, you can get it back when you're in the process of being deported, or you can try to get a new one from the government of your country, if you're free and able to. But that also causes consequences if you're applying for asylum from that country, because you don't generally want to apply for a passport from the country that you're applying for asylum from. So it can be a challenging process. It does happen where they do take the documents, and it can be difficult to get them back.
Okay. And after deportation, I mean, how long are individuals typically banned from re-entering the US?
So the general rule is that if you have a deportation order, it's 10 years. You can't come back for 10 years without a waiver. So if you have a waiver and a visa, then you could come back sooner. If it's an expedited removal, it's 5 years that you would need to stay out 5 years, or you can come back sooner. But again, if there's some other complication, like you overstayed, you overstayed, and you have a permanent bar, it can also add that 10 years to the equation as well, that you truly have to stay outside the country. So, but just solely on your specific question about the deportation, it's 10 or 5 if it's expedited removal.
Okay. Thank you so much for answering the question, Ruby. And guys, if you're liking this conversation, if it's informative to you, if it's helpful to you, so make sure to like this video, share this video, and also subscribe to Immigration Talk Show. And now let me very quickly take Vishwanathan's question. So Vishwanathan is here and says, I think this is regarding L1 processing, but still, if you're okay, I would like to read this question.
Yeah,
Do we Okay. Do we expect more challenges with L1 processing? My petition filed on 27th January. Any delays now post 17th January in processing premium petition processing?
Well, we haven't heard of a concern about the premium processing so far. I mean, that was a concern under the Trump administration 1.0, that he got rid of it for almost everything, I think. And so, but what I would say is that there's been so many changes, and there's been a lot of fear and concern about the federal government employees about being, told they have to come in the office and do this and do that. I mean, there's been a lot of things going on. So I think there might be some just general delays because of that, the change in administration and how it's impacting the adjudicators and their lives. So that's all I could think of at the moment. I don't have anything exactly on point for that would affect that case.
Okay. Okay. All right. So, Vishwanathan, I hope you have got your answer. In case you're looking for more, continue posting your follow-ups. Thank you so much for joining this webinar and posting your question. Let me quickly take another question. The next that I would like to take is of Lokesh. Lokesh says, what should I do if I'm already in deportation proceedings and I fear for my life in my home country? How does asylum work when you're already facing removal from the US? What do you have to say to this, Ruby?
Well, if you're in immigration court, you probably, depending on where you are in the process, you have to tell the judge what you're planning to apply for. So you would need to apply for asylum, withholding of removal, and Convention Against Torture, depending on, these are forms of relief you apply for when you are in immigration proceedings. You can apply for affirmative asylum outside of court, but when you are in court, this is what you can apply for. So this is so I don't know where you are in the process right now, but if you have been told to go to a master calendar hearing, that's what the judge is going to ask you that first hearing. What are you applying for? And that's when you tell them, and then they're going to say, okay, well, this is the deadline, and this is when you need to submit everything, and this is your final hearing. And at the final hearing, that's when you're going to have the opportunity, if you have an attorney, or you to explain your situation. But you usually only have a couple of hours to put on a whole hearing, and this is really important for you to do the best you can. Ideally, you need to have an immigration attorney who has experience and help you. But yeah, this is where you can apply for asylum in immigration court.
Okay. Lokesh, I hope you have got your answer. But Ruby, with this, I would also like to ask you that, are there circumstances under which a person might receive a lifetime ban also?
Well, we don't have. So let's just say there's the 3-year and the 10-year bar of unlawful presence. For unlawful presence, there's the permanent bar, which means you stay out for 10 years. There's different inadmissibilities and the consequences of them. One of them is if you don't go to your immigration court hearing and you have what's called an in absentia order, deportation order, in absentia, like you're not there. If you leave the country, you could be found that you cannot come back for 5 years, like legit stay out for 5 years before you can submit a waiver on any other issue you might have. When we say permanent bar, we mean you stay out for 10 years and then you need waivers to get back in. So, but where I think the answer to that question, what you say, is we don't necessarily have something called a lifetime bar, but what we do have is if you have an issue that there is no waiver for, then it could be considered like a lifetime bar. Because if there's a matter that I don't know, some like national security issues or something like that, terrorism type of things, and that those certain different issues, like there's no waiver for certain things, and so that's really what the concern would be. That means if you get found for those problems and admissibility issues and you leave and there's no waiver for it, then it is like a lifetime ban.
Right. And I mean, is it possible to also maybe appeal or shorten this ban period?
Well, so I do a lot of speeches on like waivers and stuff. And so what you really have to do is you have to see what is the inadmissibility or issue, and is there a waiver, and are you eligible for it? Because like maybe a person doesn't have a qualifying relative or doesn't have the hardship standard or whatever it is. So it really can be limiting, especially if the individual doesn't have those relationships. There is a non-immigrant waiver, but I find those have been very difficult, especially with the level, the non-immigrant waiver. The concerns are what's the bad thing that the person did, like what's the issue. So if it's more serious, then it's going to be really hard to get in. The second is why are you trying to come in? What's the intent? And I'm blanking out for the third. It's matter of Harenka, and it's what are you trying to do? What's the bad thing? And I guess in like just overall, are you a concern for public safety? Are you going to harm society? So like if someone had a DWI, for example, they would consider that as maybe you drink and drive and you're going to put other people in danger. So it really does take the analysis of what is the inadmissibility finding, sort of like the problem, and is there a solution to it? And if so, do you qualify for that solution or waiver? So it really can come down to a case basis.
Okay. Thank you so much for answering the question, Ruby. And guys, you can also give us a call. I mean, you can also ask your questions by giving us a call on the number 425-436-6335. And don't forget to put the access code. The access code is 988888. So you can also ask your questions by calling us on this number. Now, let me come back to our viewers' question. So viewer Vishwanathan is actually back, and he says, thank you. I think he wants to thank you for the answer that you gave. And he says, the reason I asked is that 17th January, my colleague got his petition and got approved on 31st January. But with changes to I-29 from 17th January, do we anticipate any delays?
What changes to well, I think just with every new change in forms, it takes a little while for everybody to get on board, and also like I was mentioning before, a lot of federal a lot of government officers have been having some changes in the HR issues, and so it could cause some delays there. I think we should just like how immigration attorneys are getting slammed right now, I think we should probably give the government a little moment to breathe and try to take it in, because like if you think about it, there's all these policies that were coming out, even though it initially impact this particular issue, but then there's also staffing and whether they can work remotely or not, and changes, and then there's like the different secretaries for the different agencies in the cabinet, and so there's a lot of like the trickling down of the different policies right now. So hopefully it all stabilizes soon, and we can see what's going on.
Okay. Thank you so much. Vishwanathan, for your question. I hope you have got your answer. Gagan says, just want to extend a thank you for doing this webinar. Of course, you're most welcome, Gagan, and make sure that you like, share this video, and also subscribe to the channel, and also make your friends subscribe to this channel if they want help regarding immigration cases. But thank you for your comment. And Ruby, I would like to actually come back to my question and also ask you that, do you think that the US, they share records of deportation to other countries as well?
Okay, so they're not supposed to, but then in some respects about like asylum, but then at the same time, they're also getting, that's a really good question. Okay, so let's break down different scenarios about this. So one thing is the deportation. Well, in some cases they are, because they're giving a list, a manifest, they have flights and buses of individuals who are going back to those countries. In fact, there's countries that are taking people that are not even there, or I think that's what the US is trying to do, send people who are not citizens of those countries to countries. Like, for example, Mexico is preparing to take what they call OTMs, other than Mexicans, with the Venezuelans that are about to run out of status in less than 2 months. Some of them, if they don't have anything else, they're working on where are they going to send, 300,000 or more or whatever, Venezuelans to other countries. So there has to be some information sharing about those things. But then the other side is when you do talk about asylum, like even if you think about an affirmative asylum interview, one of the things the officer says is, we're not going to share this information with your country, and this is private. So I think that asylum as a form of relief versus being deported are different things, but a lot of times it's intertwined. So I think there is that concern, but just because it's the application doesn't mean that detail is going to be communicated to the country. So I think that's just something to consider. We're sort of getting into some uncharted territory where they're. Oh, I know, that's what I'm saying. On the ICE Facebook page, they are posting pictures of individuals with their complete name and they're like charged, I guess. So even if it's like overstayed or a crime. So I'm really concerned about confidentiality and safety for those individuals. But for the most part, that's about all we can say to that question.
Okay. All right. Thank you so much again for answering the question. And also with this, I would also like to ask you that are there specific countries that restrict entry of individuals, who have been deported from the US?
Other countries that restrict individuals. Well, I'm hearing some reports that I don't know, because that's more of a relationship between the US and those other countries. But there are countries that we historically didn't send people to. There were times where we didn't send them to Vietnam or Cuba, now Venezuela. So there's been times where they're between the issues at hand. But then I think now the US is considering sending people to, even though they're national, going to another country altogether. So there's a lot of change going in that space.
Okay. All right. Thank you again for answering the question, Ruby. Vishwanathan is actually back and he says, thank you, that makes sense. Do we have another session plan? Okay, maybe we can. How about that, Ruby? We already have got a request, right? So maybe we should.
Yeah, exactly. We'll see.
We'll be coming back soon, Vishwanathan. But thank you so much for your message. Let me quickly take Ananya's question. Ananya says, I have heard that asylum seekers may be deported even after their claims are approved if their country of origin changes. How likely is this, and what protections are there to prevent it from happening?
So that's a very specific, tough one, but let's just walk through some ideas here. Like when I first read it, I thought you were talking about people who had asylum pending being deported. I've started to hear stories about that, but in your story, you're talking about somebody who was approved asylum. Okay, well, let's just say when an individual is approved asylum, yay, that's hard. So great, congrats. But and of course, I know you went through a lot for that to even happen. But you really want to apply for legal permanent residency at your earliest availability. In fact, right now you can apply for legal permanent residency as soon as you get approved. And I once had a client, let me explain this, where he waited about 7 or 8 years to apply for legal permanent residency. And he wasn't my client for the asylum claim, but he was given a hard time about the green card because they started evaluating things about like whether the individual could return, and some other issues about scrutinizing the case. And so I think maybe that's what you're talking about in this situation. And that you're explaining that because of the change, so that if things got better, the US government's saying, well, wait, you can go now. And so that is possible. I haven't seen it happen a lot, but maybe it will going forward. So yeah, keep that in mind. I would say the way to prevent it from happening is apply for a legal permanent residency as soon as you possibly can so that you're in a green card status and not just asylum status.
Right. Thank you, Ananya. I hope you have got your answer. And if you did, make sure you like this video, share this video, and also subscribe to Immigration Talk Show. Let me very quickly take Kunal's question. I think did I already take his question? Yes, I think I already took his question. Lucas's question is also taken. So Ruby, I would like to now move to some of the Facebook questions that we get in our Facebook groups. People continuously post, Facebook questions in the Facebook group. So if you allow, I would like to share my screen and, read out these questions so that I can get an answer from you. Okay. So this person says, my I-140 got approved from my old employer and I want to port the same to my new employer, but the job titles are different. Would that cause any issues?
It generally can, but I think really the question is looking to the job description, because sometimes, like at banks, for example, they call everybody a vice president, but a vice president at a small business is a whole nother story, right? So I think it really would come down to what is the more of the job description and requirements. But it could be a little troublesome if the title is not pretty much in line. But that would be more of a case by case matter, and making sure that you're as close as possible, so there's no question of that success of the portability.
Okay. Thank you so much for answering the question, Ruby. Let's quickly move to our next question because we don't have much time. Brittany is here, and Brittany says, hello, everyone. I got my OPT for 1 year and it expires tomorrow. Is there, is there any way that I can stay without problem in my status couple days more in the US?
Tomorrow. This was from 7 hours ago. Well, I mean, if you just overstay by a couple of days, the problem is then you'll have to say that you overstayed, even if it's just by 1 day, when you ever apply for something again. So that's not really good. But if you didn't file for an extension at this moment, then if you're only wanting a couple of days, I mean, you're in this situation. So you might as well just leave as soon as possible and know that you're going to have to say you overstayed. But if you were going to file an extension and you're filing it late, you could maybe do a nunc-pro-tunc. But that sounds like pretty much a serious, timely question that you have. So if you're not planning to stay and you're okay with having overstayed a day or two, then I would just leave as soon as possible. But you sort of don't have a lot of time to do something about this particular situation other than to leave or file an extension, but you need to have a plan for what you're going to do.
Okay. All right. Thank you so much again for answering the question, Ruby. We still have a lot more questions, but I think that's all the time we have with you, right?
Yeah, sorry about that, but I mean, it was great when we could get some of these. Look, I would just say, bottom line, having a consult with an experienced immigration attorney is really where it's going to be at, okay? Because there are so many changes happening, and I really would suggest finding someone who has a big enough team that's keeping up on things, or primarily just does immigration, because if they're doing a lot of different other aspects, it's going to be hard to keep up with, other areas of law, it's going to be hard to keep up with all the changes. But hopefully things start slowing down in terms of changes and updates. Fingers crossed, hopefully. But it's not just you, it's the attorneys, it's the government. There's the changes for everybody. And so we're just trying to do the best we can to navigate that and get our clients in the best place possible. So thank you so much for having me, and I hope that this was helpful, and definitely feel free to stay in touch.
Absolutely. Thank you so much, Ruby, for being here. And guys, if you're looking out for help regarding your immigration cases, make sure that you get in touch with Ruby Powers, or you can give her a call on the number 713-589-2085. I would like to repeat her number, 713-589-2085. You can also email her. Her email ID is contact@rubypowerslaw.com. And you can also visit her website, which is www.rubypowerslaw.com. So make sure that you get in touch with her regarding your immigration cases, and especially asylum or deportation case. But thank you so much again, Ruby, for being here. Hoping to see you real soon. Maybe like, one of our viewers said, another session and another episode exclusively for L1A. So if you're available, we would love, you to come back.
Okay, well, that sounds good. Well, let's definitely work on that then. Thanks, everyone.
Thank you so much. And thank you so much, viewers, for being here and for joining this webinar, for posting your questions in the comments. And we have so much more coming up for you. For that, you'll have to stay tuned with Immigration Talk Show. But for now, I'll have to take your leave. I'm Rajni Bharara, your host. I'll be seeing you very soon. But for now, take care and make sure that you like this video, share this video, and also subscribe to Immigration Talk Show. Bye for now and take care. Hi everyone, welcome to Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and today we have a topic that strikes at the very heart of the American dream: birthright citizenship, a legal principle rooted in the 14th Amendment. It has long been a cornerstone of US immigration policy, but now it's under fire. Now, before I say more about it, I would like to read out this very important disclaimer, which is here on the screen. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back, everyone. Today, we are going to dive into a very important topic, like I said. And to talk about that topic, we have none other than Jonathan Wasden, a renowned immigration litigation attorney with years of experience navigating the complex intersection of law and policy. Together, we'll unpack the implications of the lawsuit challenging President Trump's policies and its potential ripple effects on immigrant communities. What's at stake? How might this case shape the future of citizenship rights in America? And most importantly, what does this mean for immigrants today and in the years to come? So, without any further ado, let me give a very warm welcome to John. So, John, welcome back to Immigration and Jobs Talk Show. It's always a pleasure having you. And today we have a very important topic to talk about. So, welcome back again.
Thank you. Thank you for having me.
Thank you so much. John, without wasting any time, I directly would like to jump into my very first question, which is that is Trump's executive order on birthright citizenship constitutional?
I don't think there's very many people who think it is. I think the general consensus is this is something he did just to beat his chest and show his anti-immigrant following that he's doing something. So the general consensus, like I say, is that this will more than likely be invalidated by a court, and it'll be the end of it. Now, in the interim, until that happens, the real impact is going to be, if you're applying for a passport for a newly born child, the State Department may not issue it right away until a court order comes down telling them that this executive order is unconstitutional.
Okay, but John, can a president really change who becomes an American president? American citizen?
No, it's governed by the Constitution and it's governed by statute. And to the extent that the Constitution doesn't contemplate every possibility, the statute takes over. What Trump and his administration are trying to do is they're taking the very, very clear language in the 14th Amendment that says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. What they're saying is that and subject to the jurisdiction thereof clause somehow allows them to prevent the people being born in the country who are born to non-permanent residents and non-U.S. citizenship. But when you look at the history of that clause, what they're really referring to is diplomats who have diplomatic immunity who are not subject to the jurisdiction thereof. And diplomats' kids, when they're born in the U.S., have never been granted U.S. citizenship. And so, they're really pushing against common sense, the plain language of the law, and also history. And there's just really no angle that they can take on this that's going to be appealing to a court.
Okay. But then why do you think they did it in the first place? Like, why did they think about doing it if it's not going to go forward?
Yeah, so I mean, Trump's base, they are very upset about illegal immigration from the southern border, and that's understandable. Especially, if you're living along a border state, that's an issue that you're going to be voting on and you want tougher enforcement on. They were also keyed in and aware of the fact that there have been clinics and hospitals set up, mostly catering to Chinese clientele, where the Chinese clientele will come on a visitor visa shortly before baby's due, have the baby here, recuperate, get citizenship for their child, and then go home. And those are the two scenarios that they're trying to prevent and they're trying to stop, is the illegal immigration and the birther tourism, for lack of a better term. But in the mix, anybody who's on a non-immigrant visa here legally and lawfully is also most likely going to be impacted by, this executive order in the interim.
Okay. Okay. But then, John, also I would like to know from you that how could the government legally stop granting automatic citizenship to children born in the US?
So I think the way that they will do that, the only way they really can do that is through the issuance of passports or the non-issuance of passports. And so, if you were to apply for a passport for your child right now, proving citizenship would be an issue potentially if you're a non-immigrant or you don't have legal status until that court order comes down saying, no, this is not legitimate.
Okay. But then has the 14th Amendment ever been challenged in a similar way before?
No, probably because it's so clear on its face, nobody's ever thought that this was a good idea to do. Just looking at the language of the 14th Amendment, it's abundantly clear. And it's, the history of it shows that it was designed to grant citizenship to anybody born in the US, regardless of the status of their parents. So, the people that it affected back in the day were, not documented aliens, right? They didn't come here with a visa. Their parents didn't come here with a visa, rather, and they were born to people who didn't have visas or legal status other than slaves. And so to say that the executive order, has found some gaping loophole in the 14th Amendment is kind of stretching it a lot, actually. And so I just don't see a whole lot of courts having patience and time for this. I think it's going to be something that gets kicked out very quickly probably in the first month and a half of the Trump administration. They'll take a beating on this one. But it's more of a distraction, I think, from what's going on with, the grander issues within the Trump administration on immigration. And it's also indicative of where he's headed. So, there's a lot of buzz earlier about, Elon Musk saying great things about the H1B visa, right?
Mm-hmm.
So there was some optimism that maybe Trump's second time around wouldn't be so bad for immigration or legal immigration and high-skilled immigration. But, the birthright citizenship issue and the extreme vetting issue, all of that's lining up to show that no, it's just going to be just as bad as it was the first time.
Or maybe worse?
Yeah, it could be worse. I think what they learned from their last time around is, what not to do. They jumped in and rushed into a bunch of things without going through the right process. I think this time they've figured out how to game the system a little more effectively.
Okay. Well, let's wait what actually, happens there. And the first day itself had so many things coming. So we weren't really somewhere we were expecting, but we weren't really expecting this much to happen. But then let's see what really happened. But then, John, I would also like to know from you that, how much this challenge to birthright citizenship impact future presidential actions?
So probably not much because, the other court cases are going to be brought against his policies are on issues where the law is not so clear and potentially not quite so favorable to plaintiffs. The extreme vetting piece, that is something where courts are more likely to give the executive branch a lot more leeway and a lot more flexibility to, accomplish their goal of protecting the U.S. So as obvious as it is what they're trying to do with that extreme vetting, I think the courts are probably going to be more inclined to let that happen and, let him have his executive order on that issue.
Okay. And, could this set a precedent for presidents to reinterpret constitutional provisions through executive orders? Do you think?
Where they're clear like this, I don't think so. Where there's a little bit of ambiguity, there's always the possibility that, they can find a loophole or they can find some exception that a court's going to agree with. But with this case, the language is so abundantly clear, the history is so abundantly clear, and the reason for the amendment is so clear. I just don't see it, getting any traction with the court. Even if they get lucky and they get a Trump appointee from the first administration as a district court judge, that first trial court level, any court of appeals that hears this, I think is going to shoot it down.
Okay. But John, even if, let's say, it goes through, and then what might happen to the children born in the US?
Well, that's a great question, right? Because they're born here, they've been here for a while, at least over 180 days, without any type of visa. There's no provision in the law that says that if you're born in the US, you're granted immediate or automatic residency status, right? Or non-immigrant status if your parents are non-immigrants. And so, what is their status? That the law doesn't anticipate what that would be, because the law has always assumed that they would be citizens if they're born here. So there's a lot of questions that are going to be raised if this was, allowed to go through. And you would find the odd circumstance or the paradoxical circumstance where an infant born here in the US who can't even speak would have a ground of inadmissibility for having overstayed and been in the country without authorization for more than 180 days. And that just seems incredibly crazy that they would do that, but that would be a natural consequence of, birthright citizenship being destroyed.
Yeah. And do you think, would this create a group of children, who don't belong actually anywhere?
Possibly, yeah. But again, I don't think this is going to stand. But hypothetically, yeah, it could cause problems like that.
Okay. So moving forward, I would like to also know about, how will calling cartels and gangs terrorist groups change immigration enforcement?
So when you throw out the magical T word, the terrorism word, it does loosen up certain funding within the federal government to do emergency, actions. It also gives the federal government a little bit more flexibility in what tools and what, things they bring to combat the issue. By labeling it terrorism, theoretically, they're opening up, activation of military to combat terrorism. Historically, if you look at it, it wouldn't be the first time that, the country has brought the military in to the southern border to fight what amounts to a terrorist organization. Back in the early 1900s, there was Pancho Villa. He was a Mexican rebel that was leading border incursions across and attacking settlements on the U.S. side of the border. And, we sent the American Army down there, and they had, the punitive expeditions fighting in Mexico, chasing down Pancho Villa. And so there is precedent for using the military along the border. Whether or not we're going to get into that remains to be seen. I would hope not. I think that would be a catastrophe. Having been in the military, in my lifetime, I just don't see that as an operation that we would be set to excel in, because we've learned one thing from the U.S. military over the past 20 years, and that is fighting an insurgency or fighting what's called asymmetrical warfare is something that we're just not very good at, and no country is terribly good at. So it would be a catastrophe if we sent the military south of the border.
Okay. But do you think also, this designation can lead to increased a legal risk of migrants, accused of association with such groups?
Mm-hmm. Yeah, it does open up new grounds of inadmissibility, or it makes people, qualified to be in grounds of inadmissibility that would prevent them from getting visas or admission into the U.S. if they've been labeled. The problem with that is the way that, USCIS in particular and DHS has been dealing with these issues of inadmissibility is completely illegal. What they're supposed to do when they take an adverse action against somebody is they're supposed to give them notice, they're supposed to give them opportunity to respond to the allegation, and then they're supposed to make a decision in writing and give that explaining the law and the facts that their decision is based on. What we see DHS and USCIS doing, however, is they're entering these findings in secret, not telling anybody. And the only time you ever find out about these findings is when you go to a consulate for a visa stamp or you go to the port of entry for admission. And that's when you find out that you've been, listed as inadmissible for one of these categories. And I see that all the time in regards to alleged false statements, inadmissibility based on false statements. And I am suspecting that we're going to see that happening with the terrorism related grounds, is that they will just start using that incredibly freely without a whole lot of thought or discretion, and it's going to be a tool they use to eliminate a lot of people from the pool of those that can come to the US.
Okay. Thank you for answering the question, John. Also, what could happen if military is used for border enforcement?
So the border enforcement is an interesting question. It's an easier question to say, can we send the military south of the border to combat narco-terrorism? Legally, yes. I think we can do that. I think, practically it would be a horrible idea. Border enforcement's another issue, though. It's quite a bit different and it's more nuanced. So there's this thing called the Posse Comitatus Act. And it goes all the way back to post-Civil War when the U.S. Army was occupying the South. And they were the law enforcement, for the South in the Reconstruction era after the Civil War. And part of the compromise of ending Reconstruction, getting the levers of power restored to the civilians in the South, was the Posse Comitatus Act that said that the U.S. military will not be allowed to enforce civil law, and they have no authority to do that in the United States. And so, the question is whether or not border enforcement, which is on our side of the border, would violate Posse Comitatus. And I think, the U.S. military could serve in a supporting role legally to CBP, like logistics and things like that, because they're not enforcing law. But once they start putting the military into an enforcement role, there becomes a whole lot of problems with the Posse Comitatus Act. And I think that's something that it's a little bit more nuanced, but I think it's also something that the administration will lose in court.
Okay. So also, how might stopping asylum and refugee admissions affect international human rights?
Yeah, so the asylum and refugee issue, it's a program that in theory is very valuable and it's very noble. What the Trump administration, I think, is responding to is pretty well documented cases of abuse of that noble policy. And there are pretty good documented cases of people that are just running these asylum mills where they give people these backstories, they prep them for these interviews based on facts that never actually happened to the person, and then they send them for their asylum or their refugee screening. And that's probably the minority of cases by far, but it's something that has happened in the past, and I think that's what they're responding to, is the abuse in the asylum system. I think for the legitimate folks that are truly impacted by oppression in their home country, it's going to be a catastrophe. They're going to be stuck in refugee camps. They're going to be stuck in their home country with really no protection or no sense of certainty of what's going to happen in their future. But again, asylum and refugee policy is something that the law does give the president a lot of discretion over and how he administers it. So it's something that's probably not going to be very easy to challenge in court.
Okay. And John, with this, I would also like to talk about, the government and workplace changes. So I would like to know from you that what might happen legally if diversity and inclusion programs are ended in federal agencies?
If there were which program, sorry?
If diversity and inclusion programs.
City inclusion programs?
Yeah, diversity and inclusion programs.
Oh. Yeah, so the DEI stuff or yeah, I think that's any mandatory or encouragement on the federal level is going to probably end if it hasn't ended already. Individual states, individual cities, they're completely allowed to have their own policies on that. However, it remains to be seen how courts are going to handle challenges to that under the Equal Protection Clause. So as we look at the history of affirmative action and how that's fared in courts, the current Supreme Court, being very conservative, they have a view of the Equal Protection Clause that says that you can't give preference based on race to anybody, even if it is somebody who's been historically oppressed or disadvantaged. It has to be race neutral. And I think where these DEI policies are going to run into problems is, when they're giving preference to certain categories of folks and disadvantaging others, that's going to have equal protection ramifications. And that's something that, in theory, the federal government could proactively sue the municipality or the state on.
Okay, but do you think that cutting federal jobs, can face constitutional challenges?
No, it would. Let me put it this way. If Congress authorizes money, then the president's hands are limited because Congress has said this is how we want to spend our money, and this is the only way you can spend that money. So as long as Congress keeps pumping out the money, the executive branch, is in charge of spending it and has to spend it typically. If Congress is working with the executive in cutting jobs, it's very easy. There's no constitutional issue involved. The only time there becomes a constitutional issue is a separation of powers issue between Congress and the executive. If there's a disagreement there about how the law is being enforced and whether or not the executive is faithfully executing the laws that Congress has created, then that's an issue that can come about. One way that they typically are going to do things like this is not overtly. It'll be attrition, hiring freezes, pushing people out through retirement, just subtle changes in process as opposed to outright layoffs and firings to eliminate positions. So I would expect it to be death by 1,000 paper cuts as opposed to, chopping the head off the snake.
Okay. John, thank you so much for answering all these questions. With this, I would also like to know your viewpoints on the CBP app shutting down. So I would also like to know from you that how will the sudden shutdown of the CBP One app impact nearly 1 million migrants who had scheduled legal entry appointments?
Yeah, I think it's just indicative of where the Trump administration is headed. They want to make life as difficult as possible for people trying to enter the U.S. And, that's simple, full stop. They are under no obligation to make things easy. They're in charge of creating process. They're in charge of, dictating how services are delivered. And if they throw up obstacles or they eliminate efficiencies, it's annoying, especially if you're an immigration lawyer or you're the person impacted. But it's something courts are not likely to get involved in and tell the executive, no, this is the process you must follow. So as long as they're not overtly doing something illegal, those process type of issues tend to get a pass in court.
So then, what legal challenges can migrants potentially can take against the abrupt cancellation of their pre-approved appointments?
So not much on that. There's if they're outside the country, especially, you have very few rights when you're outside the country, and the executive branch is given a lot of authority to determine, who can enter the U.S. And if you don't have a right to enter the U.S., then you clearly don't have a right to a scheduled appointment. So I don't expect that there's going to be a whole lot of legal challenge to that aspect.
Okay, so John, also does the executive order violate any existing immigration regulation or international asylum protocols?
Well, international asylum protocols probably, but the Trump administration has never really shown themselves to be big fans of international law, and international law is one of those things that is tough because it's all based on agreement to cooperate and to follow. And if somebody opts out of following international law, there's really not a whole lot that you can do, especially when you're the biggest kid on the block. You're the one spending money to support the UN, and you're the most powerful country in the world. There's not much people can do to punish you for violating international law and conventions like this.
Okay. And what immediate risks do migrants face after having their appointment suddenly cancelled?
Just being stuck in place where they're at. I think that's the unfortunate situation is just they're on hold and their lives are on hold while they're waiting for those appointments.
Mm-hmm. And how might this action potentially increase unauthorized border crossings?
So, interestingly, right now, illegal border crossings that are kind of at a historic low, they're greatly decreased during the Biden administration. So I don't know how much of an effect it'll have, because typically the unauthorized border crossings are more a reflection of disruption and problems in people's home countries more than anything. And the lack of border crossings that we've seen, I think, is indicative of countries starting to get more stability and addressing their internal problems, which takes away the incentive for people to leave. So I'm not sure, how that'll play out.
Okay. And then how might courts also view the sudden revocation of scheduled legal entry appointments?
I don't think the courts will get involved in that one. I don't think there's really a legal hook to have a successful lawsuit on. Like I was saying earlier, the courts have historically given the executive branch a lot of latitude and a lot of authority to determine who is admitted into the United States. And if the courts have given that authority to determine who gets in, clearly the executive has the authority to determine who meets the first step in that process of admission, which would be those interviews.
Okay. And then how does this action align with existing US immigration laws?
So in terms of the appointment cancellations, I think US, especially under Biden, US immigration law had been trending toward a more user-friendly experience. And clearly under Trump, they're going to be retrenching. They're trying to make it as difficult as possible.
Okay. John, also, I would like to know from you that, all that this is happening, do you think, is this about fixing immigration or punishing immigrants? What do you think?
So I don't think the Trump administration and the Trump supporters have any desire to fix immigration. I think they just want to end immigration. And so I think it's all about making life as miserable as possible for people in the US or trying to come to the US as a way to discourage them from coming to the US or staying in the US. And I think that's a trend we'll see as long as Trump's in power, to be honest.
But then, US is a country who's built by the immigrants. And how will this work if this happens?
That is the grand irony. Not only are we a country built on immigrants, immigrant populations have historically, spawned great innovation, economic, recoveries, and success. And the problem we're having in the U.S. right now is that we have a very small number of people that are going into the hard sciences, getting degrees in things that matter, and being prepared for even college and degree programs that are valuable to the economy. And so we're not generating enough brain power in the country to sustain the economy that we currently have. And the only way that we're going to fill that gap is, frankly, to poach the best and brightest from other countries to come to the U.S. and work and drive the economy. And excluding immigrants, in the Trump mind, if you keep out immigrants, then automatically somehow some kid in the U.S. in the Midwest that didn't study hard in school is going to be qualified to be, an IT professional. And that's just not reality. They didn't study hard enough in high school. They didn't study in college. They didn't prepare themselves. They got an English degree instead of a computer science degree. There's just not, qualified U.S. workers to take these roles over. And so, immigration has been a way that we've been covering that for a long time, basically since the early 90s. And if we cut that stream off, we're really shooting ourselves in the foot.
Okay. Well, also, John, with this, I would also like to know from you that do you think that with these rules coming in, we are actually changing the rules of who actually belongs to America?
So I think they're definitely trying to reshape the landscape. They want to decrease the number of people that are coming. And Trump's made no secret that some immigrants are good, and then some are completely undesirable. And those good immigrants, are Northern Europeans in Trump's mind. And so, they would definitely like to change the mix of people coming to the U.S. But frankly, I mean, anybody who's been to Europe and has seen what life in Europe is like probably isn't a whole lot, doesn't have a whole lot of motivation to come to the U.S., where we have very expensive healthcare, we have ridiculous working hours, and the lifestyle is just not very good. And so I don't think we're going to be getting the immigrants from Northern Europe that Trump sees as valuable to the U.S.
Okay, and also very recently I saw, I think on the inauguration day itself, I saw a tweet from Elon Musk, and where he wrote from MAGA to MEGA, I think make America great again, to make Europe great again. So what do you think this means? What do you think he meant by this?
So there's an American perception of Europe. I don't think it's terribly accurate, but the American perception of Europe is they have let so many Arab and North Africans into Europe that they've destroyed European culture. And basically they want to make Europe white again and eliminate those folks. And that's what you're seeing there when they make Europe great again, is they're saying return back to your genetic European roots and stop letting those North Africans and those Arabs in.
Okay, so you mean that that whatever decisions this administration is going to take will not directly impact America, but the whole of Europe?
Well, I don't think they have a whole lot of impact over Europe. And I think most European leaders think that Trump's a bit of a buffoon. So I don't see him having a whole lot of sway over their internal policies. But the perception that certain Americans, especially in the MAGA crowd, have is that Europe is, somehow destroying itself internally by allowing immigrants to come in. that's their mindset they have about the US. That's the mindset they have about Europe. And, I think it's an unrealistic view of Europe, especially. Europeans aren't clamoring to come to the US. So they must be doing something right there.
Okay, thank you so much for answering the questions, John. I have a lot of questions from our viewers, so let me quickly take them. So I think AD Sterling is here, and AD says the ploy was to get thus into the courts so the Scotus can decide the matter. All I read is the term immigrants. If you cross into the US, that person is here illegally. Okay, I think this is a comment that he made. Do you have anything to say to him?
Is that in regards to the birthright citizenship?
I think so, yeah.
Yeah, I think what the Trump administration is trying to say is that U.S. citizens and permanent residents that have children, those children have automatic citizenship. But if you're a non-immigrant or you're an undocumented immigrant, then your children do not get automatic citizenship. And that's the spin that they're putting on this.
Okay, and Tricia is also here, and Tricia says 93 countries have ended birthright due to the abuse of the original meaning.
Mm-hmm.
What do you have?
So, most countries, the way they handle citizenship, it's through, their legislatures, and then their parliaments. And that's a very easy change to make. If the sentiment in the country is we want to change, legislatures can do that very quickly. Our legislature in the US, not quite as efficient. We haven't actually got anything meaningful done in Congress in at least a good decade and a half. And it's just mostly been the administration, the executive branch that's been running the show. But our Constitution is the one that creates the birthright citizenship. And historically, changing the Constitution has been a very difficult, very prolonged process. And the vast majority of proposed amendments to the Constitution have failed and haven't gotten off the ground. So because it's in the Constitution and because it would take, going through all of those incredible hurdles to get an amendment done, I just don't see it happening. Okay.
And Viking for Life is also here, and Viking says UK got rid of birthright citizenship a long time ago. Two illegal aliens couldn't. Oh my God, this is a big statement that he said. Okay, let me quickly take Monali Thakur's comment. Maybe. How do you think the outcome of this lawsuit will impact the lives of immigrants and their children born in the US, considering the potential consequences of denying birthright citizenship, such as loss of access to federal benefits, social security numbers, and voting rights? What do you have to say, John?
Yeah, I think the lawsuit is just going to preserve the status quo. So I think at the end of the day, we're going to see, people that are born in the United States getting citizenship, unless you're a diplomat's child. And I don't think it'll have any long-term effect, is my prediction. I think in the short term, the only impact that we're going to see is the State Department potentially not issuing passports. And so, people who have newly born children that haven't gotten a passport yet, they may have to sit in place before they can travel with their kid.
Mm-hmm. Okay, so Manali, I hope you've got your answer. In case you want maybe more answers, you can continue writing or posting your follow-ups. Meanwhile, let me take Ram's question. Ram says, how does this lawsuit affect the immigrant communities who are already living in the US as permanent residents or asylum seekers? Could their children be impacted even if they are legally here?
Yeah, I again, the only thing that's going to be impacted, I think, long term is, or short term rather, is the issuance of passports. That's, the only thing that's going to be a problem. I think, at the end of the day, at the end of the lawsuit, we will go back to status quo. There won't be any changes. And anybody born here in the U.S., except for diplomats' kids, will get birthright citizenship.
Okay. Thank you so much, Ram, for your question. Continue posting your follow-ups if you have more. And let me take Girish's questions in the meanwhile. Girish says, there are people saying that this lawsuit is just a political move. Do you think there's any validity to that argument, or do you believe there are strong legal reasons behind challenging birthright citizenship?
Well, so just to be clear, the lawsuit is challenging the executive order, and the executive order is the one that's attacking birthright citizenship. So do I think the executive order is a political stunt? 100%. I think any legitimate, thinking lawyer realizes that this is going to die, that the courts are going to shoot this down. So it's definitely a political stunt. And in terms of whether or not ending birthright citizenship has merits, that's a question that is going to have to be resolved through a lot of debate over time, and it's going to have to go through a constitutional change that's going to require a lot of public participation and input. And I think even if we did see changes to birthright citizenship, I think we're looking at years and years and years down the road.
Okay. Thank you so much, Girish, for your question. If you have follow-up, please continue posting them. Meanwhile, let me take Arpita's question also. Arpita says, what's the long-term impact of this lawsuit for immigrants who are still hoping to become US citizens? Would it make it more difficult for families to navigate the citizenship process in the future?
I think if you're here and you're on that path, it's not going to have any impact on you, because all the executive order is doing is trying to limit, going forward from the date of that executive order, who qualifies as a U.S. citizen, when you're born here. So the lawsuit, the long-term impact of that is just returning us back to where we were at the day before that executive order, and how citizenship is dealt with. Now, whether or not USCIS and the Department of Homeland Security are going to make the naturalization process more difficult for people and for applicants, that is a possibility. I mean, that's something the executive order can do, or that the executive branch rather can do pretty easily, just by saying this is a higher priority. We need to investigate people more thoroughly. We need to make sure they qualify. Yeah, all of those things can impact the naturalization process. But in terms of birthright citizenship, the executive order's impact is going to be very short-term, temporary, and limited. And I think we will return to birthright citizenship very soon.
Okay. Sarvesh is also here, and Sarvesh wants to know that what role do you think international human rights laws, such as the Universal Declaration of Human Rights and the Convention on the Human Rights of the Child, might play in shaping the court's decision, particularly with regards to principle of non-discrimination and the protection of vulnerable population, including immigrant children?
Yeah, so when it comes to international law, the courts don't really give it a whole lot of credence, to be honest. Yeah, if you make international law arguments in a federal court in the United States, it's like, oh, that's cute, that's nice, that's interesting. But anyway, let's focus on the real issue. Very, very, very few cases in the American judicial process have ever turned on immigration or international law. And so I wouldn't expect those conventions to sway anybody in the court.
Okay. Let me quickly take Sanjay's question also. Sanjay says, how might the judicial outcome of this birthright citizenship case influence the evolutionary trajectory of US citizenship laws, and what potential far-reaching consequences could emerge for the future landscape of American immigration policy? What do you have to say, John?
So I think in terms of naturalization policy, again, the executive order limiting birthright citizenship, I don't think it's going to stand. I've been pretty clear about that. But changes to the naturalization process could take the form of statutory changes, limiting who's eligible for naturalization. That is something Congress can totally do, and they're authorized to do. And frankly, if Congress creates rules on naturalization that are more difficult, those are going to stand. The courts aren't going to overturn those. And so, that'll just be at the end of the political process, the political debate and codification of the law. So, if you look at our Congress, we haven't really accomplished any major legislation or major policy changes, especially in immigration, in decades. So I'm not expecting anything, dire or dramatic to happen anytime soon, just because, the procedure used in Congress to get things done is very unwieldy, very difficult, and, hot issues, difficult issues tend not to get resolved because they're too difficult to resolve.
Okay. Thank you so much, John, for answering all these questions. I think we have covered all the questions from the viewers as well. But with that, I would also like to know from you that what more can we expect? It's just been a day since Trump has taken the office, but what more can we expect in terms of, what might happen to immigrants and immigration policies and visas? So what more can we expect?
I think if you're outside the U.S., you can expect the consular process to be much more difficult, much more limited. I think they will scale back appointments. They'll make everything as hard as possible to get a visa. And then at the port of entry, there's going to be much more scrutiny. So if there's anything in your immigration history that's been flagged, you're not going to know about it until you get to the port of entry. And you may face, questions about something that happened a decade ago, in your immigration process. So I think those types of things are what we should expect, especially for the H1B population. I expect that the FDNS, which is a branch of USCIS that is like their immigration Gestapo, that goes out and does these visits and harasses H1Bs. I think those investigations are going to increase dramatically. And the important thing for that population to understand is that they have a right to a lawyer in that situation. And having a lawyer represent you in those cases is about the only way that you can protect yourself from getting bullied and pushed around and, having your statements twisted and mischaracterized in some report that is going to impact your immigration future forever. So I would say get with an attorney immediately, have what's called a Form G28 signed between you and the attorney. And if there's ever a FDNS officer that shows up on your doorstep or comes to your work, give them a copy of that G28 and say, I have a right to a lawyer. I'm using that right. Please contact my lawyer for further inquiries on this issue, and leave it at that. And don't let yourself get bullied into talking further.
That's a great advice. Thank you so much for that, John. And guys, if you want to directly get in touch with John, make sure that you give him a call on the number 844-592-7336. Yes, I would like to repeat the number 844-592-7336. You can also email him. His email ID is support@wasden.law. And you can also visit his website, which is www.wasden.law. So make sure that you give him a call, reach out to him on his email, and you can also visit his website. Thank you so much, John, for being here. It was great speaking with you. Thank you so much for your insightful answers on all these trending questions. People are really looking to get an answer for these questions. So thank you so much for answering them in so much detail and depth. And we're looking forward to doing another great episode with you on another great topic. But until we meet again, thank you so much for being here.
Thanks for having me. It's good talking to you.
Likewise. Thank you so much. And to our lovely viewers, thank you so much for posting so many questions of yours, and we enjoyed taking them. Thank you so much for that. And we are going to see you very soon in another webinar. And we are going to have another webinar at 12. So make sure that you tune into that. And if you want to get in touch with me, my number is 732-707-9151. My email is rajni@staffingly.com. So if you have any queries for me, make sure that you give me a call, send me a text, or maybe email me. But for now, I'll have to take your leave. I'll be seeing you soon on another webinar. But for now, I'll have to take your leave. Make sure that you like this video, subscribe to the channel, and share this episode with anyone looking for answers to these questions. But for now, have a great day. And I'm Rajni, signing off. Bye. Take care.
Hello and welcome everyone to Immigration and Jobs Talk Show. I'm Nipasa, your host for today. And before we start off with today's session of discussion, and I have this very amazing guest, I want to read out this very important disclaimer. So, yes, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, once again, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and on X. So, please feel free to join us by commenting. You can participate with your questions. And yes, we also have a phone number where you can join us. So, all you have to do is call in this number 425-436-6335, and the access code is 988-888. And once you're in, you can speak. We will be able to hear you. So yes, very very excited that our topic of discussion for today is facing deportation under Trump's immigration plans and what are your legal options. I know there has been so much happening ever since Trump joined a week back, and yes, we hear a lot of deportation news, a lot of scare that is faced by a lot of immigrants out here. So yes, if you know someone who's in danger of deportation, this discussion is also for you. So, yes, we'll be talking about the latest legal options, possible defenses, and how you can protect your rights in this uncertain times, and I'm very, very excited because joining us today for the first time is a very distinguished guest, Isadora Valacuez, and yes, an AV rated board certified immigration attorney from ISA Law PA in Miami, Florida. And Isadora has years of experience helping clients navigate complex immigration issues, and she's going to join us, to shed some light on what steps you can take to protect yourself or your loved ones from deportation. So, without further ado, a very warm welcome to you, Isadora. Thank you so much for joining us today. And
Thank you,
how are
guys.
you doing?
I'm doing great. Great. I mean, despite everything, happy that I get to share some information with you and all your viewers.
I'm very excited, and this is our first time, so it'll be very nice to know from yourself about you. So, would you like to tell us more about yourself?
Well, in a nutshell, I am located in Miami, Florida, but immigration law gives me the luxury of being able to travel and represent people all over the world My niche practice is actually in removal proceedings. So I tend to represent, although we bring investors and I help employees and employers bring anyone here into the United States, I mainly help you if for any reason you're getting kicked out. So that's my niche, and that's why this specific topic is so essential to what I do and why it's
And
such a
very,
privilege
very
to share it with
timely.
you. Yes,
Very, very
exactly.
timely, I would say. Yes. So we're very lucky to have you today. And I mean, it'll be so nice to know it from you, your experiences as we, get deeper into this topic of today. So, what can folks out there expect from today's discussion?
So you mentioned it a little bit in terms of experience. We've been through this before. This may seem new because Trump just took over as president, but he was our president back in 2017, and we got some lessons as to what we can expect. Also, we have his campaign promises to follow as a good roadmap as to how immigration may look under his administration. First, I'll start by remembering 2017. And in 2017, the most shocking aspect, at least for me, in the immigration practice was the Trump Muslim ban. Basically, for those of you who don't know, or for those of you who remember, it left many individuals with valid visas out of the United States simply because there was an executive order listing specific countries, for example, Nigeria, and stating that people who were out of the United States, their visas basically were no longer valid. This has created a new warning now for my clients in terms of whether you have a visa here in the United States and if you can travel. I have many clients with H1Bs, for example, L visas, different types of visas, many students who now may be looking to visit their families, see what may happen. So far, President Trump has not signed an executive order similar to the Muslim ban that we lived back in 2017, but we did go through it back then. He did warn us that it could happen again. And most importantly, the Supreme Court here in the United States upheld such an executive order. So I would like to start by warning anyone who may have a valid visa that although it may seem absurd, the reality is that a president can't overrule and overturn and basically revoke your visa simply with a pen stroke through executive order. So keep that in mind when you're making travel arrangements, because it's something that we typically don't consider. We have our visas, everything's fine. And it was rather shocking experience back in 2017. And I would hate for anyone to go through that again during this next 4 years. As to the
Well,
people
thank you so much. Yes. Sorry, I interrupted. Please go on.
It's okay. As to the people here, I just wanted to warn. I know that if you turn on the TV, it can be scary, as you mentioned in the introduction. You keep seeing ICE raids, you keep hearing at least about executive orders that may affect people in the United States. I will gladly go into details as to who may be affected by executive order, but I'll start by giving the warning that immigration law itself has not changed in over 40 years. I've been practicing 17 years. It has not changed. What changes are executive decisions that may be temporary and have a very deep effect. Right now, the rates that you are seeing are being targeted to individuals who either have a criminal record or have a deportation order. That is the warning. However, when it comes to raids and ICE, anyone who may be without status could be subject to removal, and anyone in border states, Florida, for example, anyone close to the border by 90 miles is also subject to expedited removal. So just be careful, but understand that the law remains the same.
Thank you so much. I mean, that was a real great insight, and I'm really looking forward for this whole session ahead of us. So much to learn from you, Isa. So thank you. Yes, and like you've mentioned, ICE, and we've seen like DEA, FBI, everybody joining hands with ICE in this mission to really deport. I mean, everywhere you're bombarded with news of deportation. So I can only imagine how scary it is for all immigrants out there, status or no status.
It is terrifying. So for individuals who may be here, the reality is in the United States, the only individuals who are guaranteed entry at least and know that their status is safe are citizens. That is a truth. However, executive orders cannot get rid, for example, of your residency if you're an lawful permanent resident. But for any individuals who might be fearful as to what are their rights, how can you protect yourself, if you already know you have a removal order, then I encourage anyone to explore how they can reopen. Any removal order can basically laws change, they may change, and you may be able to go back in time and reopen your case before a judge. Anyone who does not know their status because they're afraid of finding out, now is the time to find out. It's best to know now and protect yourself. And lastly, for people who might be pending, it's good to explore what options may be available. You may still be able to seek, at the very least, withholding of removal if your circumstances in your country may have changed. So explore your options. They're out there.
Thank you. At least that was hopeful. Thank you, Isa. Yes.
try.
And I think without further ado, I'm going to move on to the questions that I have. So my first question to you, Isa, is with regard to the legal grounds, what are the main legal grounds? You've said it's not changed. But yes, when you talk about deportation, especially under this current administration, Trump 2.0.
So we have to distinguish between what is a revocation of a visa, which may be that you're here on legal status and you may receive an email or something letting you know that your visa has been revoked. That is not a deportation proceedings. That is simply warning you that you may not be able to return on that visa status. A deportation proceeding entails, a removal proceeding entails appearing before a judge. Individuals who come in under a status known as ESTA or visa waiver don't have that privilege. They have waived their rights, as the name says, so they will not appear before a judge. Only individuals who may be subject to deportation appear before judges, and these individuals tend to be people who have been in the U.S. for over a certain amount of time, who may have a remedy, and you may appear before the judge because you either don't have the correct status or maybe something happened that affected that status. Under the new laws, and this is a new act that was recently passed by the Senate in the first week of Trump being in office, individuals who have been accused of committing a crime could be held on immigration detainers for ICE to pick them up. So although they may not end up in deportation proceedings because of the crime itself, because they haven't been convicted, they may end up with their visas revoked or their status in jeopardy simply because of the accusation or the arrest. So this is the only expansion in terms of who could be subject to deportation. During the campaign, Trump focused heavily on people who were criminals, had criminal record, or had deportation orders in absentia, which means individuals who were supposed to go to court and simply chose not to go to court. Those were the main targets, but we have seen, like I mentioned in the introduction, that when it comes to raids, many people could be subject of the raids, even if they are not part of these two particular groups. So it's good to know your status and know your rights. Know that even if you are detained by ICE, you still have the right to appear before a judge, depending on how you enter the country. And the asylum right is a universal right anywhere in the world. So you can always let the government know that you have a reasonable fear to go back home, but you must show persecution from the government or from an agent that the government cannot control. It's a very difficult remedy, so it's best to explore all the other remedies first and use that one as a last resort.
Absolutely. And I think it's always best to consult with an attorney. And why not contact, the best for now in this case would be, of course, Isadora herself. And folks out there, she's based out of Miami, Florida. So her phone number is 305-938-0676. And you can email her about your case in case you need help. And her email address is isadora@isalawyers.com. And go visit isalawyers.com to get to know more about Isadora for sure. And with what you just said, this fear of deportation everywhere and with every individual, every immigrant. So I have my next question. What should one person do? The immediate steps that the person should take, facing deportation to protect their rights.
The first step is to find out your status in the United States. If you've been here for too long, you may not know. It's good to figure out what does immigration have on you. If you maybe submitted an application and thought nothing happened with it, or it was never processed, believe me, if you were submitted, it's there. So it's good to know. And you can find out directly from the Department of Homeland Security by submitting a Freedom of Information Act request that will give you your entire record. So you will know if you have, for example, an alien number, if you have a case pending, if it was denied or maybe approved. It's good to know your immigration status if you're in the country. For individuals who are in the US for more than 2 years, it may sound silly, but it's something new and it's something that you should do. especially if you live in a border state like I do, state of Florida. It's good to have record of how long you've been in the U.S. I emphasize this because during the Biden administration, we had certain benefits, people allowed into the country of certain countries like Nicaragua, for example, Venezuela, Haiti, Cuba, for 2 years. Now, Trump has announced as of Thursday last week that these individuals or anyone close to a border state could have their parole status revoked. And that is a process called expedited removal, which would apply only for people in the US for less than 2 years and who are, once again, in a border state close to the border. And the border includes the ocean. So it also includes California, Washington State. It's good for you to have your records. So that would be my other advice. If you filed taxes 3 years ago, may sound weird. You may want to carry a copy of that tax return with you to show that you've been here enough time to be able to go through any proceedings if needed, instead of to be placed in proceedings quickly when that shouldn't be the case. Lastly, explore options. And I'll repeat this. This will be a common theme throughout this presentation. There are options available. You may be here, for example, as a student, and you may be able to switch your visa. You may be here under temporary protected status. Maybe you can travel and we can find another status, a more suitable status for you. Find your ties to the US, and let's find a way to make you more permanent in the country so you can rest at ease no matter who's president.
Absolutely. Thank you so much, for that hopeful message. And yes, look out for options. I think it's always best to do your research, know your rights, know what options you can have, and of course, consult an expert. An attorney would be great. And, I would also like to appeal to folks out there to call us up. We have Rohan, Bhavin join us. So why don't you also, we will take up your comments for sure a little later in this show. But what I want to tell out to folks out there, yes, take this as an opportunity that you can call us and talk to Isa herself, and just call us on this number which is displayed on the screen above. And so now, moving on, Isa, I have another question, and that is, how can individuals determine, if they qualify for relief from deportation? And,
I'm going to
there is a problem, as you mentioned earlier, then cancellation of removal or even adjustment of status. So how can they know that?
Of course. I'm going to answer your question by, at the same time, addressing Rohan's question in the chat so that he gets a response. The best way to determine your remedies is to determine how did you come into the country. As you keep emphasizing, Nipas, and you're absolutely right. Speak with an attorney. And I get the warning that in many of our countries, for example, in Latin America, notarios may be considered attorneys. In the US, they are not attorneys. So you need to be very careful who you seek legal advice from. Attorneys have a license on the line to lose. And also, if an attorney gives you the wrong advice, there are actual legal remedies that you can use to fix your status, get some status in the United States based on that wrong advice because you relied on it. So that's the benefit of speaking with an attorney. The best way to know what remedy you qualify for is after having that consultation, determining how you came into the country. What ties do you have to the United States? For example, if you've been here for a long time and you're placed in deportation proceedings and removal proceedings, you may qualify, as Tipasa very well mentioned, for cancellation of removal. But to qualify for that remedy, you need ties to the United States, a family member. There may be waivers that may be available, whether if you have a criminal record, that would also require a family member. If you were a resident and you may be losing your status, either by a mistake or something that may have happened, waivers are also available that may not require a family member, but will be based on how long have you been here and your character. So because each case is unique, it's always good to have that consultation and know that there are many remedies that are available only if you are placed in proceedings. In Rohan's case, for example, without more information, it's important to know how we came into the United States, because coming into the United States legally, meaning with a visa or being paroled to the United States, meaning they allowed you to come in, may open the door to other remedies. For example, adjustment of status. That's what we call when you change your status maybe to a residency through marriage. You may marry a U.S. citizen. You may even marry a Cuban resident and acquire status through their marriage, but only if you entered legally. Meanwhile, if you enter irregularly through the border and you overstayed or simply stayed too long, it may be that your only remedy is to seek asylum. If too much time has passed, 15 years or more, it may be that your only remedy is to seek withholding of removal, which means that you are basically trapped in the United States. You're allowed to stay, you're allowed to work, but you won't have the privilege of a residency and you won't be able to travel. So these are little caveats that are very unique to each person's case. And also remember, some of these remedies are only available, sadly, once you are in deportation proceedings.
Right, right. Thank you so much for taking that up, Isadora, and also Rohan's answering to Rohan at the same time. Hi, Rohan. I hope you've gotten your answer, and you can keep commenting and even join us, in fact, if you want to. So, Isa, I want to have ask you to explain a little bit. Why do you think people overstay or they fall out of status and still are in the US? Why not find a solution before that? Play safe.
Lack of planning. I can tell you 95% of my consultations are people coming in and telling me, so I came in as a tourist and what do I do now? And not understanding that as a tourist, you only get merely 6 months. And without a proper plan, simply coming in as a tourist, it's not like the movies where you can just stay and things will be merry. You need to find a way to adjust your status. Or the other way is minimizing it. People simply minimize the consequences. They think, what's the worst thing that could happen if I just stay longer than I'm allowed? That later on, doors that may be available, particularly employment opportunities that are maybe available, are no longer options if you have stayed out of status. If you are in the US illegally without status for more than 6 months and you decide to leave, you basically cannot come back for 3 years. If you're out of status for more than a year, decide to leave, you can come back for 10 years. Same applies for employment opportunities or other visas that may be available. If you're out of status for up to the 6 months, you may be able to change your status, apply for an investor visa, seek that job that you want, change your status. But the 6-month mark is crucial. So the lack of planning is essential. We need to avoid that, plan ahead of time. And also remember, there are other options if you still need more time to plan. You can always extend your tourist visa depending on the visa. And you can also choose to become a student, which is a very popular option, which people decide to embark on. It has many limits. You're not allowed to work, which is very burdensome, but it does buy you, at the very least, buy you time until you figure out what do you want to do in the United States.
Well, there you go, friends. I think it's also ignorance. So I think it's always best to do your research, learn more why you're there and what options you have, especially because that's not your own country and you wouldn't want to be kicked out. I mean, imagine, getting yourself paralyzed of options. I mean, greater options. So, yes, play safe and all the best, I would say. So let's move on. Isa, I have another question for you. And, this is, what role do sanctuary cities, they play in protecting undocumented immigrants? And how effective are these measures under federal law?
So we have seen their role a little bit so far in this week. Granted, it's only Wednesday, Tuesday. We've seen it a little bit, particularly in Chicago. Chicago is considered a sanctuary city, and their behavior during the Trump announcements of the ICE raids in the city shows why they're considered a sanctuary city. They were very clear that the local police enforcement would not cooperate with ICE. However, there's only so much you can do. The reason Chicago was chosen to be the model city for these ICE raids is because of the high volume of Custom and Border Patrol officers and ICE officers that were already located in the city. So the city may be an advocate for immigrants, and they may be vocal in letting the federal government know that they will not cooperate with them. That does not mean that the federal government cannot come in and choose to enforce the ICE raids as they please. What the sanctuary cities tend to do, and we see this mainly in Chicago, we've seen it, and we see it particularly in cities in California, they promote individual rights. Immigrants in the United States have limited rights. It's not the same as what we see on TV. You have the right to remain silent. That does not apply in immigration proceedings. In fact, they're considered civil proceedings because the penalty of being deported is not considered as severe as the penalty of being incarcerated, for example. So you do not have the right to an attorney. However, when it comes to warrants, having to open your door for individuals to come into your house and arrest you, your boss having to open the door for an ICE raid, you do have rights. And you don't have to talk to anyone that you don't want to. You can always politely ask if you're being detained. And if you're not being detained, you can always walk away. Those are simple rights that everyone should know. Last, and I'll repeat that regularly, they have emphasized the right to a reasonable fair interview, meaning the right to an asylum. So for individuals who ultimate choice may be like they've been here way too long, there's no other remedy available, the right to an asylum is a universal right. And if you're able to express your persecution by the government or an agent that the government cannot control, you have the right for an interview. So sanctuary cities tend to repeat this to the immigrant community so that they know their rights, but they're very limited in how they can control the federal government coming in if they want to.
Very, very important points. And thank you so much, Isadora, for highlighting each one of them. And it's so important, to know your rights. And especially in these trying times, I'm sure people are, so anxious as in what is going to happen. They are all seeking help. They're probably Googling, which is not the right place, maybe right now. So I really hope that folks out there are not missing out this session. And yes, if you know anybody who's in this fear of getting deported or are on the verge, so please share this link with them, ask them to join. And even better, that even after this session is aired live, we will still have this. So I hope that folks out there can watch this and don't miss out on the important points that Isadora is really sharing with us today. Thank you, Isa. And let's move on now to my next question. And this is, with regard to folks out there who cannot afford, what legal resources are available for individuals who cannot afford private representation during deportation proceedings.
The way deportation proceedings begin is that you receive what is called a notice to appear. That notice to appear tends to be attached to many documents, including a list of free or low bono providers in your area. So that would include here in Florida, for example, Catholic Legal Charities, that they work closely with private attorneys. We take on pro bono cases to help people. So if you're ever in deportation proceedings, because you'll receive the notice to appear, we call it an NTA because of the letters in English, know that you will also receive this list of attorneys. When you contact them, keep in mind from former experience, these are my colleagues and my friends, they may be overwhelmed, particularly during this time. But I will also give you the second part. This is going to be a very slow process. At least here in Florida, we're having individuals, which are the final trial dates, scheduled for 2028. So that should give you enough time to find the attorney that fits your needs to create your case. That is very different than what we may see, for example, in individuals during the COVID pandemic or individuals in the border. The border right now is in a state of emergency. Doesn't mean that the border is closed. We still have people coming in and out with visas. We still have goods coming in and out. It means that individuals who are seeking asylum might be forced to get this benefit in Mexico. They're not allowed into the US. That is something, once again, that we lived through during 2017 to 2020 in the Trump administration. Those individuals and other individuals who might be in expedited removal have quick cases before judges, and they have to rush to present their case, to hire an attorney. That should be a low percentage. We saw that increase during the Trump administration before. It's likely to increase now, but it should still remain a low percentage. So my point is, look at the list. If you're ever in immigration proceedings and you cannot afford an attorney, look at the list you will receive with your charging document. They may be there, they can help you. And in the alternative, explore how long it will take so that you can find an attorney who can give you a hand. Last disclaimer for anyone seeking asylum. Asylum itself needs to be requested upon a year of entry. So if you've been here for more than a year, you're not seeking asylum itself, you're seeking withholding of removal, and that's based on the fear that you may have of going back home because of the circumstances at your home. So that's something good to distinguish, because sometimes we take a little bit too long to file for asylum and we're out of it. Or we get promised that we're going to file for asylum, but we've been here for 15 years, so we no longer qualify. So be aware of the remedy and talk to an attorney. These are complicated cases. It's good to speak with a lawyer.
Yes, absolutely. Thank you so much, Isadora. And I think, we should quickly take up a few questions from our audience, and that way we can jump back to our questions as well. So let's take up Bhavan's question. I've been detained by ICE before, but was released under an order of supervision. If there's a shift in enforcement priorities, could that put me at risk of being detained again?
Pavan, I hope I'm wrong, but if you are under an order of supervision, typically that happens because you may have a removal order, meaning a deportation order signed by a judge, or your court case may have been closed and administratively closed for whatever reason. If you have a removal order, technically you are already part of the priorities that Trump has already mentioned. So you should be very careful. Right now, my point is, if you have an order of supervision, you don't really have status in the United States. They're giving you the courtesy of letting you stay. That's what you have to report every so often. I highly encourage you to find out what exactly happened. How did you get this order? What was the final decision that led to this order of supervision? See if you can reverse it, reopen it, try to find a more stable status. In 2017 to 2020, we didn't see the Trump administration go directly after people with orders of supervision, but we did see them work closely with countries that were not taking people back to revoke these orders of supervision and send people back. I wouldn't want that to be you. So see if you can fix this. An order of supervision is not the best status. And yes, you could be subject to one of the priorities in the future. Sorry.
Thank you so much, Isadora, for taking this up. And Bhavin, if you were happy with the answer, it's great. But otherwise, we would like to know more information about why were you, put under supervision. So tell us more. And otherwise, why don't you contact Attorney Isadora herself? Yes, and let's go on to Anusha's question. I am an Indian citizen who has been living and working in the US on an H1B visa for the past 5 years. Recently, my employer filed for my green card, but the process has been delayed due to the COVID-19 pandemic and the Trump administration's immigration policies. Okay, I'm getting married to a US citizen soon and am worried about my immigration status. What are my options for obtaining a green card and how can I expedite the process given by my circumstances?
So I'll go through each step. First, if you're here on an H1B, you should be okay. As you know, the H1B, and if you don't know, now you'll find out, you have a limit of 6 years. So eventually you need to know how long have you had this visa, and it will only count the time that you've been physically in the United States. So if you're close to the time and maybe you spent 6 months out traveling, you can renew for that amount of time that may be left on the visa. As to applying for the green card, when an employer files for the green card, they have the choice of doing it in an adjustment packet, which would mean doing the petition with the residency petition all together at once. Or the way I prefer to do it is to split up, to do the petition first, get that approved, good for you, and then apply for your residency. And the reason I prefer splitting it up is that if anything happens with that first petition that is not approved, I can fix it. So instead of having it all denied. So it's good for you to know, how did your employer apply for this green card? Did they do the entire packet? Was the petition will be called an I-140 petition for employment, employer petition. So if that I-140 was already approved and they filed for your residency, you can relax. You're here pending adjustment. So congratulations on your marriage, but you're okay. You will eventually receive your green card through your employer if the I-140 was already approved. If they was filed in a packet, same thing. You can just simply wait for the decision. But you asked about expediting. If it was filed in a packet and you don't have a decision on the I-140 petition, you also could file through your marriage. You can have many petitions running at the same time. You can have a petition through marriage. You can have a petition through one employer, two employers, three employers. You can have it through many spouses, but you could have it through several employers. So you can have many petitions running at the same time and see which one gets to the finish line first. Typically, we've seen the marriage petitions tend to be quicker. We've seen that. In 2017 to 2020, petitions that were taking 2-3 months during the Obama administration, that were also taking 3 months during Biden, back then were taking 2 years. So I can't guarantee filing through your marriage will expedite it, but it's definitely something you could do, and just have them running at the same time and see which one gets to the finish line first. As long as you file any petition for your residency, which is the I-485 application, as long as you file that application while you're here on your H1B, doesn't matter that your H1B expires, the time that you're waiting, you're here legally. And you can apply for a travel permit if you need to go home for any reason.
There you go. Anusha, thank you so much for participating with your comments, and I hope you got your answer. Thank you, Isadora, for taking that. So would you like to tell us also, how important is the I-140 and the I-485?
So first, I wanted to emphasize that as to how some people do it, because I know that many of my clients many times want the entire petition together. They want the I-140 petition for the employee filed simultaneously with your I-485. It's very important for you to know which category you're applying under. If you're an EB1, meaning you are, and we're not very creative in immigration, so the letters and terms that we use are very boring. And EB1 means employment based. So when you hear EB for any term for immigration, at least, that's residency based, employment based petition. EB1 are the bosses, the big boss, the one that never answers the phone. He just tells people what to do. If that's your case, then you may be eligible to file the entire packet together all at once. If you're in the second category, which is EB2, that tends to be extraordinary individuals or individuals who are going to be working for the common good, something in the national interest. It's good for you to follow exactly, it's called a visa bulletin, and it will have dates letting you know if your application is what they call current or if you're going to have to wait. Because I also wouldn't want you to waste money filing an entire adjustment package with an I-140 and I-485 application for residency only for it to be rejected because your application is not up to date. I can tell everyone here who may be in the most common category, the EB3, which is for the regular day-to-day employee who has a degree and is needed for the economy, but simply can't be found in the U.S. economy to work the position. Those individuals will have to wait. Right now, they're processing the applications from 2022, if I'm not mistaken. It could be 2023. So it's not current right now. So it is best to file your I-140 petition first, no matter what, because you're going to have to wait. And as it is pending, once it is approved, you will know the date when you can file your I-485 application for residency. While you're waiting, you need to keep legal status if you're in the U.S. Otherwise, you can always do a consular process and receive your green card in your country through the embassy.
Thank you. Welcome back once again, everyone, to Immigration and Jobs Talk Show. And it's really exciting today that we are having a great discussion with none other than Isadora Velasquez. And yes, we are here talking about a very, very important topic today, facing deportation under Trump's immigration plans and what are your legal options. Well, thank you so much, Isadora, for being here today and for patiently answering, taking up so many of our questions and making this discussion a very interesting one so far.
It's my pleasure. I see that Pratibha has a question about
Right.
overstays, which I asked before, Nipasa. What happens if you overstay? I don't know if you want to read it, and I'll gladly answer it.
Sure, I can read it. I overstayed my student visa years ago, but I've since started a business and contributed to my community. If deportation becomes stricter, can my contributions or business ownership help my case? Pratibha is
Under
asking.
the law, and like I said before, this is over 40 years that the law has not changed. Your contributions while out of status will always be beneficial. The same, it's called the ties to the country. So the contributions, your business, any family you may have, the amount of time you spent in the United States will always be, they will be considered beneficial factors for you to present your case. And depending on how long you've been in the US, you may qualify for some things that we discussed before if you're placed in deportation proceedings. Now, please understand that contributions alone are not sufficient for you to seek a legal remedy by yourself. It might not be enough. So you may need a little bit more than simple than a business. And I'm not doubting your business is very successful. I'm not doubting they're contributing a lot, but you may need more, especially if you want to seek business by yourself, if you want to seek a visa or more control by yourself. So the ties tend to prefer family ties. Business will definitely help you fight for your right to stay, but it might not be enough to actually win your right to stay. So keep working on it, keep building it, and in the end, they may help work on your favor.
Thank you so much, Isadora, for taking that up. And Pratibha, I hope you've gotten your answer and you can keep asking more questions if you have any further questions. So, Isa, we also have more questions from our Facebook group. So I think we should quickly address them and then when we get time, fall back to our questions again. So, Control, if you can display them, please. Let's take up this first one. This is from Krishna asking, hi team, H4 to F1 transition. Could you please zoom in a little bit? What are the best options to choose for changing to F1 from H4? Her F1 visa is rejected in India and she came back to USA on H4.
If the F1 visa was already rejected at the embassy, the F visas, and for those of you who don't know, the F visas are student visas. The student visa, in my humble opinion, should always be processed by the school that is issuing you the visa. As international students, you will end up paying much more than residents or citizens of the United States. And the reason why your tuition is so much more expensive is because the school has to be heavily involved in the visa process. They have to apply for the visa for you. So if for any reason India rejected your F1 visa, you can always choose to change your H4 status in the United States locally to an F visa. The big caveat here is that when you choose to travel for any reason and you go back home in India, you'll need to get your F1 visa on your passport. That's the difference between what we call a change of status, changing your status from H4 to an F1, than to acquiring status. You cannot come back after you change your status under an F1 visa if you don't have it on your passport. So you will have to go back to the embassy. They may reject it again. Very helpful to know why they rejected it so that you can fight it here and be ready to get it again after you change your status in the United States.
Thank you so much. And I hope, Krishna, you've gotten your answer. I think this was a question for somebody else, but yes, great question. Let's go on to our next one. This is from Sachin. Hi, all. I am currently on STEM OPT with my end date in February 2026. I have one more chance to apply for the H1B lottery this year. If my H1B gets picked and approved, will I be able to travel to India in August and return to the US by October 1st? H1B deactivation date.
So I'll explain the H1B lottery visa process. You will know if you were chosen by this lottery basically by April. You should know by April. And hopefully your employer will be applying for your visa by the summer, before August when you leave. Because ideally, you will be coming back to the United States after your trip in August by September. So to answer your question, yes, you can leave in August and come back in October. That's perfect. But you may want to come back a little bit earlier, maybe a month earlier, before what we call the fiscal year starts, and get settled up and find the apartment, get set up to begin working. And you should be allowed to return in September if you're picked up in the lottery for April. So good luck. Hope it happens.
Yes, all the best. Since it is lottery, I think you need all the luck. So all the best, Sachin. Let's go on to our next one. This is from an anonymous member. As an H1B holder, I avail Medicaid for children and premium discounts, tax credits from state on health insurance purchased via marketplace. To my knowledge, it doesn't fall under public charge category. And will this cause any issues in future visa extensions or green card process? Any expert opinions are appreciated.
Great question. The marketplace, also known as Obamacare, is private insurance. The only reason it's called the marketplace, Obamacare, is because of the law that forces these companies in private insurance to give us that insurance, even if we have pre-existing conditions, and for the government to subsidize that insurance if we cannot afford it. But it doesn't mean that it's a private company, so it shouldn't affect your public benefits, because you're not receiving any public benefits. I would encourage you to try not to accept any government subsidies when it comes to paying. If you can pay it out of your pocket, that would be best. But feel free to use the marketplace for your insurance needs. You're entitled to it. You should be okay. It should not affect any visa or future green card process.
Great. Thank you so much for taking that up, Isa. Let's go on to our next one. And this is also from, okay. My H1B extension was submitted on August 2nd, 2024. H1B expired on September 30th. Until today, it's been in review status with no update.
You have the option, and you may not like it because it's pricey, but you have the option of paying $3,500 more. It's called premium processing, and that will force the government to give you a decision on the extension in 15 days. Make sure you have the option available. You have to let them know ahead of time, send them a check. It is a good option if you want peace of mind. However, technically, under the law, during the time that you apply for the extension, it's the same as when you're applying for a change of status. So you are technically, legally in the United States until a decision is issued. So be on the lookout for that decision. If you really want the peace of mind, it's worth it to pay a little bit more, but be aware that technically under the law, you should be okay until you get a decision.
Okay. Thank you so much, Isa, for taking that up. Now let's go on to our next one. This is also from an anonymous member. Planning to travel with family from US to India this year after a long time. H1B, H4 visas have expired on our passports, but have approved extensions, I-797 petitions. Travel costs seem exceedingly high to travel with family, but routes via Europe seem relatively on the lower side. Question is it possible to travel via Germany or UK, etc., with an expired visa? And the second question is, would a transit visa help? And next is, don't bother, take a different route.
The answer I'm going to give you, what they will call in the US a very legal answer. It depends. What are you coming to do in the United States? If you're coming to work, you can use your H1B, H4 expired visas because you already have the extensions. It doesn't matter if you come through the UK, Germany, it doesn't matter. You should be okay because you have extensions on your H1B and your H4 visas.
Mhm.
However, if you're coming as a tourist, you will be asked why you're coming to the United States. So if you're not coming to work, then yes, the best way would be to apply. I wouldn't call it a transit visa. I would call it a tourist visa. We also call it the B1, B2 visa, B1 is for employment purposes when you come maybe for trainings or for a conference. B2 is when you come to visit Disney World or to check out how California is doing. So if you're coming as a tourist, that's the way to go. If you're coming to work and your visa has been extended, you should be okay. Doesn't matter where you come from.
Okay. Thank you so much, Isa, for taking that up. And let's go on to our next one. I think this is the last one from our Facebook groups. This is also from an anonymous member. Recently got a Canada PR and have H1B job in Seattle, 2 days a week in office. Employer doesn't care if I spend remaining remote days in Canada. So for H1B stamping, is it okay to disclose I may work remotely from Canada regularly or occasionally? Wondering how to answer the question, will you be working remote or hybrid from your work location?
Answer yes. And the main reason I would say answer yes is because now that you have the permanent residency for Canada, you may be seeking a more permanent status in Canada. And you'll find out that once you have Canadian status, you can come in and out of the US for 6 months per year, no questions asked. It's actually very flexible. Being candid and honest now, letting them know that you have your Canadian permanent residency, that you will be working remotely from Canada, will also help them relax a little bit whenever they see you and asking you questions if you choose to come in through the Canadian border. So answer yes, you will be working remotely. That's still your H1B visa was still approved under the same conditions, so it shouldn't be an issue as you come in and out through the border. You'll also notice that the Canadian border is very flexible. If you have to renew your visa, you can do so through ports of entry through that border. So it's good to be honest with them and letting them know that you're spending time in your new home of Canada.
That's great. That's great. Thank you so much, Isa, for taking that up and so patiently answering each one of our group Facebook group questions as well. Yeah, and brings me to another question that I have for you. I have prepared some more questions, and this is with regard to mixed immigration statuses. So families with mixed immigration statuses, can they take proactive steps to prevent separation or deportation under the current policies?
Yes. So if you have children over the age of 21 who are US citizens, I don't care if your mom and dad don't want to live in the US. If you are in the United States and you're over the age of 21, give your Mother's Day, Father's Day present by simply filing for your parents. The reality is, children, we have the control. It's our petition when we're petitioning for our parents. So we can be proactive, we can file for them. And later on, when mom says, I don't want to move to the US, I don't like that country, it's okay. At least you tried. You have it there. It's ready just in case. If you're in the United States, you can also file for your parents. And if you enter the country legally, it doesn't matter if you entered 20 years ago or actually 22 years ago and you were born the year after you entered, you will be able to give your parents legal status through this petition. So for children over the age of 21 who are US citizens, petition for your parents. For spouses, any spouse who's a US citizen can petition for the other spouse immediately. They can get them status. I say immediately because technically under the law it should be available immediately. You may have to wait a couple months until it's processed. So if the individuals are in the US and they came into the US legally, you will be able to help them adjust their status to a residency fairly quickly. If they came through the US illegally, meaning through the border or something happened, they may qualify for waivers. These waivers are scary because they force you to leave the country, leave the United States, and get your residency in your home country, but they're worth it because if you already qualify for the waiver and you're approved by the time you leave, it should be just coming back with your green card. Scary to leave, but definitely worth it. Now, Trump knows this is happening and he warned us. Part of his campaign promises were that he was willing to separate families that were mixed, as you mentioned, individuals who may have children in the United States, but the parents don't have status. And he warned us of this because back in 2017 to 2020, we saw family separation in the border as a deterrent for people not to come in. So he knew that it was going to be very shocking for, especially for US citizens, for his voters, to see children separated. So I know it is extreme, but I have been warning my clients to, if you know you're going to leave your child or you may be forced to leave your child, or that could happen, that if you have an encounter with immigration, your child is a US citizen, but you are not, it's good to have a plan. So I hate to send that answer in a sad note, but it is helpful to have a plan. Who will care for your children? Power of attorney if you may need it, because he has made it clear that he's willing to go forward with this, even if it's something the U.S. Citizen is against. It was part of the campaign promises, and so far he has delivered in the past 2 weeks.
Thank you, Isa, for that insight. Really, very helpful. And now let's move on to our next one. We see that there are a lot of changes. It's just been a week with Trump hitting the office, but then how have these changes, whether you talk about visa or green card policies, how have they impacted these deportation risks for non-citizens in the U.S.?
So the main impact that we've seen, of course, is fear, because we don't know. And that's why I start by always warning everyone to at the very least know your status. And after you know your status, meaning know if you have a deportation order, know if you have been in here illegally but you entered legally, and you have a business here, you have a spouse here, you have a child here. Know your circumstances, know it well so that you can present it. Know your country. So know that if you have an encounter and they want to send you back to Nicaragua, now there's a dictatorship there. You cannot go home, and then you can articulate the reasons why you cannot go home to you, not to the country in general, to you. They will follow me or persecute me because I am a woman, because I am gay, because I am religious, whatever it may be. Make sure that you are able to explain it if needed, because that's what we've seen, that these are encounters that, although he warned they would happen, people are not ready for them when they do happen. Lastly, if you have the relationship with your employer in which you can be fully honest with them and have them understand both your rights and their rights, an employer is very limited sometimes in their rights depending on their state. For example, the state of Florida gives a lot of leeway and authority for inspectors to come into my workplace. So there are limits, but you typically require a warrant. And if typically a warrant is not available, these ICE visits, these ICE raids are done on a whim. We assume this person's here. They may be looking for somebody else who's not you. So request that document. It may seem simple, but it's important and very helpful.
Thank you, Isa, for taking that up. And now that everybody is facing a lot of fear of deportation, what would you advise employers of undocumented workers who are really concerned about potential workplace raids as well and deportations? What do you suggest they do?
For the employer on a personal level, I know the concern, for example, Florida, the main concern is whether we're going to be fined, and the fines can be steep, but the fines are available everywhere, doesn't matter where you are. And they tend to be related as to having individuals work for you who don't have the proper documentation. What I've noticed in the past, doesn't matter the president, from Obama, from George W. Bush, when I started practicing, to now Trump, when you're able to show that you've consistently paid the correct wages, meaning that you were not underpaying your employee because of his status, they tend to be much more flexible with the fines. They tend to lower them because they understand that maybe you hired out of necessity, which tends to be the case, or maybe you hired out of ignorance. You didn't know that you had to request all those documents to hire somebody. Now, to protect your employees, a warrant is needed to enter your place of business. In Florida, an inspector can enter your place of business to check out if you have 25 employees and to determine if they're here legal or not. That's a local law. But under federal law, to enter your place of business, it's like entering your home, and you can reserve the right of admission. You can call your business a club, and you can simply say, I'm not letting you in unless you have the warrant that forces me to let you in. And check out that warrant. You may be able to give that employee a warning, a heads up. For employers, the reality is that we know when they're coming. We know, and they tend to come to us normally not for immigration reasons. So if you have a heads up, be nice. Let them know, and they'll be out of there.
That's a nice one. Thank you so much, Isa. Yes. And I have another question, and this is with regard to legal protections. We've been hearing a lot of raids in schools, even in worship places. I mean, recently, even a Gurudwara was raided in New Jersey and New York, I think. So, what legal protections are in place for students and families affected by school raids, and how can, these institutions respond to such incidents?
Well, sadly, the same way I started with the sad news that a president can get rid of your visa by simply signing an executive order. In this case, sadly, for the legal community, for the immigrant community, the legal protections can also be eliminated by signing an executive order. President Trump recently signed one of memorandum executive orders saying that ICE raids can occur, as you mentioned, in schools. They can occur in hospitals. However, there are some places that tend to be considered places of business, and they can be protected. Churches are the most common one. So you can seek protection there. That would be, we're talking here of extreme cases, but we've noted that tends to be where people feel the safest. And in reality, that is another place in which you would need a warrant to enter. But public spaces such as schools and hospitals can no longer afford the protection that we typically associated with these areas. So we have to be mindful. A little trick: when we have minor children, we sometimes don't apply for them to have a work permit because they're little. Why are they going to work? Who cares? But now I find myself warning my clients that it might be a good idea to have their child, if they're here on a status that may be temporary, like temporary protected status, or even under particular visas like the H visa. Of course, your child's not going to work, but maybe you want to pay the $500, $600 and get that work permit so that he can carry that ID showing that he's here legally. It sounds weird and not needed because it's not needed, but these rates are terrifying even for attorneys. And the fact that they can go into schools, I would like to protect my child if that were the case.
Yes, for sure, for sure. And talking about Miami and your place out there, I'm sure it's been very busy. I mean, the past week must be crazy. How is it? Would you like to share some cases or incidences? Anything you want to share with us would be great.
So Miami has one particularly notorious ICE station. It's called in Miramar, and it's fairly busy. Typically at 9 a.m., we have people who will be showing up in orders of supervision. During the Biden administration, it became routine. They would get a new number. Miami also has the little caveat or the little additional flavor of the Cuban community being very, very famous here. We have a lot of Cuban communities, many Scarface, believe it or not, from that back in the day. It's very interesting that many countries that back then were not accepting people, deportees, I emphasize Cuba in particular. Now you're finding that when you're reporting, there is a sense of fear that Cuba Cuba has accepted deportees since the Obama administration. That's something that changed. It has since stopped during this Trump administration, Venezuela, Nicaragua. So we have this new flavor of people who are coming in with deportation orders, order of supervision in the morning, who are routine up to that point. And then you have the second wave that comes during the day, and that's where we see the ICE rates. And it is a little bit like Top Gun, the Miramar station, but it's not as cool. We don't have good looking Tom Cruise looking guys. It's just a simple building with no windows, very terrifying. But we do see the wave in the morning of the people reporting who regularly report. And in the afternoon, we see the effects of the ICE rates that are very notorious in Miramar.
Well, I think, all I can say, it's getting scary, and I think it'll be best to stay safe. So, maybe last but not the least, if you could wrap up by giving a few tips to folks out there who are facing fears right now, and tell us what should we do next.
I'll begin and end with the same note. Anyone who is subject to removal, who may not have any legal remedy, maybe you have a deportation order, maybe you already tried to reopen that case and you failed, maybe you appealed it and you failed too, you stayed too long, you came in through the border, there's really nothing you can do. Asylum, you may not be able to qualify for asylum itself, meaning you won't get a green card, but the asylum right, the right to seek asylum, protection from going back home, is a universal right. So you can always say, I'm sorry, I messed up. I've been here for 25 years. I have no papers. You're absolutely right. But I'm terrified of going home. And this is why. Asylum must be from the government or from an agent that the government can control. So if the police is going to be looking for you because you're a girl and they don't like girls and you know it, and you can say, hey, my country, women are persecuted and I'm a woman, verbalize it. Second, and I mentioned this before and I'll mention it forever, at least for the next 4 years, know your status. Sometimes we ignore it because we're afraid. We think if we ask, we're going to expose ourselves. It's good for you to know. By knowing how you came in, you may be able to fix it. Deportation orders can be reversed. The law changes. People may get deported for something they did 10 years ago. The best example, marijuana. Huge deal in the 60s and 70s, not as much right now. So if you were deported in the 80s because you were smoking a joint, maybe now you can get rid of it. So it's good for you to keep that in mind. Know your status. Know your family. Who do you have in the US? Siblings, you may love them. Aunt, auntie, uncle, you love them. They're not going to give you anything. You want your mom, you want your dad, you want that. Siblings, they may give you something, but it's going to take like 20 years. So, and you want your children. So know your family and keep being like your listeners. Keep growing your businesses, keep growing your ties to the US. They may help you if you end up in deportation. Remember, asylum is a right. You can ask for a reasonable fear interview. Just remember that if you forget everything else I said.
Thank you so much, Isa. That was really very helpful. And I think if we still got some time, we should take up Ansa and not leave her without an answer. So Ansa's asking, what can I use as ID for my daughter who is pending H4 dependent visa? And can the letter I received from USCIS be used as evidence?
Yes, Ansa, it can definitely be used as evidence. Anyone who has any letters from immigration, make a copy, keep them with you. It's good to have them, especially if that letter has any dates for over 2 years, because then you will not be subject in the worst case scenario. You will not be subject for something called expedited removal. So keep that in mind. You can use that for the time being. You can also check in your local DMV department what they can accept as documents for your child to get an ID. And maybe they can get our local state ID. That might make it easier for all of you.
Thank you so much. Thank you for taking that up for Ansa. And Ansa, I wish you could join us on call. But yes, if you're still available, 425-436-6335, and the access code is 988-888. Join us. But nonetheless, it's been a really very insightful session so far, Isa, and really great having you. It's our first episode together. And folks out there, you can call Attorney Isadora herself, and you can also email her with regard to your case, your status, and with all the details, write to her. You can call her on her number 305-938-0676, and her email address is isadora@isalawyers.com, and go visit her website www.isalawyers.com to get to know more about Isadora. Well, do you still have anything else to share? I mean, this last week, do you have any deportation case that you're dealing with that is interesting that probably you want to share with us?
Yes, I do. I have many of them actually. And that's why I started by mentioning that many of these cases are being reset. What we notice is some judges, Miami is a very busy jurisdiction, as you can imagine. So we have some judges resetting the final hearing dates for 2028. These notice in the mail, if you are to be placed in deportation proceedings, you could receive a notice in the mail, what we mentioned, the notice to appear. And it will have a date in the bottom. And it may seem very simple, minimal, something that you may want to ignore because what's the big deal? Don't ignore it. It's best to show up, even if you don't have an attorney. It's best to show up and simply ask for more time. Most judges, 99.9% of judges will give you time to find an attorney to move your case along. If you talk to an attorney ahead of time, they might be able to explore options to close your case or maybe see if there's something that can be done so you don't even have to show up. But most likely you will have to show up. So it's good to just simply go. Don't ignore it. As to interesting cases, that's where it's good to know that the law itself, once again, has not changed in over 40 years. I'm getting the same cases under the Trump administration that I would get under the Obama administration. What changes are the discretion that some prosecutors may have. So it's good to have a good report with the court. And what I'm finding now is that simple cases that are maybe, it's a deja vu of 2017, simple cases that I would have gone dismissed or resolved, because I gave the example of marijuana, not a big deal right now, big deal before. It could definitely get you deported. Now I find that prosecutors, and it's not a fault of their own, I don't have the privilege of negotiating with me and getting the case dismissed or getting the case closed. So it's good to speak with an attorney and show up no matter what. Even if you're alone, show up. The judge will give you more time, and you will have time knowing that cases might be set for 2028. So you have 3 more years to figure out what we can do for you.
Yes, that is it. Thank you so much. Thank you once again, Isadora. It was really, really very insightful, this whole session today. And I wish we could go on speaking, but, I will save some, so that you can join us very soon again, maybe discuss on another very important topic. Since changes are happening, it's just so dynamic. Every day we hear new news, everything is, popping up every time, and everywhere we see is Trump, and whatever Trump is doing is affecting so many people out there, immigrants, America, or even the world. So there we go. So I hope that you can join us soon again. And thank you. I hope you have a great day ahead today.
I would love to join you, please, whenever you need me. Lastly, for your audience, you may hear about getting rid of the 14th Amendment, which is the birthright citizenship. That is still
Yes.
pending. The Supreme Court is likely to hear it. So the law remains. People who are born in the United States are citizens as per the Constitution. Just last thought of the day.
Thank you for that. Thank you for that too. Yes, I think we're going to hear soon about that also, probably another 10, 11 days we still got in hand. And let's just keep our fingers crossed until then. Thank you so much, Isadora. Really great having you. See you soon.
Same here. Take care.
You too. And folks out there, thank you so much for joining us. And please feel free to contact Attorney Isadora herself. And you can email her. You can even call her up. Go visit her website as well. And her website is www.isadora at, sorry, isalawyers.com, and you can email Isadora at isalawyers.com, and you can call her up also at 305-938-0676. And you can also call me. You can even WhatsApp me. I have a phone number, 408-335-6444. That's my number. And you can also email me about your case. And, that way I can forward the emails to Attorney Isadora also. My email address is nipa@staffingly.com. Thank you so much for joining us today. Y'all out there have a great day ahead. And stay tuned on Immigration and Jobs Talk Show, because at 4 p.m. Eastern Time, I'm going to be back with my co host Sam on Daily Immigration Dose. And yes, keep watching our space. Have a great day. Bye bye. Hello, everyone, and welcome to Immigration and Jobs Talk Show. I'm really happy to be here. I'm Napasa, your host for today's session. And before we head on with our webinar for today with our amazing guest, I have this very important disclaimer to read. And that is by watching our videos, you agree and understand that the by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, once again, folks, thank you so much for joining us here on Immigration and Jobs Talk Show. We are streaming live right now on YouTube, LinkedIn, Facebook, and on X. So, please feel free to join us. It'll be really nice to have your participation. All you have to do is comment wherever you're watching us. And also, if you are in America, you can call us on this number 425-436-6335, and the access code is 988-888. Take this as an opportunity because we are going to be joined by a very familiar face who has been with us, for I think almost a year now. But it's really great to keep having him because he has such great insights to share, and he is none other than immigration attorney from SPB law firm, Attorney Chand Parvathaneni from Dallas, Texas. So please help me welcome him back once again. Hi, Chanda. Thank you so much for joining us, and I hope you're doing great today.
Thank you, Napasa. Yeah, I hope everything is good on your side, and thank you for inviting me to be on the
Thank you
show.
so much. And I'm pretty sure you know that it is a very busy schedule for you, especially with the Trump 2.0 and this past week, with all executive orders being signed. So I'm really, really honored, and I truly appreciate that you have taken some time out of your busy schedule to be with us. So I'm excited for today's session. And if you could tell us what can folks out there expect, on today's discussion.
Sure. So we have seen about, a week of President Trump's administration, the second term. And in the last couple of days, we've been seeing a lot of issues. We are seeing a lot of media articles and news reports. Some of it is real, some of it is fake. We're seeing all kinds of news. And I think today, what I want to discuss is the trends in the last 1 week or so. We have done H1B filings, we have done I-140 filings in the last 1 week. We have seen approvals in the last 1 week. So I want to discuss about what are the recent trends we are seeing in terms of employment-based cases, and also compare that with what's happening on the deportations, because the deportations have started. People are getting arrested, and what's going on? What kind of people are getting arrested? What kind of means is the administration using to send people back? How quickly are they doing it? And so we'll discuss things around it, its impact to legal immigration, its impact to illegal immigration. Because when we talk about immigration, we see two kinds of situations. One, somebody is actually entering into the country and properly inspected by CBP, properly going through the visa process. And we have those kind of immigrants who are in the country who are also concerned. Then we have other side where people have entered into the country without any kind of inspection. So we don't even the government does not even have a proper data on them, and they're not inspected. So the rules are different when somebody is coming into the country through an inspection, and the rules are a little bit different. What happens if somebody overstays their visa? They can come into the country legally. Probably they're not in the country legally right now. And then there is this other aspect where somebody just came into the country day one itself, they were illegal. So the current regulations, the current law, it has uh, various laws on all these situations. And I think we'll talk about the legal immigration part and also the illegal immigration part, and it's like impact all across the board. Because in the end, a lot of these people are actually contributing to US economy. They are actually working in United States, whether it's legal or whether somebody's working in illegal status, they're still contributing by working for the local economies. So definitely, I think there'll be impact, and what kind of impact is expected, and what are the legal rights for people in various situations. I think we'll probably use that this time to discuss those things. And the goal again is to educate people with the importance of compliance, with the importance of following the rules and doing everything right, so they're not even in a bad situation where they have to worry about deportation.
Absolutely. And thank you so much. Those were great points to keep in mind. And folks out there, today we are going to, revolve around whatever Chan has just mentioned just now, because our topic of discussion for today is how are Trump's deportation plans reshaping immigration and employment cases in the US. And as we see, whichever side we look, whichever site we visit, everywhere we see is Trump, his decisions, his orders, and we hear about a lot of deportation cases, immigration, not just being affected in the United States, but the whole world is getting affected by, all these laws and orders that Trump has passed on. So it's going to be a very, very interesting topic. Stay with us, friends. And I'll quickly say hello because we have Sunita who has joined us with your comments. Sunita, stay with us. We are going to take your comments. And if possible, anyone out there who's watching us, do join us on call. It'll be very nice to have you join us. So, with that said, let's jump into our topic for today and talk about deportation. So how do you think, Chant, that Trump's deportation plans, like using military planes, reshape the future of U.S. immigration policies?
Sure. So in general, like when we talk about immigration, illegal immigration or deportation in United States, so the way it works is immigration comes under the federal law, and what that means is the local state police. So like every city, you'll see the police departments. The police departments don't enforce the immigration law, and what that means is if the police stops somebody, and they don't typically ask about immigration, they don't typically enforce immigration rules. It's the federal government that typically enforces immigration, and that basically boils down to ICE, called Immigration and Customs Enforcement, or CBP. So they are the people that typically enforce the federal law. So a CBP officer, a federal government officer, the ICE officer, so they have the power of actually asking people about immigration and enforcing the immigration rules. So nowadays, what we are seeing is in the way of doing things. President Trump has stated that people who have criminal backgrounds, they are the ones that are going to be targeted. And in terms of what is happening is ICE seems to be specifically targeting people with criminal background. So I think they're not going after people who don't have criminal aspects. When I talk about criminal, a part of the administration is talking about anybody in the country illegally, technically has broken a law, so they are criminals. But I think in reality, I think they are actually targeting people with a real criminal background. But what is happening is there is collateral damage. And what that means is when there is a raid, a nice raid, they're going after people, they have information that they have some criminal background on their records. But unfortunately, the people around them, even if they don't have a criminal background, they will have collateral damage, which means when ICE is picking up a person who has criminal background, at that time, if they see somebody around who does not have criminal background but is illegal, they're getting picked up. And in the recent times, in the last week or so, what we have also seen is military planes are being used for deportations. So military apparatus is getting used, and normally it doesn't happen that way, because the way the deportations happen are the federal government, the federal officers, they do the deportation, but typically military planes are not used. But because President Trump's administration, I think their focus on deporting people, specifically people with criminal background, what they've said is they're going to spend money, they're going to start using military planes, and that has already started. And we are seeing military planes being used. And what that means is you can see significant ramping up and enforcement using military planes. And it's a standard shift from the standard way of doing things. So in reality, that leads to a quicker and a faster deportation process, because normally it's a very slow process. You have people in detention centers. It's a very lengthy process. Nowadays, using military planes, what that means is people are getting deported very quickly. And using military planes, is it a good way or not? There is a lot of debate, and a lot of countries, the countries where these planes are going into, uh, they've raised concerns. They're raising concerns that these people are not really criminals. They are people who just went for looking for better options for their family. So it's a bad message when people are actually put in handcuffs and sent back in military planes. So I think that's a debate that's still ongoing. But at this point of time, we do see that there is a militarization of immigration policy using military apparatus. And definitely there's going to be impact on immigrant communities. There is a lot of fear. There's a lot of anxiety in immigrant communities because what happens is we're seeing a lot of mixed families. Somebody's a US citizen. They have US children, US citizen children. And then say one of the people in their family is illegal. So now it's causing more fear, more anxiety, and it's leading to a chilling effect where immigrants sometimes probably are even avoiding to seek help or reporting crimes when they are really like a victim of some crime. I think the reason is they don't want like the federal officers to come and then deport somebody in
Yes.
their house. So even if some people are a victim of a crime, I think they're just hesitant to ask for help. So these are the kind of consequences we can see. And since it's just a week, I think we just have to see how things will go in the future. But definitely, we're seeing the trajectory of U.S. immigration policy shift. And right now, I've never seen enforcement so aggressive. Yes, enforcement was always there, and I think we talk about the last 4 years of Biden administration and that administration. I think definitely, I think we're not as aggressive as the current administration, and that led to more problems because I think it led to more uh, people with criminal background slip into the country, which I think caused this whole issue right now with aggressive
Yes.
enforcement. And we'll have to see how things will go into
Yes,
the future.
absolutely, Chand. Very well put. And when you talk about aggression, yes, it's like never before. And not just that, I mean, ICE raids are so frequent, and it just started, I think, the second day or the first day itself when Trump joined office.
Mm.
And not just that, ICE are also being joined forces by FBA, DEA. They've just become stronger, and they have been doing these raids right, left, and center. So it's really scary a situation out there.
So, yeah, so typically they're using like various. Yeah, I think it's not just ICE. I think they're using all federal officers from various other departments. So it's like multiple departments from the federal government. I think that are working together to deport people. But I think the goal, I think, it's still to deport criminals.
Yes,
I think they're like talking about like hardcore criminals. But unfortunately, I think some other people are
affected.
getting impacted because of collateral damage. But I think at least the goal is like be very, very aggressive with people with criminal
Yes,
backgrounds. Because unfortunately, I think there are some people who are like murderers, who are child rapists out there who are illegal. And I think nobody wants people with such criminal backgrounds. But because of focus on these guys, some people who don't have any criminal background are also getting
so true,
impacted.
so true. And yes, the discussion is on, folks. So keep joining us. It'll be really nice to have you comment and join us on call. The phone number is 425-436-6335, and the access code is 988-888. I mean, you can even join us to tell us if you are facing any such issues with yourself, and maybe, yes, join us. It'll be very nice to know your story as well. So, yes, Chanda, thank you for that highlight and a good start to our session of discussion for today. Moving on, I have another question, and that is, these deportations already started to happen. And how do you think these deportation policies are impacting immigrant families also who are really dependent on US jobs, and maybe they're sending money to their home countries as well, to their families?
Sure. So most of the immigrants are actually like hardworking people. They actually come here to work hard and provide for their family. So a lot of people, majority of the people are of that attitude. And unfortunately, now what's happening is I think people who are impacted. I think they will have profound impact on their families because there is going to be economic disruption. These immigrants, they depend on working in US. They support themselves and they also support their families back home. And these mass removals there and this increased fear of deportation, sometimes people are losing jobs and it's a sharp loss of income. And not only that, I mean, again, people who are legal, who are actually working hard, the whole uncertainty and anxiety and job security, things like what will happen when I apply for my visa extension, my H1B extension, will I get a denial? So I think that uncertainty and anxiety is like increasing even among people who are having a legal immigration status, people on F1, for example, they're worried. What tomorrow when I apply for H1, will I get an approval or not? What is going to happen? So all this anxiety, will there be a backlash against immigrants? So all that uncertainty and anxiety, I think what's causing is people are not able to perform to the best of their abilities because people are depressed. People are sometimes not sure what is happening. And this, I think, will definitely have an impact on remittances, not only remittances, their own productivity. I think the productivity is going to get impacted. There's going to be psychological and emotional strain. The whole this daily news about deportation, it's creating an environment of constant stress. This is for people who are legal and also people who are not illegal. Even because people who are legal, they're just worried because I mean sometimes the media makes it sound like uh, there is so much of backlash against immigrants. It may or may not be true, but the way the media, when I talk about media, even the social media, because social media, not everything that shows up in social media is the truth. And I've seen like so many reports where people call our office about something they heard in social media, somebody getting deported, even if they had a visa. So all these kinds of stuff. So definitely, I think we are seeing increased psychological and emotional strain, and it's not only going to impact the immigrants, it's also going to impact local economies because these people work in the local areas, they contribute to the economies, they rent houses, they spend money, and they do all these things because it's people want to work hard. Majority of the people are working hard. I think eventually, I think what it's going to lead is it is definitely going to lead to labor shortages, and we're going to see some impact on local economies if things are not done right. If all they're focusing is on people with criminal backgrounds and that is their focus, I think we will not see a major impact. But if they're like focusing on everybody, and again, we don't know where it'll lead to, but there is a good chance of an impact on the local economy.
Them would be people who are falling out of status, maybe people who are, you know, I mean, I think I was sorry, my audio, I was muted, but I was saying, very well put. And I think, yes, very surely that the worst are going to go out of the country first. But following them could be, people who are going, maybe getting out of status, people who have overstayed, people who, they really need to get their visa aligned with their status, right? They have to be in status to be able to be there. And another thing which I wanted to ask is, Chand, you have mentioned about the fear of being caught, if you are illegal in the country, and even more that you are a criminal. I mean, Trump or no Trump, right? Wasn't that fear always there? Like, what if somebody catches that I am out of status? Didn't they have this fear already?
Yeah, I think, I mean, we have not seen ICE raids and these kinds of stuff on a large scale previously. And now what's happening is, I think there's a lot of rhetoric in the media. And not only that, all of a sudden, like somebody's putting a post in the social media saying like there was this raid, that raid. Some of it is true, some of it is false. So I think the fear was always there, but I think illegally. Um, I think I mean, it's a little different because people who are into the country in a legal fashion, what happens is they
Yes.
have an I-94. They know how long they're supposed to stay. They know that before that day they're supposed to apply for an extension. So there is a
Mhm.
process. And those people, because I mean, they've given their fingerprints at the port of entry, so a lot of it is trackable. And for the people who have slipped into the country without any kind of inspection, it's a little different because the country probably a lot of them they're not even recorded. Their information is not even recorded. So I think
Yes.
there's a little bit of difference between these two sets of people who came with inspection and who did not come with inspection. So people who
Yes.
came into the country with inspection, typically they have the record out there because uh, there are fingerprints with CBP, there are fingerprints with the federal government, and so on.
Mhm.
So it's a little bit of different, and I think the people who are in the country illegally, who don't have any record, because nobody even knows where they are unless somebody has done some criminal act and there is some record somewhere. If not, it's a little bit of challenging effort, which is what I think the government is trying to do. I think they're trying to kind of at least figure out initially as a priority people with criminal
Mhm.
backgrounds.
Yes. 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 Absolutely. Thank you so much, Chand, for that, detailed explanation. And I have more questions. So, but before I think we move on to our questions, I wanted to take up this question we received on, I think, WhatsApp. If Control can put it up, it's from Megha, if I'm not mistaken. Yes, Megha. So it's a WhatsApp question. So Megha is asking, "Hello everyone. I need to ask a question. I am on day one, I think D1 CPT, but I need to go to India for family emergency. I'm planning to come on H4. So, do you think is there any possibility to get my visa rejected, my H4 visa, as I am on day one CPT? Really appreciate it."
Sure. I think in general, when somebody has a valid visa and they're entering into the country on that valid visa, on the terms of that visa, and they have not violated their status in the past, usually they should not have a problem. Again, the entry is never 100% guaranteed. That being said, uh, usually they are not going to have a problem. So if somebody is coming on H4 to be as a dependent, they should, and their goal is to be uh, living in the country as a spouse of some H1B holder, they should not have a risk. And even if somebody has taken day one CPT, as long as they have uh, properly been admitted to that school, they have actually studied in that school, attended classes, and taken the CPT program in a legal way, going through the school DSO and all those things, they should not have any problem. So CPT by itself is not illegal. The only thing is CPT has a lot of requirements that they're supposed to keep and maintain F1 status. And as long as somebody is going through the process and properly maintaining a valid F1 status and properly working on CPT, their future entries should not be impacted. So if somebody wants to come back on H4, I don't see it as a problem. Usually, you should not have any issue. And people do it all the time. I mean, somebody's on F1, they get married, they go to the country, they come back on a different visa, in this case, H4. So I don't expect issues. That being said, uh, an entry is never 100% guaranteed, so you can always expect questions at CBP. That being said, legally, it is totally allowed, and people should not have any issues coming back on H4.
All right. Thank you so much. Thank you, Megha, for participating. And my WhatsApp number, I think I will just say so that people out there, can even call me there, or better just message me also. My phone number is 408-335-6444. So please feel free to join me there as well. Otherwise, the number is 425-436-6335, and the access code is 988-888. So, yes, that was Megha's question on WhatsApp. Thank you so much. So, now, Chand, I would really like to know, what challenges do you think individuals and families are facing, after deportation under stricter and even these sudden immigration rules?
I think the immediate and the devastating challenge is getting separated from the family members, because I think sometimes when uh, they have a family here, one of them is illegal, one of them is legal, for example, and they get deported. I think the fact that they're going to be separated from their family, I think that separation, I think is going to be huge, and not only emotional and psychological trauma for that individual, but also for the entire family members. So that is like the biggest thing. And then the financial hardship, because somebody who's working is leaving and they cannot work. So if part of the family is like back in US, and that somebody has to leave the country or deported, I think definitely that financial hardship is a problem. And then I think another thing a lot of people are talking about is reintegrating into the home country. So if somebody has been in this country for a long time, and now they're deported back to their home country, so the whole thing about um, reintegrating in the home country, I think it is going to be difficult. And because there are going to be cultural barriers now, again, going back and all those things. So it is going to exacerbate, I mean, it is going to like increase their struggle. And so we don't know. I mean, again, there are more than 10 million illegal people in the country, and I definitely don't think that everybody is going to be deported back because of practical obstacles and the realistic way of looking at things. But I think the last count I heard was about 5,000 people uh, are being deported, are caught so far in the last a week or so. So I think I don't really think it'll be like millions and millions of people at this point of time. So that being said, I think whoever are impacted, I think are going to face a lot of obstacles, and uh, I think there is going to be an impact on children, especially if they have children, and a lot of emotional and mental health struggles for those folks. So, and that is why I think the one thing is I think yes, people have broken a law, but I think what normally people expect is the federal government is a little bit more shows a little bit more empathy and kind of focuses on people with real criminal backgrounds, not just go after everybody like immediately, but
Mhm.
at least immediately, I think kind of show some empathy to most of the normal people. Maybe just target people with huge criminal backgrounds, at least initially.
Yes, yes. And also with regard to birthright citizenship, right? I mean, there was that whole news, and though it's on hold right now, I think people are very much still worried, anxious as in what's going to happen. So I'd really, say to folks out there, stay strong.
Yeah.
And if you are abiding by the rules, there's nothing to be afraid of. Right, Chan?
Yeah, birthright citizenship, I don't think it'll pass because
Yes.
we have this constitutional amendment that is out there from 1868, and we
Right.
also had the Supreme Court deal with this issue in 1898, a long time back. So the case is properly decided. So I don't think the courts will do anything different. And I
Mhm.
think the only way to do that is through a constitutional amendment, and that's the only legal way to do it. And again, a constitutional amendment is not easy. It requires like a whole big process. The states have to agree, the Senate has to agree, the House of Representatives has to agree. So there's a whole big process. So for all practical
Mhm.
purposes, I don't think it is happening anytime soon. But as far as the courts are concerned, they have a temporary restraining order. They have not given a long-term injunction, but temporary orders are passed. And even if it
Yes.
goes to the appeals court down the line, even if it goes to the Supreme Court down the line, I don't think the courts will do anything different because we have a legal precedent in the United States. It's already decided by the courts previously. So I'm a little
Mhm.
skeptical that the courts will even interfere. I think the burden will fall back on the Congress and the states to pass a constitutional amendment. If that passes, yes, it is possible. But for that to pass, I don't think there is a easy route to that.
So that is at least one good news, I think, a little relaxing and hopeful. So, folks out there, I think, yes, that's some good news for you. So, if you want to actually have a one-on-one consultation with Attorney Chand Parvathaneni, you can even call him up or email him about yourself, your status, and it's always best to consult with an expert, an attorney who's going to be able to guide you best with your immigration status. So his phone number is 817-523-8247. And you can email Attorney Chand Parvathaneni by emailing him at law@spblawfirm.com. And go visit www.spblawfirm.com to get to know more Attorney Chand Parvathaneni and Sim Parvathaneni and Brown Law Firm in Dallas, Texas. So, yes, those were a few updates, and it's been a great session so far. We also have Nilanjana join us. So, Nilanjana, just stay with us. We will take up your questions a little later in the show. So, now, though, we should quickly take up another WhatsApp message which we had received, and this is from Kakoli. Hello, I have a B1 visa applied by my current employer, Amazon. Now I would like to visit my family in USA for a small party. Can I use the same visa to enter? If so, what documents do I need to carry with me?
So one of the things that will happen, even if one has a visa, is at the port of entry. So whenever somebody lands in United States, they have to go through CBP inspection. And one of the things that the CBP is going to do is ask questions and see what somebody's intent is. And if somebody's intent is not matching the terms of that visa, they might have a problem. So in general, if somebody has a tourist visa and they go for tourist reasons, they should not have a problem as long as the intent is disclosed and the officer is okay. So in this case, if it is a business visa and somebody is going on tourist purposes, again, in the current way of doing things, because now rules have changed a little bit and now things are looked at a different way. So so the entry is at the discretion of the CBP officer. So what they're saying is admission into United States. It's a privilege. It's not a right just because somebody has a visa. That's the way of looking at the current uh, the way of looking at things. So what that means is at the end of the day, it is that the CBP officer, and if CBP officer feels that somebody is not doing something that is a requirement of that visa class, they could deny entry. So just having a visa is not enough. The actual the entry and the intent and the purpose should match the purpose of that visa class.
There you go, Kakoli. You have your answer. And always consult an attorney. So we have Attorney Chan's contact details scrolling on the screen. You may note it down and contact him as well for further details. And for now, Chand, we also have a lot of industries like farming, manufacturing, IT also. They are all being affected by this mass deportation policies. So, what do you have to say about the impact on these and also the target immigrant workers?
Sure. So I think every industry is different because in the United States, when we take a look at IT sector versus a farming sector, you're going to see uh, completely a different impact based on the current rules. Because if you look at the current the policies, so President Trump last week, even after his swearing-in ceremony, he stated that he likes H1Bs. He clearly stated that the country needs H1B, and what that means is so when you look at the IT industry is heavily staffed by people from other countries. A lot of Indians work in IT. So IT by nature of the industry heavily depends on H1B employees, probably also L1 employees, probably also O1 employees. So IT sector typically does not have a lot of people who are illegal working in the industry by the nature of the industry. And to me, based on the current news that is coming out of the Trump's administration, his advisors, there might be scrutiny on H1Bs, but they have no intention of completely removing H1B. So sectors like IT, I don't think they will see a lot of impact. The reason being, people already there is a process for the H1Bs, and the industry is not heavily staffed by people without a legal status. On the other hand, when you look at farming depends a lot on immigrant labor, and a lot of them are undocumented workers. So things like harvesting, planting, packaging, these kind of industries, they have hired a lot of undocumented workers. And the current administration, they're focusing more on undocumented workers, people who are in the country illegally. So these are low wage positions, and these are positions that a lot of US citizens are not willing to fill. This low wage agricultural jobs. And when we're seeing mass deportations typically happen in these kind of fields. So I do think that you will see a labor shortage if mass deportation continues for a long period of time, and we might see labor shortage in, say, farming industry, or probably some areas of manufacturing industry. But on the IT sector, I don't think we will see a major impact. Uh, but what we will see in IT sector is a lot of people, they're seeing wrong news in the social media. So they are probably going to be so scared. They probably are going to see this as something that is very scary. Like they probably will think that, is it even worth going to US and working in IT sector? So what I see is, if the rhetoric is bad and if the media projects these deportations in a wrong way, the foreign talented foreign workers more than likely will be deterred into coming into US in the first place, and that would definitely stifle growth and innovation in the tech industry. So I think in general, I don't think we should see an impact in the IT industry for people who are already in the country, but people who want to come to US to work in IT industry, highly talented people, those people might be second guessing in immigrating to United States. So we will have to wait and watch and see how this rhetoric continues and so on. But I do see this risk that some people will be hesitant to immigrate to United States.
That is very much happening. I think people out there are probably looking out for more options because they wouldn't want to go to the US and then know the next thing that they cannot stay there anymore. It's going to be very, very expensive for them, right? So yes, moving on, since they're all facing individuals, I mean, individuals or families are facing all these sorts of deportation or are on the verge of facing one. What options do you think are available for them, under these new plans? Maybe you can keep it short and just give them some points what they can do, Chan.
Yeah. So I think people who are in the country, anybody who's especially who are in the country through a legal process, like showing a visa, what everybody should do is they should take a look at their I-94, and they have to make sure they file an extension before their I-94 expires. That is very important. So that is the first thing that anybody in the country who is in a legal status should do. The reason is if somebody accidentally forgets to file for an extension before their I-94 expires, they will become illegal in the country. So that is one thing that people can do to ensure that they don't even have to go through this deportation mess. That's the first thing. And for other people, they might look at temporary protected status. Some countries, some individuals from some specific countries, they get this thing called temporary protected status. So one of the things that people can do is see if their country is designated as a TPS country. If so, they might get some relief. And right now, DACA, Deferred Action for Childhood Arrivals. So people who qualify under DACA, they have temporary relief. So they probably will not be deported right now. So anybody that is eligible under DACA, they can use that as relief. And some people who are inadmissible, they might be eligible for some waivers. So one of the things that people who are subject to deportation should do is see if they're eligible for any waiver. Waivers are extremely difficult, but under compelling circumstances, some people might be able to get a potential path. So that is one way. And another way is if somebody has a US citizen spouse, they might they might be able to apply for adjustment of status. Again, everybody's case is different, but one of the things that people can explore. And asylum, again, asylum is a program that sometimes people tend to misuse, but again, there are some people who genuinely will qualify for asylum. So that's another thing that people can take a look and see if they qualify for asylum. And asylum is only limited to people who fear persecution in their home countries due to some specific factors. So those people are allowed to file an asylum application, but there is a very strict process. So again, something for people to explore based on their scenario. So these are a couple of things that people can always explore, and then see if they come under any of these circumstances.
Thank you, Chand. Thank you. Those were very important points, and I hope that people out there, you heard what Chand has said and have noted down, and will look out for your options. Quickly, I will take up Suresh Kumar's comment on YouTube, and then we can take up some more of the other comments as well. So Suresh is asking, according to the new provision of H1B, I can start my entrepreneurship. What would you like to say on that?
Yeah. So I think that's a great feature that a lot of folks out there should explore. And this new rule that just got into effect since January 18th, what it says is if somebody starts their own company, they own 100% stake in the company. Those people can have that entity, the entity that uh, they started. That entity can sponsor them. So it's like I'm an entrepreneur. I started my own company. Now the rules allow that company to sponsor your own H1B. The only thing is your initial visa validity will be only for 18 months, but that's still a good option. And you still have to pay yourself. So the company will still have to pay you. You still have to demonstrate how the company will have money to pay you, and what your idea is, what your company is, and all those things. But at least now we have a pathway. So for a lot of folks out there who are budding entrepreneurs who are starting their own companies, you should explore this option. And legally now it is possible, and you will be able to file for a H1B. And if you're able to convince USCIS that this is a legitimate company, that it has a proper business plan, that it has the ability to pay you the salary, because the salary does have to meet the LCA obligations. If you're able to do it, you should be able to get this H1B. And it's a very new thing. It just started on January 18th. So something out there that everybody who has a very good business idea, who have started their company, they should start exploring this option.
Wonderful. Thank you so much, Suresh, for joining us here on YouTube. And you can also join us on call. The number is on the screen. And yes, to know more, maybe you can even contact Attorney Chand Parvataneni. His details are scrolling on the screen below. So, Chand, we also have some questions from our Facebook group, so we would quickly like to address them as well. And when we have more time later, we can come back to our questions. So, Control, if you can display, yes. The first question we have is how many months it takes for I-797 approval for H-1B visa extension?
So when we talk about H1B visa, we have multiple service centers. We have California Service Center, Nebraska Service Center, Vermont Service Center, and Texas Service Center that are currently handling H1Bs. And what we are seeing is it is taking anywhere between 1 month to 6 months for majority of the cases to be adjudicated. And you're going to see this little bit of variation because it depends on which service center your case is, which officer is looking at your case, and so on. But starting from a month, we are seeing approvals or adjudications. And normally, what we suggest is if it is taking more than 6 months, maybe it's time where you explore the premium processing. And the rule for extensions is that once a company applies for an extension, there is something called a 240-day rule. So for a 240 days after your H1B expires, you are allowed to work in the country. Your I-94 automatically gets extended to a max of 240 days. So theoretically, even if your case is still pending, you can work for a maximum of 240 days when your H1B extension is filed. So normally what I suggest is wait up to 6 months. If it takes longer than that, don't wait until the 240 days, but right after 6 months, try to upgrade your case. So you definitely have an answer before your 240-day deadline is over.
Thank you so much, Chand, for taking that up. And I'm sure that was very helpful. And going on, let's move on to our next one. This is from an anonymous member in our group asking approved I 140 for H1B EB1C. PD is not current. Can I switch company?
So, so because the priority date is not current, you cannot file the 485. And what that means is if you switch your company, the new company will again have to do the EB, the I-140 once again. The only thing is when the new company does the I-140, you can recapture your previous priority date. But in terms of applying for a green card, if the prior company where you have the I-140, if that company withdraws the I-140, you might not be able to file the 485. So if you want to do the 485, eventually you will need another I-140 approval. The only good thing is that you can recapture your previous priority date. So remember that one thing, if you do switch, the new company will have to do an I-140. You can still get the old date back, but without the new I-140, the new company will not be able to sponsor your 485 and sign off on the supplement J.
Very important. Thank you so much, Chand, for highlighting those very important points. And thank you, anonymous member, for participating by commenting in our groups. So, folks, we are on YouTube, LinkedIn, Facebook, and on X. Our handle is Immigration and Jobs Talk Show. Please feel free to connect with us, join us by commenting, follow us, and yes, participate. Thank you so much. Let's go on to our next one. And this one is how many days is premium processing for H1B transfer taking after January 18th executive orders? I know they don't impact directly, but I'm concerned because I am due for a travel to my home country. Any leads will be very helpful. Thank you.
So our office, we had a couple of cases filed after January 18th, and we got approvals for a few, and for a few they're still pending. So from a legal standpoint, it is 15 business days. So anytime now you should see some answer, but they can take up to 15 days. So every case is different. We've got a few approvals, few are still pending.
There you go. But do you suggest premium processing though than the regular ones?
At this point of time, I would say that premium processing is probably a good idea because there is so much of rhetoric out there and people are getting scared. So it's one thing out of the way. So you do a premium processing and the case is adjudicated. It's one less thing to think about. And in this current scenario, the more you wait, the more somebody else is going to stress you. You're going to read news and so on. So the way I see it is, a premium processing is one way of getting peace of mind. It's very expensive process. You have to pay government a lot of fees. It is $2,805 to the government. It's a lot of money, but again, uh, to a lot of folks out there who think that they're restless because of all this news out there, I do not see any problem. We're not seeing any bad uh, adjudications or policies being changed. So we're still seeing approvals even in the last 8 9 days, and even the RFEs that we're seeing, they seem to be the standard kind of RFEs that USCIS typically asks, because there are certain things that even USCIS has to follow. So other than the regular issues that they are raising, we're not seeing anything majorly different so far. So if anybody has a pending case out there, I definitely suggest getting it done in premium and getting it out of the way.
Thank you so much, Chand. Thank you for taking that up. And now let's go on to our next question. And this is also on our Facebook from another anonymous member saying, "Hi, my mother and mother in law both are coming to Chicago as my wife will be giving birth. I did a one-way ticket for them as we didn't know if they can or could not stay for 6 months or how long they can stay. Is it necessary to have a return ticket? Will they have issue at port of entry? If yes, is there a way to get fully refundable tickets that I can cancel as we are not sure about the return dates?"
So one of the things is, the port of entry. Definitely, the office is going to question them on their intent and what they want to do, and what their goals are. And this is what I see. If somebody's intent is not to stay temporarily and leave the country within their allocated time, which is usually 6 months, I can see the officer trying to cause an issue. And in this case, if somebody's intent is to stay longer for more than 6 months, more than likely the officer could cause an issue. And this rule, like the return ticket rule, it is never a written rule, but it's always been there, because I've always seen the officers ask about a written ticket, even prior to President Trump's January 20th swearing in. So this rule was always there, that the officers can check and see what's going on, and if they suspect that somebody's intent is not to leave the country in about 6 months, more than likely they will cause an issue. And we are hearing about people being sent back. So something I think everybody should be cautious about. The intent should be for a temporary purpose, and if you're not able to demonstrate that, a written ticket is one way to demonstrate your intent, what exactly your goal is. If not, the first thing that the officer is going to think is that yes, you don't intend to leave the country in about 6 months, which means you are a high risk candidate to be sent back.
So true, so true. And we even heard the news a few days back about an Indian couple, old couple actually. They were going to go visit their kids in the United States, but because they did not have a return ticket, they were sent back. And it was very harsh and unexpected. So,
Yeah.
I mean, to avoid all of
Yeah, and
that,
I think this rule was always there. Yeah, because this rule was always there, because I've seen this issue pop up a lot of times. It is just that it got highlighted recently. The reason is because of all this immigration rhetoric, that thing got highlighted.
yes.
Even before, the officers were like heavily scrutinizing this aspect, because what has happened is, during COVID time, a lot of people came into the country and filed for extensions. During COVID time, yes, they had a valid reason. And after that, I've seen a lot of people come into the country and apply for extensions after 6 months. They're seeing more and more of those situations. So for that reason, I think the scrutiny in general is that they want to make sure somebody is leaving the country uh, in a short time. And short time for them is less than 6 months. So the scrutiny is there. Not only that, another thing that people are going to have a problem with is if they leave the country and try to re-enter the country on a tourist visa immediately. So they left the country, and in less than 6 months somebody's trying to get back into the country. Even those cases, we expect to see issues, some people being sent back. So I think, as a good practice, a written ticket is important. And also, um, don't come into the country too often. So, which means that at least keep 6 months of gap between entry to entry. Otherwise, somebody is going to argue that you're misusing your tourist visa and probably cancel the visa or send you back.
Thank you so much, Chant, for taking that up. And those were great details that we really need to keep in mind. Thank you, anonymous member. And let's go on to our next question. So this one is hi, my visa will expire in February this year. Extension is in process since last 3 months with no status change. I don't expect to get the renewal by Feb looking at the current trend. My question is how people manage without driver's license. There are tons of things we need a car for here in America, and without availability to drive would greatly impact the day-to-day activities. Is there any alternatives apart from under and carpool? Is there any consideration by authorities?
Um, Again, so driver's license is like a local state thing. So every state is different. And what we are saying is some states, you take a receipt copy and show that your H1B extension has already been filed. We are seeing some states issue temporary licenses based on that receipt copy for your extension. Some states are refusing. And I think what I suggest is uh, the premium processing. It costs about 2,805. So look at that cost versus carpooling or going in Uber and all those things. And if you feel that premium processing is going to be cheaper, I definitely suggest getting the case upgraded to premium, so you can get an answer quickly and then not have to worry. But before doing that, go to your local state's DPS office and see if they can use your receipt copy and give you an extension. Some states are doing it based on that extension receipt. They're getting a short-term extension. So that is the first thing probably you can try. And if they still refuse, the other option is probably go back to your employer and insist on premium processing. And that is probably the fastest way to get your approval and then get your
Yes,
license.
and I think you would also know your status with premium processing. It only takes about 15 days or so, right, Chand? So, yeah, so yes,
Uh, so the bad thing is it used to be 15 days until
okay,
April 1st last year. Starting from April 1st, now it is 15 business days. So not calendar
business
days, but it is
days.
business days. So they changed it a little bit
Thank you
last
so
year.
much, Chand. I mean, another point to keep in mind, folks. So 15 business days. Thank you. And I think with that, we have completed our Facebook group questions. And I have a few more questions, Chan. So if you don't mind, telling us, what should employers also
Hmm?
know about compliance and risks while hiring immigrant workers during these changing times?
Sure. Uh, so one of the things we hear about is the illegal immigrants being deported. But what's also going to happen is any employer who knowingly hires somebody who's not legal, I do expect criminal penalties for them. Some at least some penalties, maybe even criminal penalties for them, depending on how they're hiring people they know that are not legal in the country. What that means is every employer should follow the process. There is something called I-9. I-9 is a mandatory thing uh, for every employer like Microsoft, Google, or even a small consulting company. It doesn't matter. Every company that hires employees, citizens or immigrants, they are supposed to do and verify the I-9. So I-9 is very important. So what we suggest is every employer should be completely complying with the I-9 provisions. Make sure they have an I-9. Make sure they check the status before hiring somebody. If they don't do it, more than likely they will be at risk. If there is an audit down the line, or DOL visit, or a USCIS visit, or an ICE visit, they will be in risk. And sometimes, if the employee does something wrong, gives them a fake document, it's a different issue. But knowingly, if they hire somebody who's illegal, it's going to be a upfront. They are liable for major issues. So the good practice for every employer is adhere to the I-9 provisions, and as long as you keep doing it, you're relatively going to be safe. At least the government is not going to come after you.
Well, there you go. Thank you so much, Chand. And my next question is about these international agreements that are happening. With Trump putting up executive orders and so many changes, tariffs going high for different countries. So, how do these international agreements, such as between U.S. and Colombia, affect immigration enforcement and even employment policies?
Yeah. So one of the things is for people who are in the country illegally, I think the administration has already stated that they're going to start sending them back to their home country. And we have few countries who cause a problem. For example, China. China, I think, normally doesn't take people back that easily. So I think what President Trump is trying to do is trying to work with all the governments and trying to make sure that they take their citizens back. And some countries are agreeing because I think some countries see that as their moral obligation. It is somebody, the citizen of their country, they see it as their moral obligation. They're ready to take them back. For example, if you see India, India clearly stated that yes, they're going to take back their citizens once verified into their country. So most of the countries in general, what I am seeing is they are willing to take their citizens back. Some countries, I think, are trying to cause a problem. And last week we saw this news about Colombia. So Colombia initially stated that they don't want to take their citizens back. I think then the administration, I think, put some pressure and they try to put some visa bans and other steps to pressurize them. And at this point of time, looks like Colombia, they agreed. And not only that, they did say that just don't do it in military planes, but as long as it is civilian planes, do it in a decent manner, we will take them back. So it looks like that issue is resolved. And that is what's going to keep on happening. What's going to happen is the administration is going to try to work with all these foreign governments to make sure that there is an agreement and people are sent back and those countries accept them back, which is what I think we will keep seeing in the future. And majority of the countries seem to be willing to take their citizens back.
So true. And we are seeing, many countries, even India is one of the major ones who are, joining hands in this deportation process. So, let's wait and see. We really need to keep, illegal immigrants aside and economic policies, on the other hand, totally different. So, yes, thank you so much, Chand. And I also got a couple more questions if you still got some time to be with us, if that's fine with you. Okay.
Sure, sure. Yeah.
So, my next question is, you as an immigration attorney, and I'm sure many folks out there, your colleagues as well at SPP law firm, and there are so many community groups also. Maybe you can tell us what are you doing, or how can, attorneys like you or community groups help individuals prepare for potential deportations that are happening and the changes in their legal status.
Sure. I think we get a lot of questions, and I think my practice is a lot on the employment side. And I work with a lot of employers, and the main cases that we see are like people who are wanting to work in this country on H1B, or somebody who's a student on F1 trying to work on H1B, and so on. And what I see is, unfortunately, most of the people, they're highly qualified, but what they try to do is sometimes they don't follow the rules. They don't comply with the immigration rules. So what we try to do is we try to educate people and talk about compliance. And because we don't want somebody to be in that situation where they are scared to be deported. I think our goal is to educate people so they're not even in that situation where they will have that risk of getting deported. And what that means is making sure you're always maintaining valid status in the country. So every visa class will have a set of rules. Always adhere to those rules. For example, if somebody is a student, the typical issues lately that we've been seeing is people are doing some part-time jobs. These students, they're like, for example, master's students. They already have a very good education. They're getting a master's degree. They are going to be highly skilled down the line once they get their degrees. So we don't want them to do anything that will jeopardize their career. And what that means is we discourage people from doing unauthorized employment. We discourage people from working in restaurants or working in the jobs because it is short term. Very soon they'll graduate. Very soon they'll have such a good career. Now, doing these kind of things, now they are stressed on what's going to happen and all these things. So rather to be in a situation where somebody is doing unauthorized employment or doing anything that is against the regulations, I think our goal is to educate people, let people be aware of the rules. We encourage people to uh, go through USCIS website and keep following up the regulations to ensure they are not even accidentally not complying with anything. And one of the things that a lot of people we have been seeing is lot of people on H4 or sometimes even on H1B, they forget to check their I-94 every time they enter the country. Everybody is supposed to download their I-94 and look at the I-94 end date. Sometimes people don't see it. They assume that they can stay in the country until their visa is valid. Sometimes their I-94 is shortened for various reasons. Maybe their passport is expiring. And by the time they come to us, what happens is they're already they are out of status. So at least our work is heavily involved in educating people to make sure they are able to figure out their status, figure out their identity for end dates, and do these extensions, do these things that they're supposed to follow before they go out of status. So our focus is entirely on how do you maintain your status, how do you do things that are compliant with the law, and at the same time we also want to make sure that people, sometimes what happens is on the social media they get scared with things that are not true. Yes, there is a problem, but not on such a large scale where people have to be worried, because we've been getting calls this week, and one of the questions was, is everybody getting deported back who's on F1 and traveling out of the country on OPT? Things are not that bad. It's just that there is scrutiny, and their goal is, if somebody is following the rules, they will not have a problem. So things are not bad, or things are not anything where people have to really worry. It is just that there is going to be scrutiny, and what that means is, watch out what you're doing, watch out what you're doing on the social media. um, uh, Always follow the law. Don't drink and drive. Don't steal in the departmental stores, because we had some cases where somebody got drunk, drove, got caught. Now they have a big mess, because now they have a big RFE and all those things. So it's more about things that you can easily avoid, because uh, half of the problem is people accidentally getting into some issues that they don't really have any intent. So at least a lot of things can be avoided by getting properly educated
Yes.
about the rules, and that's the goal. Doing so, I think you will keep yourself safe, because if you don't break the rules, nobody can even touch you, because this country follows due process. Due process works as long as you follow the process. You break the law, that is when you can't really use due process, because uh, the rules
Right, right.
say
Very
something.
well put, Chand, and thank you so much for that. And I'm sure that folks out there are able to take notes down, because these are very important points. And you are educated, you know what you're doing, and just don't act stupid. Don't do things that will make you fall in trouble. And with that said, Chand, we have a caller actually. She's online, and she's Satya. And Satya, please go ahead. Tell us, where have you joined us from, and ask your question.
Yeah, sure. Thank you. Hi, Chandra. This is Satya here. I'm calling from Michigan. I have a quick question currently. I'm on my OPT. Initial OPT is going to be closed. But the question was a bit different. So I came to US in the year 2022 August. And initially when I entered, while filling my DS 160, from 2015 to 17, I did my master's in India, but I did not mention that while filling my DS 160. In the place of 15, 17, I kept it that I have already working in some company since 2015. Now, like my current company informed that they wanted to make me as a full-time employee for them. So now the question is, because in future, if my H1 got picked up and if I wanted to, go for stamping while filling the DS 160, so do I need to mention everywhere that I did my MBA in past, or I should completely remove that? So I don't know this. So I just have a question on this.
Sure. Sure. Uh, and I think from immigration perspective, if that omission was material to your visa, it could cause a problem. But I don't think it is material, because I don't really think you gain any advantage by omitting that information. That being said, I think what you should do is, at the next given chance, you should correct it. And what that means is, eventually when you go back to India, and you're going to apply for your H1B, definitely put that information on your DS 160, because that is your chance to correct. If you correct something before they catch you, you should probably not have any issue, because this is such a simple thing and it is not really material to your case. So that accidental mistake that you did, next time correct it. Make sure the next time you do the DS 160, correct it. Okay, and put it. And if somebody has a question, you can answer it. And if they don't even question you, you pretty much disclosed it to them. Okay, so at next given chance, definitely disclose it, and I think you'll be fine, because I don't really think it is a material issue to
But I
your
cannot change the past
class.
one, right? I can't change the past one. But I have to accept that it
Um,
was done by all of a mistake, but it's a typo mistake, right?
right, because one time you make a mistake, that's okay. But again, the next subsequent chance that you have, where you will be able to correct it, you should correct it, because you don't want somebody to say that you misrepresented it even after knowing about it. Now that you know about it, I think put on your DS 160. I don't think it is material. I mean, you did not gain any advantage with your admission by omitting that information. Say, for example, you put fake experience, and because of fake experience, they thought you're qualified and gave you the visa. Then I see a problem. Yeah, so I don't think it is material, whatever that omission was. But again, definitely, I think next time, definitely include that on your DS 160. So nobody's talking about any kind of a misrepresentation in the future.
Yeah, got it. Yeah, but yeah, I got you. Yeah.
Okay, so Satya, is that all? Or if you have any other question, you can go ahead. Otherwise, thank you so much for joining us from
Yeah,
Michigan.
that's, yeah, thank you.
Thank you. Thank you. Please don't forget to like, share, and subscribe to us. And folks out there, you can also join us on call. And our phone number is 425-436-6335, and the access code is 988-888. I think with that said, we should wrap up our show for today, Chand, and maybe leave our folks out there with what strategies that immigrant workers or immigrants they can adopt to stay safe and compliant with all these. The existing law, and the changes as well.
I think the main thing is, again, ensuring that you don't overstay your visa. And again, if somebody has overstayed their visa or did something, there are potential waivers that some people could be qualified. So at least, even if somebody is in not in status, try to kind of at least make sure you do something to proactively uh, get some relief under the current regulations, but don't just not do anything. So if you accidentally did some mistake, try to kind of figure out a way and see if you can get some relief using the existing regulations, and follow the law. And for everybody else who is in a legal status, make sure you accidentally don't do anything to jeopardize your legal status, and keep following the rules, keep applying for extensions on a timely manner, because if you miss filing for extensions on a timely manner, you will jeopardize your legal status and future entry into the country. So just try to be compliant and don't do anything very stupid, because things are like, some things are like very it is like just common sense things, like should you work uh, illegally, like off campus, things like can you work for some employer for cash illegally. So these kind of things, some things are common sense. So just I think try not to kind of do anything that is going to jeopardize your legal status in this country. And I think people who are actually following the rules, I don't think the administration is probably doing anything drastic. I think they're only talking about people who came into the country in an illegal way, and again focusing on those who typically have criminal records. I think if people don't have criminal records in general, I don't think they should have a lot of issues. So people who are currently in the country, make sure you even accidentally don't do anything that could have criminal implications. And to me, that means speeding, DUI, theft, hitting your spouse, hitting your girlfriend, because even those things are big issues. Anything that is illegal, stay away from it. And I think that should kind of safeguard everybody's status.
Absolutely. And these are all very easily avoidable things. So, folks out there, play safe, stay safe. And thank you so much, Chand, for joining us on this amazing, insightful session. So much you have shared with us. The knowledge imparted, I'm sure, has helped everybody who joined us today. And really great to have you. I'm looking forward for February for another great session with you. So soon we are saying bye to January. So really great that you joined us today, Chand, and I'm hoping to see you soon.
Yeah. Thank you, Dipasa. Thank you all.
Thank you, friends, and thank you so much for joining us. Don't forget to like, share, and subscribe to us. We are Immigration and Jobs Talk Show, and folks out there, who got your answer. And Satya, thank you so much for joining us on call from Michigan. All the best for your future endeavors, and yes. To all you folks out there, stay tuned to Immigration and Jobs Talk Show, because we got a lot more content coming up, and we also got daily immigration dose that's coming up at 4 p.m. Eastern Time. And yes, it's Nipasa saying bye for now, and Chand also saying bye and thank you, everyone. Hello, everyone, and welcome back to another episode on Immigration and Jobs Talk Show. I'm your host, Napasa Pradhan, and today we will be diving into another very critical topic, a pressing issue, a very timely one as well. And before I tell you what the topic is and who our guest is going to be for our webinar today, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks out there, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, X, and it's really amazing to have you. And good thing is that you can also participate by commenting wherever you're watching us. And yes, join us on YouTube, will be great. But other than all these platforms, you can also join us on call. And for that, you will have to dial this phone number that's displayed on the screen above, 425-436-6335, and the access code is 988-888. So join us, friends. And today's topic of discussion is how is ICE's crackdown impacting immigrant communities across the US? So yes, with all the news that's we are bombarded with right now, increased enforcement actions, deportation, workplace raids, school raids, so many in the list, right? And they're all making headlines. Many immigrants, both documented and undocumented, they're all facing new challenges, and families are also being separated, businesses are struggling, students are struggling, and the fear is growing in so many communities out there. So to help us break down this very interesting and a very timely topic, especially on what's happening, what's going on, what rights individuals have, and what to expect moving forward here on. So we have a very special guest who's going to join us once again, and he is Attorney Justin Rivera from Wasden Immigration Litigation, a very experienced immigration attorney. So please help me welcome him. Hi, Justin, and thank you so much for joining us today.
Hey, yeah, thanks for having me. It's always nice to be on, especially on a Friday. So thank you, I appreciate it.
Thank you. I'm looking forward. I know Fridays are supposed to be fun ones, especially that weekends are coming in, but our topic is such a serious one, and
Mhm.
all the dark times, I would say. So what can folks out there expect from today's discussion?
So yeah, I think I will preface this by saying, Wasden LLC, particularly, we work with people on business immigration visas, work visas, things of that nature. So this is a little bit outside of my scope, a little bit outside my wheelhouse, but I think that after doing some research, I think I can provide at least an outline, a basic understanding of kind of what's going on right now, what is anticipated to occur, and kind of a little bit more about what this impact is going to be on not only people that are undocumented, but even people that are here in a legal status. So that'll hopefully I can shed light on that. There's a lot of great resources too that we'll try to highlight that are available to people as well.
Absolutely. I'm looking forward already. So, yes, we hear a lot of, things that you just shared before we started this webinar. We'll get into all that details as well. But I have some questions that I need to ask. And if we could start with, how has ICE's recent surge in deportation efforts, they have affected immigrant communities, particularly those without legal status. If you can
So,
highlight those, it would be very nice.
so yeah, I mean, anybody that's been watching the news has been aware of an increase in deportations and rates that is directly correlated to a change in administration. Where is that coming from? Basically, immigration officials are being given or have been given expanded enforcement discretion powers. So basically, they're being given a wider leash on what it is that they think, qualifies someone as deportable in this circumstance.
Mhm.
Before, under the Biden administration, there was a prioritization, obviously, of certain individuals, probably people that weren't conforming with requirements for check-ins, things of that nature, violent individuals, stuff like that. Now it seems that there has been a wider scope, a wider net that has been cast as to who qualifies under this deportable statute, who they believe needs to be prioritized for deportation. A big thing that I was noticing when I was looking into it was that there are a lot of individuals who they take place in what's called routine check-ins. So these are people who, their immigration status is suspect or they're undocumented, and a part of what they do to work with the government in an attempt to find a remedy is they routinely have check-ins with, ICE officials or immigration officials. Apparently, according to a couple different individuals, some people in Florida and other places, apparently some of those people are starting to get detained and deported. Now, that was not a prior practice, mainly because these are people who are conforming to the government's needs and actually providing an avenue for them to be tracked if needed, or provide additional information or documentation. These people were not prioritized, but at the end of the day, they are very easy people to deport to show increased deportation numbers. And what that has done is created a fear. There are presently about 1.4 million people who currently have pending deportation orders in the U.S. All of those people are obviously going to be targeted. And that can be, basically a circumstance where someone, if they're caught, they're done. They're being deported. I think there's going to be a growing call to have people under expedited removal at a higher rate. And what that basically means, expedited removal is removal without the need to go before an immigration judge. It's literally, you're put in, you're questioned, you sign the forms, and you're done. They put you on the plane to get you out. I think that's going to probably increase. And I really feel bad for the people who have been attempting to kind of follow the rules through this check-in process. And it's frustrating for those people because they're kind of caught in a catch-22. If they go to the check-in, then they're seemingly risking being in a circumstance where they could be, detained and deported. But if they don't go, they can also be placed into the deportation pool for non-compliance. So all of this obviously creates fear. It creates a circumstance where people don't know what to do or how they're supposed to behave or act, or what steps they're supposed to take. And I think that's kind of the point. I think that the point is to create chaos. And I think right now there's definitely been a lot of chaos created.
It is getting chaotic already, and we can see, so many people are already almost getting deported. Even Selena Gomez crying. Everybody is reacting to it.
I honestly can tell you personally, I have a story that I couldn't believe that I would have been talking about with people, but I'm going to tell you guys because it really happened to me. I got on a phone call on Wednesday with someone who called me because they're the younger brother of someone I know, someone I went to school with. And they called me because they needed to understand the I-485 adjustment process for people that marry a U.S. citizen. And the reason for that is because they had just found out that their girlfriend of 3 years, I believe, or 2.5, 3 years, had just been notified that their TPS status was going to expire. So this is, again, someone who's in the U.S. legally under temporary protective status. And this person's calling me frantically trying to figure it out, literally in the car driving to buy a wedding ring to expedite getting married so that he can ensure that this person can remain in the United States. That's the kind of chaos you're looking at right now. going after people that are on parole, going after people that are on temporary protected status, it would very much shock me to think that those are the kinds of people that this administration's supporters wanted removed. And yet, here we are.
That's right. And that is just one case. There are so many stories out there. And
Yeah.
folks, if you want to share any of your stories as well, you can by commenting or by joining us on call. And it'll be really nice to have even Justin, tell us what we should do next. And with all these, deportations happening, Justin, maybe if you could give out some tips, as in what are some of the legal protections available to immigrants who are facing this right now, the threat
Right.
of deportation by ICE in this current climate.
So I would definitely say work with a lawyer that's more qualified than me in this regard. I would definitely say that. I can't sit here and say that I am qualified to handle this kind of exact case. But what I can do is at least provide general information and what people's rights are and what they can and can't do. So I want to say right off the bat, to kind of get rid of any rumor mills with the internet are always compounded. Legal permanent residents are not at risk in these circumstances. So that's a rumor that I saw when I was looking around on the internet. No, you're an LPR, you're fine. People formerly on temporary protected status could be at risk, though. The idea promoted by the Trump administration was that people with criminal convictions, pending criminal cases, and people with final removal orders were going to be the prioritization. However, people with pending asylum or parole could honestly end up getting caught in this and getting arrested and eventually deported. Specifically, humanitarian parole. I believe it was recently ended for Cubans and a couple of other different countries. So what are kind of the rights of individuals? If it's a civil arrest, it's very complex. If it's a civil arrest, there's not necessarily a constitutional right to an attorney, but you do have a right to due process and a right to protection from self-incrimination. So what I'll explain by that is you have the right to remain silent, just like they tell you, on any law and order. You don't have to provide information. You don't have to give over anything. So in the event that you're detained, I would basically say, don't talk, or express that you have the right to remain silent. And then secondly, express a right or a need to speak to your attorney. There's minutia there, but for the most part, you should have access to that counsel. I think another important thing to talk about is an ICE warrant. So an ICE warrant is an administrative warrant. And what that means is it does not allow the executing officer to demand entry into someone's home or their private space. However, a judicial warrant does. That is a warrant where they have gone and got it signed by a court to carry out an action. Typically, ICE is not going to go through the process of getting a judicial warrant because of how timely it is. So, if someone's in a situation where they're dealing with an ICE officer that is at their door knocking, you can say under the Fourth Amendment, you are required to show me a judicial warrant before I'm obligated to grant entry into my home. And then you can have them slide a copy of that warrant either under the door or through the window. You don't have to open the door. So warrants are typically going to be needed to go into sensitive areas. And sensitive areas are usually places like homes, schools, churches, doctors' offices, maybe courthouses. Now, under the Biden administration, most of those sensitive areas were explicitly non-targeted areas. And the reason for that is you don't want people that are here undocumented to be afraid to take their child to the doctor's office if their child is sick because they're afraid of being deported. So the courthouse was another one, similar thing. Maybe a child support case, for example. You don't want them to be afraid to go to the courthouse to appear for a child support hearing because then it hurts the system. Because now, the person can't pay child support, they can't put an order, paternity, any of that kind of stuff. What is the impact of that with the present administration? We're not sure. I mean, they rescinded Biden's guidance essentially. Now, they've been talking about saying, well, we're clearly not going to do that stuff, but we just don't think it needs to be, affirmed in writing that we're not going to do that stuff. So take it with a grain of salt. But this all kind of gets back to the fear avenue, like the notion that like it's going to be difficult for people who are undocumented in particular to feel any level of comfort. It's scary for them. And I think that it's going to impact probably where they go, what they do, who they see, how they interact, because all of it's going to be suspect. They're going to be worried about the implications of the activity and whether or not ICE is going to be involved or even local law enforcement in some capacity. I think really for people just knowing that, and I'll talk about it a little bit more in further detail, but knowing, you don't have to talk. You can express that right. You don't have to say anything, and you can, express a desire for counsel would be my two big points.
Thank you so much. I mean, those were great tips, and folks out there, I hope you have noted that down. I mean, these are some of your rights. So I think it's always best to do more research and contact an expert, an attorney. They will be able to guide you best. And also, I mean, ICE, they're being joined forces by FBI, DEA, so many people out there. And Justin, what else do you have to say if you want to add more?
So for the local law enforcement, I think we were going to talk about it later, but I mean, we can talk about it now if you want. I wanted to do a little bit of diving into that and what role the local law enforcement is supposed to play in federal deportation actions. So there's this section of the INA that's called 287G. So under 287G, state and local law enforcement are permitted to question, arrest, and detain people for suspected immigration violations, and in very unique circumstances, place them into removal. But there is no power beyond that point. So what it kind of creates is, does that particular police unit or, like Harris County, for example, because I live in Texas, does Harris County want to cooperate with the federal government? Because if they do, they are not given additional resources because they basically are told, you're going to operate within the grounds of what we have within our budget. But if you're a state funded entity and your main issue is to deter criminal activity, it's kind of hard to say, well, we're going to now fill up, 30 or 40% of our jails with issues related to immigration violations, and then also any time that's spent dealing with that is taken away from the amount of time that they can spend dealing with with criminal violations. So I think it really just is going to turn on where in the country that police, those officers are situated and how willing their offices are to comply. Now, in circumstances where they're carrying out issues for criminal activity, I think you're going to see some hand holding because it makes sense. Hey, this person who has an immigration issue has also been convicted of a violent crime or, something of that nature. Then it makes sense for them to play ball. The idea of deputizing the state and local police to expressly look for immigration issues, I think might be more suspect. I think time will tell on that, but it's probably not likely. That you're going to see a lot of participation unless there's changes made in the law in areas that are, maybe not predominantly blue, but maybe areas that have already large criminal issues. That police force is going to probably focus on that more so than help out with immigration issues. But we'll wait and see.
Yes, it's just getting more complicated. And from what we hear, people, or I mean, states who are not cooperating are also being said that they are going against Trump and they are, facing more, what to say, um, like they are not compliant with what they need to follow.
Mm-hmm.
Well, thank you for that, and thank you for those tips, I would say. And I would also like to greet some of our, folks out there who have joined us with comments. Santosh, we have Kiran, AJ, and Mangu also. So, yes, I think we should take up Mangu's comments quickly because I
Sure.
think it is related. I'm deeply concerned about reports indicated that many immigrants, particularly those from India, are being detained and deported without adequate access to legal representation. How can we ensure their rights are upheld during deportation proceedings?
So I think specifically in that circumstance, my experience is those are individuals who have entered through CBP, typically through an airport, and those individuals are inspected before they are admitted to the United States. When you are undergoing inspection, you are not basically granted admittance into the U.S. and subject to the U.S.'s protections and laws. So what that means is if you are coming in, let's say through Chicago O'Hare Airport. I hate that airport, by the way. I want to tell everyone on this call. It's one of the worst airports in the entire United States. It's just garbage. 2-hour waits at security. It's ridiculous. Anyway, sorry. If you're coming in through Chicago O'Hare and you're on, let's say, an H1B visa, when you go through CBP, if they tag you after they look at your information, you can be placed in what's called secondary inspection, right? Secondary inspection is a place where they take you into a room or a waiting room and then have you called in, and then they basically question you about whatever it was that popped up in your record when they scanned your passport, or whatever information you said that they thought, that's weird, we're going to need to look into that. When that happens and you're in secondary, you do not have a right to counsel. You have not been admitted to the United States. There is no right to counsel. You can even have a G28 from an attorney saying, this is the attorney that represents me. I'm coming into the US. I'm on a legal visa. Here's my G28. The CBP officer is going to take that and say, that's fantastic. I don't care. They're going to throw it right in a trash can. So the thing about this is we have had people recently be put into secondary inspection for 4+ hours who have no immigration history of violation, no problems whatsoever. They're literally just picked out. And we've had their spouses call us and say, what do I do? How can I do anything? You can't do anything. That person is basically on their own. So what we have to start doing for people, and what our firm is doing for people, is we're coaching people beforehand. We're saying, look, what are the things that you could be asked? What are the ways that you should answer that comport with what's in the petition that you're using to apply? And how do you need to answer those questions? And in doing that, we're hopeful that coupled with the fact that these people, are highly educated and trained individuals, are able to get through the system. Now, the other thing that I will say about that, when you're going through CBP, once they put you in secondary, 9 times out of 10, they're pulling all of your electronics out. They're going through everything that you have. Because now that you're back there with them in secondary, they're going to say, even if the problem that we've identified is fine, we may as well take a look at everything else to see if there's something that we can figure out to say there's an issue to make this person removable. So I think that coaching is going to be necessary, and it's going to require employers working with employees or individuals who are coming in even on maybe F1s, talking to attorneys beforehand to make sure that they're ready to come through. Because I cannot express to you how bad an expedited removal order screws up somebody's immigration future. It's just the truth. I mean, they carry with them default, you're getting a 5-year ban. So that's a 5-year ban from the United States that you can only overcome with a waiver. And then if you actually end up having a ban that comes with a finding of fraud or misrepresentation, that's a permanent inadmissibility bar. So those are issues that are colossal. And I think that it's open season now with CBP. I think that they are very willing to pull people into secondary. And so, Mangu, to answer your question, they're not going to be entitled to representation. And I think unless they're coached properly at the outset, they could open themselves up for reasons to be deported, even if they're nonsensical.
Thank you so much, Justin, for taking that up from Mangu. And Mangu, thank you so much for joining us. But yes, I would like to say do subscribe to our channel, Immigration and Jobs Talk Show, where we come up with amazing discussions like these, webinars like these that could be very, very informative and helpful. So, yes, and I think we should quickly take up Rag's question as well at the same time. He says, hi, Nipa and Justin. Yes, have heard bad news about ORD, but which airports are more hospitable and how does SFO fare?
Not sure what SFO is. I'm not an air traffic controller. Is that San Francisco?
Me too, Rag. Tell us more about your question, please. What do you really want to know?
I will tell you guys just off the top of my head from practicing history and what I've been dealing with. I don't like O'Hare. I'm not a fan. Yeah, it's San Fran. I have not heard bad things about San Francisco. I have not heard bad things about Seattle. That's another airport that's okay. I'm not a big fan of Dulles, which is in DC. I'm not a big fan of that one. I've seen a lot of people having issues with secondary there. And then those are kind of my big ones. The other one that I would caution people not to travel through ever is, I think it's the UAE, the Arab Emirates or something like that. The UAE airport, don't go through there. Like I've seen removal orders from UAE where the officers don't even know what the hell it is they're talking about or what they're basing their removal on. And yeah, eventually we can work on those cases and get those people back into the US. But you have to understand, once you're out, you're looking at best case scenario, probably half a year before you're getting back in. And that's if there's clear egregious error from what has happened to you. There's not clear egregious error, probably a year and a half, 2 years, maybe more. Some people are sitting out that entire expedited removal order. Yeah, that one, the one Rog just said. No, not a fan of CBP there. So yeah, I would say that there are bad airports. As that list expands, I can keep you guys updated. But for now, those are the ones that I don't like. The ones that I do generally are along the West Coast. Now that I'm starting to kind of think about it, I think the West Coast is usually more where I recommend people to travel through if it's optional. I've never had anybody have issues in like Denver or anything like that, but I'm not sure how many international flights you're getting there. But yeah, that's it. As I know more, I will let you guys know. There's definitely POEs also that I'm not a fan of, but I think that's really niche. That's only for people that are going to be traveling from Canada. So yeah, thanks for that question.
Thank you. Thank you so much. And I think we should also just read out AJ's comment. Please don't make the places foreign national come from seem like God-forsaken places that nobody in their right minds want to return to, because for the most part, that is not the case.
Okay. Look, man, you're entitled to your opinion, but at the end of the day, there are definitely people that try to come to the United States from places that are in significantly worse off, not only financial, but governmental circumstances than what is here.
Yes.
It is
Thank
what
you
it
so
is.
much. Yeah.
Look,
Yes.
I
Yes.
understand that may be your opinion, but it may not be based in fact for everyone. Now, yeah, if somebody has to return to China, okay, they go back to China. The country at least has a semblance of a stable government, whatever your conditions against that government are. They at least have a stable government and an economy. There are plenty of places in South America that cannot say the same thing. And in fact, there are plenty of people who were just on temporary protective status who come from countries that can't say the same thing either. And at the end of the day, if your choices are between attempting to carve out a life in a place where you're unsafe and have no economic opportunities, and trying to go to a place where you could have safety and economic opportunities, not only for yourself, but for the people you care about, a lot of people are going to pick that option. And to say that we're going to shut off that valve under the notion that, no, these people are coming from countries that are completely fine, I think is nonsense. And I'll go far enough to say, would you want to visit that place?
There you go, AJ. But thank you so much for participating. He's one of our, frequent
Yeah, no, I
viewers.
appreciate it. Hey, look. He's not completely wrong in regards of all of it. At the end of the day, there are definitely people who are going to undergo removal and they're going back to completely stable countries. And yes, the world doesn't end for those people, but it does change the scope of their life. People who are immigrating typically are coming to the United States because they're seeking economic opportunity or something else that's drawing them in. That's the whole push-pull of how immigration works. So yes, they'll go back to a country where they'll be fine, but it does change what they wanted to do, the scope of what they wanted to do with their life. And then that turns into a conversation about generally what you think about immigration itself, rather than where the individual is coming from. But,
Right,
all right.
right.
Thank you, though, for the question. I appreciate it.
Thank you too, Justin, for taking that up. Such a sport you are. And, we should get back to our topic of discussion. And we are hearing so many raids happening already, affecting industries that depend on immigrant labor as well. So, what legal risks do employers face?
So I'll be honest, when I was looking into this, the biggest thing that I saw people complaining about is actually I-9 compliance issues. And I-9 compliance issues, basically it's saying, you know, when you hire somebody, they have to fill out an I-9 to show how they're in the country and able to work under authorization. If you violate I-9 compliance, you actually get dinged a set monetary amount for any violation related to the individual application. So if you have 45 employees and you have each one has 7 violations on it, however they drum it up, you're going to be looking at a circumstance where you're turning over thousands of dollars to the government, if not hundreds of thousands of dollars to the government. So that right there is a big thing. In terms of the workplace raids, I don't know if they've been at the level people were really thinking they were going to be. I think that there was kind of this presumption that day one you were going to see like just ICE everywhere, you know, at every poultry factory or farm or any of these places where there's a presumption that undocumented workers are utilized. I'm not sure that's been seen at that big of a volume. I'm sure it's happened, but when it does happen, there are certain rights that individuals have. If you're, you know, if you're a workplace owner, if you're the owner of a company, there's always the issue with the warrant. If it's an ICE warrant, it does not permit entry. It has to be a warrant from a judge. So until you set eyes on that, the individuals are not allowed to enter. You and your employees have the right to remain silent. You have you definitely have the right to counsel as the owner of that organization. I would recommend people be represented at all times at this point and have either a copy of a G28 on their phone or a copy of a G28 available in paper that they can hand over. And then have an opportunity to contact your counsel and, if possible, have your counsel present. Your employees have a right to remain silent. They have a right to remain silent, and they also should never, ever turn over documentation that is false. Never present anything that is false. Fake driver's license, social, whatever. Never turn anything over, and don't sign anything. I would recommend not signing anything until you've had an opportunity to have counsel review what's being signed. So if you are detained, you know, be quiet, request a phone call, and request a copy of what's called the ICE National Detainee Handbook. So this is a document that has to be furbished when it's requested. Gives you an opportunity to look through it and know a little bit more about what your rights are. When you are that employer, request the ID of the individual ICE officer carrying out the warrant, request a copy of the warrant, legal representation, have a site manager assigned ahead of time who's going to know what to do during a raid. Don't talk without the lawyer present. And another thing about it is when you look at the warrant, you are allowed to contest anything that is beyond the scope of the warrant. So if the warrant is tailored to search in area X and the officers begin to divert off to area Y, that can be contested. And that's something that should be noted to your representation. So I would say to limit access to areas that are expressly mentioned within the purview of the warrant itself. And also, you do have a right to send all non-essential personnel home that are not required to speak with ICE. So you can clear out the area basically as well. But again, I would definitely say rule 1, get representation ahead of time, speak with representation ahead of time, make a plan on what it is you're going to do, and then work from that. Let's not be reactive with this administration. Let's be proactive so that we're able to be prepared for when these things inevitably occur.
Absolutely. Very well put. And even this administration must have done just that. You know, they have been planning this from a very long time and now putting everything out there for us.
No, absolutely. And, you know, I honestly have to say, you know, if you can say Trump, you know, he sows chaos, you know, he's a little bit, I mean, the freeze on grants and everything being what it was, going and being rescinded, nonsense, right? Have to give credit to how quickly this administration has begun implementing changes within immigration. It has been quick and it has been sweeping, not only for the undocumented, but for legal immigration as well. And so, yeah, they came in with a plan. they learned from the last time the administration was in a position of authority, and they are implementing those things very, very quickly.
Yes, very true. And we still have so many questions to go. I would quickly like you to also highlight, how are FDNS site visits impacting H1B employees as well, and their employers in terms of compliance and even visa approvals.
So FDNS has been emboldened through changes in regulations, right? The H1B modernization rule, which went into effect on the 17th, contained with it language that expressly codified the authority of FDNS. So now that it is no longer a voluntary process. It's a mandatory process, meaning that you have to play ball with FDNS. And if you don't, and they say non-compliance, then that's, their grounds or alleged grounds for opening the door for notices of intent to revoke for the H1B. So what have we seen so far? I have not seen, as of now, a colossal uptick on the physical site visits, but those are very likely coming. What I have seen is an increase in the emails and phone calls being made to employees and employers requesting information and documentation. Now, those documentation requests, which were previously, maybe 8 or 10 things, and we would work and turn over maybe 6 because we think that they're actually related to the petition. Those have grown exponentially in scope. And we're getting to a point where I saw one the other day that was 34 different questions, and the officer alleged that there was a 24-hour response time to provide all of that. And a lot of these things are beyond the scope of the petition. They have nothing to do with the individual's H-1B, and they're more so a fishing expedition. They're an opportunity to look back on the entire immigration history of the individual with the hope of finding a violation status. And now that the officers have the ability to say, well, if you don't comply, we're just going to refer this for notice intent to deny or revoke. Employers are more on edge. And I think that when you're an employer and you're going into this and you're not aware of what it is that you do need to provide and what you don't need to provide, and you're handing over everything, USCIS is going to figure out that they can just keep hitting you over and over. And they're going to do so. So I think that, for FDNS, it's going to get more aggressive. I think that even though there hasn't been an increase in site visits, I think what we're seeing is the preamble to it. I think we're seeing the increase in calls and emails is a gathering step where they're going to accumulate documentation and then execute on site visits, because I think they're going to go after people who are working at third-party sites. I think that they're going to go after people who are working from home. And I think their goal is going to be to take all of the information that's turned over to them, run it against the statements made by the people in person, if they're not represented by counsel and realize that they should shut up and hand over the G28. And then they're going to run everything against each other, and they're going to find something or try to find something that shows that there has been fraud or misrepresentation, which would allow them to send a notice of intent to revoke for the petition. And I think that's what they're going to do. And I think that's going to be a powerful tool for them too. I think it's going to be something that they're going to want to hire more people to do this, because it's a great way to scare the individuals that are working subject to non-immigrant work visas. And that's not even just the H1s. I mean, the L1s are people that I think could face being targeted, which are specialized knowledge and managers and executives from multinational companies. I think the F1 program is probably going to be getting targeted in some capacity. So I think these are all things that are up they need to change basically how they're practicing now before it's too late and they end up into getting a revocation, because you get one and it really does open the door for them to just kind of hit you over and over again. And also, you have to remember what FDNS collects goes abroad to the consulates. And so not only are you dealing with issues with challenges potentially that you beat back with USCIS, could be grounds again for another issue when you go to apply for a visa abroad.
Right. And also, Justin, we've been hearing that, there's too much, a lot in the news, actually. Everything is definitely sparking more panic and everything. But do you think everything is true? There are also false rumors about ICE raids, which are really sparking all this panic everywhere across the United States. You want to say about that too?
Well, social media is both a benefit and a burden to society at large. I think that it does a lot of things well, and I think it does a lot of things poorly. And something it does really poorly is allow for the simplistic dissemination of false information. I think that, the need to verify things has kind of fallen off. I'll be anecdotal and just let you guys know I quit X. I left. I quit that. I quit Instagram. I just, got to a point where I really couldn't handle it anymore. But unfortunately, it's kind of they're what is in our society now, and that information, that hole of false information, is what is constantly churned out to everyone. There are websites that are supposed to track statistical data in regards to deportations and raids and things like that. I would look at that information. I would use that as your barometer for, making a decision about whether or not the information is true. That being said, just because there hasn't been this colossal raid for work sites doesn't mean that it's not precluded. It doesn't mean that it's not going to come in the future. My personal opinion from the research I've done and the conversations I've had is right now what they're doing is cherry picking. They're taking low-hanging fruit. They're trying to go after low-hanging fruit because they want those deportation numbers to be bumped immediately so they can show that they're carrying out their promises, right? A big goal of the Trump administration's first 100 days is all the promises that they're going to keep. So they'll do that because it'll be an opportunity for them to just grab people and kick them out. And that way they can say, look, we've got something done. It may be once that is done that then the workplace raids start. It's really just a matter of time to see how it is. From legal immigration, though, I will tell you guys, things has already begun to change. The consulates have changed. They've become more aggressive, more difficult. Very quickly, I'll note the F1 program is seeing challenges that we have never seen before. For example, optional practical training, which is called OPT. OPT, you are allowed to work without pay. You do have to be paid on STEM OPT, but for OPT, you can work on what's called an unpaid internship. So we are seeing people that are applying for STEM OPT, which is their 2-year extension of OPT, get RFEs and eventually denials. And basically those denials are basically coming from this idea that under FLSA rules, the internship that they did that was unpaid should have been paid. And now this is really, it's a very odd argument for the government to make because first off, how is a USCIS officer able to make that determination? The officer is now becoming an expert in employment law and is now able to tell what positions merit pay and what positions don't merit pay. Additionally, these unpaid internships, your OPT can only be for a year. Whose jobs are being protected if you're going after people that are working on unpaid internships? Is there a bunch of U.S. citizens who feel like they're not getting their crack at unpaid internships that want them? I don't know. And that's what I mean. It's literally just a tool to deny cases. And that's what their goal is. We just saw a notice of intent to deny come in literally before I got on this call, where they're saying that this person is not eligible for STEM OPT, which again, it's a 2-year extension of your OPT, lets you work for 2 more years. There are tons of requirements on it. You have to follow a specific training plan. It has to be approved by the school DSO, has to be paid, has to be in a degree related to your field. There is regulation and guidance over it. They're saying now that for some people, you went to a school and you went into a school that had a hybrid program. And the hybrid program allows you to take classes at home and at the school. They're saying that the school has failed to register this program with ICE as a hybrid program. And as a result of the school's failure to do this, you, the individual, have violated your status. And now your STEM OPT extension is denied. And again,
It's crazy.
It's great. What frustrates me so much about this is the goal is supposed to be to weed out fraud, right? It's to weed out people who are misusing or mistreating a system. How are these people doing that? They're not. It's just a new tool that they're going to try to use to deny people when they go to change status, when they go to apply for STEM OPT. And again, these are legal immigrants. These are people who paid money to go to schools in the U.S. and get an education here. People that we allege we want to retain because of their talent.
Exactly. And it would have made little sense if probably ICE would have sent a notice to the school instead, saying that you're not registered as a hybrid program or
Well,
something like
we've
that.
seen that they wouldn't bother to do that anyway. I mean, we've worked a bunch of cases recently where we had to get people's fraud findings removed because they worked at fraudulent employers. I mean, are they going after the employers? No, the employers just shut down. And then they go start another business or do something else. So yeah, it is this kind of ass backwards thought process by which you're saying we need to go after the kid that, the kid that at the end of the day hasn't intentionally done anything wrong, rather than the entity or the institution that should know better or be responsible for what they've done.
Exactly. And yeah, thank you so much though for that great example. And I think we still have a little bit more time if you please, and we should take up our Facebook questions quickly. And I would say, Rag, AJ, thank you so much for coming back with more comments. I would appeal to you to join us on call if you can. Our phone number is 425-436-6335 and the access code is 988-888. All right, so let's take up this first one from our Facebook group. It's from an anonymous participant asking, "Hi, I have applied H1B through consultancy and I got RFE on November 2024. Yesterday, they are telling RFE document submitted, but in the site, it's still showing RFE status. Once RFE document submitted, the status will change, or is it the same as RFE status?"
So usually it's going to change to like RFE received, and your case, your case is your clock has been resumed, your processing clock. So that's usually what's going to happen first. Now that being said, USCIS's online, their website, the case status website, is kind of notorious for how slow it is and how long it takes to update. So I wouldn't be surprised if you just sent an RFE response if it hasn't been updated. If you know that it's been delivered and the RFE, like you have confirmation that it was delivered from the tracking, and you get to about a week or a week and a half and you still don't see an update, I would think about reaching out and maybe trying to contact the helpline. If it's premium, they're way nicer. If you just email premium processing, they're usually going to give you a heads up on what's going on. But of course, that's because you paid, or your company paid $2,805 more for your case. So they're going to give you a little bit more detail. But usually the way it works is when you respond to an RFE, it's going to update and say RFE received and resumed processing. And then a couple of days will go by, or if you're in premium, a couple of days. If you're regular, Lord help you. But a couple of days will go by, and then it'll say RFE, case assigned with an officer, case assigned to an officer, case with an officer under review. That's just telling you that it's now on the desk of an officer so that they can look at the case and work on it. Does it mean your case will be approved within 24 hours, 48 hours, 72 hours? No. It just means that it's under active review. So after that happens, it's going to update. Usually it's going to update to either explaining that, the case was approved and an approval was emailed or will be sent to you, or additional information is needed. Another request for evidence has been issued, which don't be surprised if that's what you start seeing with the Trump administration. I'm just going to be very straight up with you. Anybody that submitted a first RFE and you didn't get your adjudication before Trump came into office, don't be shocked if a second RFE follows. That was very common under the last Trump administration, that you would get a first RFE on one issue and then you get a second RFE on 4 completely different unrelated issues. So don't be surprised if that happens. Just make sure you got a good attorney. But it'll update then, and then obviously worst case denial. Now, I want to tell everybody on this as an attorney that has practiced for going on 8 years, so we're all clear about something. If your case status updates to denied, your attorney does not know the reason for the denial until they get the denial notice. They are not clairvoyant. Now, yes, if the RFE is on specialty occupation only and the case is denied, specialty occupation. But they don't know why, because they don't get the adjudicator's reasoning until the denial notice is received by their office. And that can take a couple of days. So when your attorney tells you, knock on wood, I pray for you, no one gets denials, But if your attorney tells you, look, your case was denied, we have to wait and see the denial notice. It's not buying time. We genuinely don't know how to proceed until we see the notice. Do we think that there's an avenue that we can address the issue with premium processing? Do we think that we could file an appeal or a motion to reopen? How much time is left on your current non-immigrant status? And is this an opportunity where you can reapply? What is reapplying going to do versus appealing? All of those things have to be borne out by the language in the denial. So to answer your question, yes, it will update. Wait a week or two and then see what happens with it. And then if you're not in premium at this point, maybe think about upgrading to premium.
Yes, money talks, at least in this case. Premium processing is always, answered earlier. Let's go
Oh,
on
yeah.
to our next. Yeah, thanks, Justin. To our next question. This is also from an anonymous participant. Hello, everyone. I have a question. With the modernization rule of H1B visa effective from 17th January 2025, do we need to state the starting date on or after October 1st? Another question is my I-94 expiration date will be on June 15th, 2025. I will file I-129 on April 1st, 2025. So after filing, can I still stay in US until I-29 is approved? Or do I have to leave the US not later than 15th of June?
Okay, I'm going to do a lot of heavy lifting with this answer because I'm going to assume October 1st means you're talking about a quota case because quota, October 1st is the first date you can be eligible for an H1B if your case is selected in that year's lottery. You can move the start date around now. That is now permissible. So you can move it back or forward. However, if your I-94 expires June 15, 2025, and you're filing on April 1st, I would probably say you're going to want to try to get work authorization as soon as possible. So yes, if it's a quota case, you can move back that start date. If your I-94, though, is expiring, I believe that would mean that you are in a different status because I believe F1 has DS as the status. So I'm going to handle that answer separately. If your I-94 expires June 15th, 2025, and you timely file an extension prior to that date, you are allowed to remain in the United States during the pendency of that application under what's called POSA bag. That's a period of stay authorized by the Attorney General. That POSA bag permits an individual to remain living in the United States and working subject to the conditions of that classification up to either the adjudication or I believe it's, please don't quote me, you may have to look it up, 280 days after the expiration of their status. So it's either 180 or 280. All that is to say, I would just file the extension. You can remain in the United States while the H-1B extension is pending, if that's what it is. And then I would probably check that statute to see how long you get. And if you start to get close to it, upgrade the case to premium.
All right, there you go. Thank you so much, Justin. Let's go on to our next one quickly, please. I have joined a new company, product company, and my I-797 was approved in September last year. I have had one stamping done for H1B, still valid, but thinking of getting another H1B stamping in May this year. With the new changes, is it harder to get stamping nowadays? I'm worried because I have an MBA and I work in software implementation. Are there major chances of getting refusals during stamping because of degree, or is it checked only during petition?
So usually when the consulate looks at an application, a visa application, the only thing that they're supposed to send back would be fraud or misrepresentation on the petition. So as long as the petition was approved and the documentation in the petition is valid and confirmable, there shouldn't be an issue that requires inquiry into eligibility. They should not technically be looking at if the position is a specialty occupation or if the beneficiary qualifies for the position. That's USCIS's job. So I would say the MBA isn't your concern here. I think what your concern is and should be for most people is the increased scrutiny at the consulates in general that have been placed on petitions by consular officers. That increased scrutiny, I think, is going to lead to an increase in 221Gs, and I think inevitably to an increase in visa refusals. So I would be a little cautious right now to go to the consulate, to be honest. I think in a perfect world, if you have the ability to wait a couple months and let the dust settle from this new adjudication and allow attorneys and companies to collect data so that they can start seeing what trends are, I think that's going to be your safest course of action. And that's regardless. I don't care if you have the squeakiest clean immigration record in the world. I don't care if you're a software developer and you're working for Apple and you have a degree in computer science. I would just say to anyone, just be careful. We're learning right now what to expect when people go abroad. I have an individual that I worked with at my former firm, and one of our client accounts had literally not received a denial, a blanket L visa denial in the preceding year or 2 years, I believe. They had already gotten 2 on this Monday. And that should be a little concerning because this is a massive multinational company. This is a corporation that you've seen advertisements for on television. It's a corporation that has a lot of power and money. They're getting visa refusals. So if these companies are getting visa refusals, what do you think the rest of the organizations are going to look like? What's it going to look like for them? So we have to wait and see. And that's why I say data is key. Once we figure out data, what are the trends, what are the consulates asking for, we can adjust and then make changes that are needed to make sure that people have the highest probability of an approval when they go in for their interview.
All right. So, Justin, at this moment, we actually have a caller, and he is John Santu, if I'm not mistaken.
Okay, I can try. I'm very close to end on time. I'm sorry, but we're at noon.
All right. All right. John, if you could just quickly ask your question, please.
Yeah. Actually, I'm a non-citizen resident of this country. I've been here for at least 24 years now. I have filed my petition for marriage spouse. I had get abused by that. The spouse and I had separated. I asked her to let me file a divorce of that. She never did. I have ended up in a fiancé, a person that I take and make a life. She is a non-resident either. And we have 2 American citizen kids. But upon filing the marriage petition, they request more evidence. The immigration requests more evidence where the spouse have abused the power and said that she's no longer doing the papers. And imagine we lived together for at least 9 years.
Oh.
What is my position here?
Wow. That's an impressive fact pattern. I'm not going to lie to you. What I would tell you, to be just completely blunt with you, is if you want to have a discussion that is very fact-centric, I would ask you to send an email to my office. Because I would have to really delve into that. I mean, the fact of the matter is if you and the other party are no longer married, then my assumption would be your I-485 is kind of a null and void situation. I'm honestly surprised your former spouse, or I guess still current spouse, hasn't moved to withdraw the I-130. So that's already its own independent issue. And then getting into the other issues, I think that would require a pretty detailed discussion. So if you want to send me an email with your facts, I'd be happy to take a look at your case because it sounds, complex and intriguing. So if you want to shoot me an email, it's my first name, Justin@wasden.law, or you can send it to support@wasden.law, and they can filter you in. We'd be more than happy to take a look.
I know you kind of busy. I can take that information from your associate right here. I have a very fast question here, sir. I know you had to go. The point is that I'm trying to get to is that I request a FOIA from immigration, and they never send that FOIA.
Okay. So you did a Freedom of Information Act, and you received confirmation of receipt of the FOIA?
Yeah, well, I did. I have contacted immigration consult, and we did send them for a FOIA, which means have the whole case that we dealt with.
Right. So usually how that works is you're going to get something back saying that your FOIA request has been received. It's going to be put in a particular category based on how complex or detailed it is, with a generalized timeline as to when you can anticipate receiving a response. Have you ever received any of that correspondence?
No.
Okay. So yeah, what I would probably do is follow up on that FOIA request then, just to make sure that it was properly submitted. Because the way it usually works is you submit the FOIA request, you get some level of acknowledgement, letting you know that it has been received, intaked, and assigned. And then you get a sort of timeline as to when you can anticipate getting your records returned to you. And then what they do is at the end of it, they send you basically a full breakdown of the documents and usually what's a partial denial explanation. And they're going to say, look, we have either blocked this or X'd out certain parts of the document because of, and they'll say, national interest security, whatever have you, criminal investigation. But they have a litany of reasons why they can refuse certain parts of your FOIA. But the very first part of the whole FOIA request is you should be getting something back when you submit the request.
Yeah, because I have some of the documents that I have received from immigration, and when we went to that interview, I try to offer her if she does want our marriage to carry through. Imagine we have slept together for at least 10 years, a whole decade, as wife, husband, and wife. But something went down the line, and she decided not to carry on with her marriage. And that's when they request more evidence of me as an individual.
All right. So, John, I think I would just suggest you best to, have a one-on-one consultation with maybe Justin. And first off, email him all the details, please. I hope that you have noted this down, support@wasden.law. And you can even call him on the number that is displayed on the screen. You can note it down, please. 844-592-7336. So I think we will have to, because your case is a little too complex and it cannot be solved right now. So it'll be best to contact him. Don't mind. We will have to cut it short right now. So thank you so much for joining us from Florida. All right. So thank you so much, Justin, for being so patient and for taking up all of our questions, and also, John Santu for joining us on call just now. We have AJ, Rag, and so many folks out there. Thank you so much. But Justin, just to
last person. If you email me or whatever, that's fine. Or set up a call. Look, they don't play around when it comes to marriage visa fraud. That's a pretty serious thing. So I'm gonna tell you right now, like that's a pretty serious case, and I think it requires the attention that it needs. But anyway, I'm sorry for cutting you off.
No, I was just saying, yes, they will need to consult you because it's a very complex case. And maybe if you could just give us a few last words, to wrap up this session, this great discussion we had today.
Absolutely. Thank you for having me as always. I feel that this has been a fairly negative oriented conversation. Obviously, a lot of negative stuff. I will say this, our office had two recent beneficial outcomes in litigation that have assisted people with issues that they had dealt with immigration. Their cases are being resolved presently, and we're hoping we can get them back, into the U.S. in the next, coming month or two. So all that is to say this. There is still, the courts are still being the courts. Like the courts are still doing what they can to follow the law right now. So that is always an avenue when everything else fails. There is litigation that's coming down the pipeline right now that is going to be challenging some of the modernization rule changes for the H1B. So that's something that'll be coming up in the near future too. I'll maybe update you guys about it as it plays out. But yeah, all that being said, everybody, stay safe and have a fantastic weekend.
Thank you so much, Justin. You too. Have a fun Friday and a happy weekend ahead. I hope it gets positive by next week.
Me too. All right. Have a good one. Bye.
You too. Bye. Folks out there, thank you so much for joining. I'm so sorry if we couldn't take up all your follow-up questions, but Rag, AJ, always good to see you. You guys are our frequent viewers, visitors. So keep commenting and thank you for sharing your opinions with us, AJ. Really great to know what you think as well and your thoughts. So keep sharing. And yes, don't forget to like, share, and subscribe to us. All of you folks out there, thank you for watching. Thank you for joining. And stay tuned on Immigration and Jobs Talk Show because we got more discussions coming up, especially today at 4 p.m. Eastern Time. We have Daily Immigration Dose, and I'm going to be back with my co-host Sam. And also, if you have to tell us more about your case or about yourself, please feel free to even contact me. And my phone number is 408-335-6444. You can even WhatsApp me in the same number. And you can email me. My email is nipa@staffingly.com. And yes, thank you once again for joining us. Stay tuned. Bye bye for now.
Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam, and today we are back again with another very exciting and very timely topic. I'm sure most of the H1B workers are really looking towards the changes that's going to happen in 2025, especially under Trump's administration. So, before going ahead and before inviting our today's guest, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. Use of information is at your own risk. All right, friends, after this very important disclaimer, thank you so much, everyone, for being here and being a part of this session. We are live on YouTube, LinkedIn, Facebook, and on X as well. So let us know from which platform you guys have joined us and do participate in this session by commenting. And we are here for an hour, so make sure to participate and ask as many questions as possible. Well, without any further ado, let me welcome our today's very special guest and who will be joining us for the fourth time, who is none other than attorney Karen Lee Polak. who is a managing attorney of Polak PLLC, a top immigration law firm which is based in Dallas, Texas, and also in Florida. The firm provides a full range of immigration services to businesses, families, and also individuals. So, welcome, Karen. I'm really happy that you are here, and we are really honored to have a show with you. Thank you so much, and we are really, really grateful that you're back here again.
Thank you, Sam. It's wonderful to be back on the show again. Thank you for having me. It's my honor and privilege to be joining you today.
All right, that's really great. I'm sure our viewers are also really eager for your next show because I think last show was really great and we really had a very great interaction regarding the H1B modernization rule. And today we are back again with another H1B very exciting topic like what changes can we expect in 2025. So, Karen, I would like to know before jumping into my questions, I mean, what can you say how 2025 will be for the H1B workers? Will it be very challenging or will it be okay or what it will be?
I think it will be okay as long as you are prepared in advance. The lottery registration USCIS has announced begins on March the 7th through March 2024. So as long as you've registered your account before then and you have your key documents, you've consulted with an attorney regarding any issues, I think you should be fine. I know we've talked about it before, but the H1B modernization rule changes a lot of things. So it's not actually the Trump administration that's changing things in 2025. It's the Biden administration that released, Department of Homeland Security, the H1B modernization rule on January the 17th, 2025, and that has significant changes for the H1B program.
That's
so
right.
some of the So some of those changes to the H1B modernization program include a significant increase in fees for registration. Registration has gone up in fees from a $10 registration fee to $215 per registration. There is also a change in specialty occupation definition to now require a bachelor's degree in a directly related specific specialty or its equivalent. So now USCIS is going to look not only at the job title and degree title, but also at the course of study. So these are some of the major changes with the H1B modernization rule. Also, one of the significant changes includes owner beneficiaries can petition for themselves now, which is great. However, these H1B visas will only be valid for 18 months.
That's right. Okay, so I think we got a gist like how this year is going to be for the H1B applicants, and it shouldn't be a lot of challenging, but I think by being updated and staying connected, with all the news and the changes that's happening, that's how you can save and you can protect yourself. So, Karen, I think let's start with my very first question to this topic. That what major policy changes are expected for H1B visas under the Trump administration in 2025?
I don't expect any changes under the Trump administration. They've all been outlaid in this modernization rule, the H1B modernization rule, which I said was released on January 17th, 2024. I've already outlaid some of the major changes. Other changes include USCIS will evaluate third-party job requirements for specialty occupation classifications. For example, if the beneficiary will be performing staffing services and will be part of the staff at a third-party work site, USCIS is now going to look at the third party's job requirements rather than the petitioner's job requirements. If they'll only be providing services such as a management consultant, then they will look at the petitioner's job requirements. That's also one of the modernization rule changes. Also, cap gap extensions now run until April 1 of the fiscal year or the approved petition start date, whichever is earlier. So those are some of the more significant changes that we can see under the H1B modernization rule. I don't expect President Trump to be making any further changes to the H1B program for fiscal year 2026.
All right. I think that's a point of relief because most of the H1B workers were really concerned about, how their time will be, especially under Trump's administration. But I think, Karen, if you're explaining and if you're saying that it will be okay, and that's not going to be much difficult. So I think that's a point of relief. And also moving ahead, Karen, I would like to ask another
Yes.
question that how will the Trump administration's immigration policies will impact the H1B visa cap in 2025?
I don't think it will impact anything at all. As I said, everything that's related to changes is laid out in the H1B modernization rule. So I don't think the Trump administration is going to make any changes to this year's H1B cap subject petitions.
Okay. I think that's again another point of relief. But Karen, I would like to know it from you because in news and in most of the press conference also, we have been hearing from Trump's side that he is not very much into H1B workers. Or he may, I mean, the process may be scrutinized or there will be more challenges. So we mostly come across with those statements, what Trump has been saying regarding the H1B workers. But now, as you're saying that we are not going to see much changes. So what do you want to say? That do you think that Trump is favoring or is going to favor the H1B workers?
I think he's actually said in press that he does favor the H1B program. He has the air of Elon Musk. Elon Musk came in on an H1B petition. So he really understands the whole program, not only from what he's read, but going through it personally. And I think, as I said, he has air, and President Trump has come out and said that he is in favor of the H1B program, and we know H1B beneficiaries in his own businesses. So I think for now he is in favor of it. I do believe that there will be greater scrutiny of H1B applications. Part of the H1B modernization rule expands site inspection authority. I think we can expect greater site inspections. I think we can expect USCIS to ask for documents to show that there's a bona fide job offer, such as statements of work, contracts, and other documents which show employee-employer relationships. So I think there'll be a greater scrutiny of H1B applications and more requests for evidence, just like we saw in the first Trump administration.
That's right. I think that's absolutely done. And also, Karen, I would like to move ahead with my next question that's regarding the lottery system. So, I would like to know your views. I mean, do you think the lottery system regarding the H1B visa process is okay? Because it mostly depends upon the luck, not on the skills. So, what's your call on that? Do you think or do you
That is
favor the
correct.
H1B visa lottery system? Yeah.
I don't personally favor the H1B lottery system. I think we should leave it to market forces. And if there's a demand for H1Bs in bona fide specialty occupations, we should give those H1Bs and let the market dictate how many H1Bs should be issued. So I think the lottery system is a very unfair way for employers to conduct their businesses. And it's actually led to a lot of jobs going offshore because businesses can't rely on luck to establish their workforce.
That's right. And I think Trump has also mentioned somewhere that he is not going to keep the lottery system, right? I mean, he hasn't put up any statement yet, but we can see because somewhere he said that he's not very much in favor of lottery system. So let's see what happens.
That may be a good thing.
Mhm. Yeah, please go ahead.
I think that may be a good thing that he's not in favor of the lottery system as long as we continue with the H1B program, and maybe he will agree and let market forces dictate it rather than just some random lottery. As I said, I'm not in favor of the lottery system, but as of now, we don't know of any changes that will take place, and they certainly will not take place for this year's H1B cap.
All right. So I think you already answered this question that I was about to ask regarding the changes to the lottery system. So thank you so much, Karen, for making us aware and also letting us know what the lottery system can we expect in this year. Let's move ahead with my next question. And Karen, here I would like to know regarding visa frauds because most of the time, there's a lot of frauds that happening. So how will the Trump administration address these H1B visa fraud and abuse concerns in 2025?
So I think I've touched on this already, but under the H1B modernization rule, the USCIS has expanded site inspection authority. So now inspections may occur at petitioners' work sites, at third-party locations, or even private residence if remote work is going to be performed there. Non-cooperation during inspections can lead to denial or revocation of petitions. This is particularly significant for staffing companies that face H1B denials or revocations if anyone in the employment chain fails to cooperate in a site visit or in providing documents that are requested by USCIS in response to a request for evidence.
Yeah, of course, of course. Okay, so I think that was a really great answer from your end, Karen. And moving ahead, I would also like to know regarding that can we expect some modification regarding the wage requirements for the H1B visa holders in this year?
I don't believe there'll be any modifications to wage requirements for H1B visa holders this year.
Okay, I think let's hope for that thing as well. And what about the diplomatic engagements? Because if we specifically talk about India, then we have seen that Narendra Modi have been visiting not only Narendra Modi but during Trump's inauguration time also. We have been seeing different prime ministers also. They have been coming to Trump's inauguration ceremony, praising them and having a very good connection. So, what's your call on that? I mean, do you think that in 2025, Trump's administration is going to have a better international relations with the other countries?
I think he'll have better relations with some countries. I think he's going to have much worse relationships with other countries. In regard to President Modi, I think he has a good relationship with him. So I don't believe that any relations between India and US will impact this year's fiscal cap. I know India is hoping the Trump administration will safeguard legal migration pathways for Indian citizens, including student visas and H1B visas for skilled workers. I know that there's worry that the US will cut the number of permits for Indians, but I do not believe that that will happen for this H1B cap or for visas in general. The Trump administration has not come out and stated that it will cut any non-immigrant or immigrant visas in relation to Indian citizens.
That's right. That's absolutely correct. And I think my next question was also about the international relation. But Karen, I would like to know it from you. Like, if Trump is putting any changes or any policies for the H1B visa workers in any country, maybe in Canada, Mexico, or India, or whatsoever the country is. So, do you think that I would say, the foreign talent recruitment strategy is going to affect the international relations if there will be any changes regarding the H1B visa policies?
So I don't believe for this year's H1B fiscal cap there'll be any influence or any changes. So I don't think international relations, good or bad, will impact this year's H1B fiscal cap. But we can see next year, I mean, there are countries that President Trump has tenuous or strenuous relationships with, and in the future that may make a change to those countries. But for now, I don't believe there'll be any changes.
Okay, all right. And what can you say about the backlogs? I mean, how might the Trump administration address the backlog of H1B visa applications in 2025?
There are no H1B visa backlogs at all for any countries. So we don't expect them for 2025. There may be delays but there are no backlogs backlogs, and traditionally there have been no backlogs in the H1B visa category.
Okay. Let's hope so that there wouldn't be any backlog because most of our viewers are really concerned about the backlogs, and especially in India there are, like, I would say, millions of people who are already in backlog and they are willing for that. But let's see what happens. And as Karen, you are saying a very positive thing, so I hope our viewers are really filled with this. So thank you so much for making us full of positiveness and letting us know about these things. With that, I would also like to know my next question to you, Karen, that could you elaborate on which employers are considered cap exempt and how working for such employers affect the H1B application process?
I'm sorry, you were up. I couldn't hear your question.
Okay. All right, no worries. I'll repeat again. The question is that could you elaborate on which employers are considered cap exempt and how working for such employers affects the H1B application process?
Sure, absolutely. So cap exempt employers include higher education institutions such as university and colleges, non-profit research organizations such as entities engaged in research benefiting the public, and government research organizations such as federal, state, or local government entities conducting research. They also include some non-profit organizations associated with higher education institutions. Those also sometimes qualify as cap exempt. The difference between cap exempt and cap subject petitions is that if you qualify for a cap exempt petition, you can apply at any time of the year and there's no lottery system.
All right. Okay, and here's another question, Karen, that I would like to know it from you. That what changes can we expect in the employer sponsorship requirement for H1B visas in 2025?
I think we've addressed most of those changes with the H1B modernization rule, but I think that the government is going to put closer scrutiny on the bona fides of a job offer and what the actual requirements are of the job. Again, I think that if the beneficiary will be part of the staff at a particular company, if it's a third party kind of situation, the USCIS will look at the third party's job requirements rather than the petitioner's job requirements.
Yeah, I think that's very well said. Okay, so Karen, here's another question from my end that for applicants who may not secure an H1B visa, what alternative visa options are available for working in the US?
Well, the first option is an F1 student visa, either with day one CPT, which is curricular practical training that will allow them to work. So either an F1 with or without CPT. There's also F1 OPT, optional practical training. There is an E2 non-immigrant investor visa for people, for citizens of certain countries, if you can invest $100,000 into your own business. There is also the EB5 immigrant visa if you can invest 1,050,000 into your own business or 800,000 into a regional center. There are also O1 non-immigrant visas for aliens of extraordinary ability, and there is the EB1 green card for aliens of extraordinary ability. So those are some of the other options that are available. But people should definitely have a game plan in place and not wait to be selected or hear that they are not selected in the lottery system.
Absolutely, absolutely. That's correct. All right. So, Karen, I think I have these questions. And with that, I also got one question from our viewer who was an Indian applicant. So, Controller, can you please? Yeah, this is the question that we got on Facebook. So, he's asking that my full family, 4 persons, applied for US B1 B2 in Kuwait. So, can we use this interview waiver from India or Saudi Arabia?
No, you cannot unless you actually have residency in Saudi Arabia or India. I don't believe that you can apply for an interview waiver.
All right. Okay. I hope he got his answer. And I would say that in case if you still have any question or any follow up query that you want to know from Karen, then you can also contact her. And the contact details are on the screen, and that will be the best thing because there are lots of things that's going. So let her know about your problem, and please reach out to her on the given contact detail. That is 214 You can also email her on the email ID that is KarenLP at polakimmigration.com. And you can also visit her website that is www.polakimmigration.com. So, yeah, I think that's all for the first half. And Karen, I think let's take a short break so that after that we can continue with our Facebook questions and also have some more questions for you. So, with your permission, I
Sure.
would just like to take a quick break so that our viewers can also prepare the questions. So, thank you so much, Karen. Till here, we really got a lot of information regarding our today's topic and to our friends also. Stay connected, stay tuned, watch the session till the end. We'll be right back. So don't go anywhere. You're watching Immigration Talk Show.
Thank
Hello and welcome everyone to Immigration Talk Show. I'm your host Sam, and today I have been joined by my, I would say, very special attorney Karen Lee Pollack. And today we have been discussing, and today we are having a very great discussion, a very insightful session on what changes could you expect for the H1B visas in 2025 under Trump's administration. So we got to know a lot of things regarding our today's topic. What changes can you expect, and how the future will be, or how Trump's administration is going to modify or look towards the H1B workers. So I think friends really got to know a lot of things in today's webinar, and thanks to Karen because you have really explained everything in a very good way. And Karen, with that, I would also like to ask some questions from the Facebook group as well. So Control,
Sure.
please let us go through those Facebook questions. Yeah. Okay. So here's the first question that we got from Hannah. And she's asking that my spouse had H4 interview at Hyderabad consulate and his passport was returned. After 4 days, he received a mail stating his passport or visa is ready to be picked up and the visa status check website says issued. So what does that mean? Now he has to submit passport and visa is really issued. Yeah.
Well, congratulations. It means what it says, that the visa has been issued and granted to him, and he should return with his passport so that they can place the visa in his passport.
All right. So I think let's move ahead with our next viewer. And Hannah, thank you so much for asking this question. In case if you still have any question or follow up, then please go ahead and put up in the group. Okay, so here's a Sanket, and Sanket is asking that, hello, I'm looking for some information regarding the conversion of H4 to F1 visa. I would appreciate any input on this. So, firstly, he's asking, is it better to travel to home country for changing the status or changing the status in US is feasible? I think let's take this one first. Yeah.
It's feasible to either go home to your home country to change your status to F1 to get an F1 visa, or to change your status in the United States. They have also, USCIS now has premium processing for F1 student visas in the United States. So you can get approval in 15 business days if you pay an additional fee to the government for expedited processing. So it's really a personal choice which go. You sure that you have a valid form I-20 from your school, that you can show how you're going to support yourself while in college, who is going to pay for your studies, and that you have ties to your home you will return to. Either options are good options.
That's right. And also, Karen, here's the second part of this question, that how long does it take to convert from H4 to F1 in US?
It could take a couple of months, or it can take 15 business days if you pay the expedited processing fee.
All right. Okay. And let's move ahead with next question. So thank you so much. I think you got your answer. In case if you still have any follow up, then please go ahead and let me know. I'll definitely ask that question. Next is Surya. So Surya is asking that, hi, I have my passport expired on September 2024 and renewed new passport in January 2025. There is a gap on passport renewal, but my H1B visa was renewed in July 2024 and it's good for 2026. I have got my stamp yet for my renewed H1B. So, will this be a problem at immigration when I come back on new stamp on H1B renewal? Yeah.
It should not be a problem if you have a new H1B stamp placed in your new passport, if that's what you're asking. I'm not entirely clear about your question, but if you get a new H1B stamp, you should be fine. And if you still have a copy of your old passport, I would carry both passports just in case.
Yeah. All right. So I think those were some of the questions, and also I would say Surya. Yeah, Surya. Thank you so much, Surya, for your question. And if you still have any follow up, or if you still want to know anything else, then please go ahead and let us know about what you think about today's topic, or any concern that you have regarding the H1B visa. All right. So, Karen, now I would like to know it from you because, most of the people are in favor of the H1B workers as what Trump's administration are doing, and about the Biden's administration as well. So, I would like to know it from you that was Biden administration little lenient towards the H1B workers, or is it Trump's administration?
Sam, you were breaking up. Oh, I couldn't hear you.
All right, no worries. I think now you can hear me better.
Yes, now I can hear you. Thank you.
Okay, all right. So, yeah, I was asking about that we have been seeing how the Trump administration is handling H1B workers, and also Biden administration, how they have been handling the H1B workers. So, according to you, I would like to know it from your end, from an attorney end, because you all know things better, you all know the clients and everything. So, according to you, what do you think that who is favoring, or H1B workers will favored by which administration, mostly by Trump or by Biden? What do you think about it?
I think it was easier, or I think it was easier under the Biden administration. I think there will be greater scrutiny of applications under the Trump administration. There will be more site visits. There will be more attention to job offers, bona fides of the offer. Now that they've changed the definition, there will be a closer look at applications, the courses of study that the beneficiary did, to make sure that it's related to the job. So those are some of the changes. I think they'll be much stricter under the Trump administration.
Right. But Karen, as you said that Trump has never said anything about against the H1B workers, and he is mostly in favor. So why is it that we can see scrutiny under Trump's administration for the H1B workers? I mean, how can you explain these things to us?
I think I'm basing my, it's just, first of all, it's just my opinion, but I'm basing my opinion on the first Trump administration in the first 4 years where he was in power, where we saw a greater scrutiny of H1B petitions and more requests for evidence that we saw under the Biden administration.
Absolutely. And there he was, I think during his first term, he was not in favor of the H1B workers. And most of the time, he has said that he doesn't like them. But now he is in favor. Maybe he got the influence of Elon Musk, his very close friend. That's what we have been seeing right now. So I think that's okay. And Karen, our viewers are really, I would say, curious to know your point of view regarding Trump's administration. So that's why these questions were really important to us. And with that, Karen, I would also like to know regarding, as currently there has been a very hot topic regarding banning the income tax and putting tariffs on. So, what do you think? I mean, do you think Trump's administration has taken a right step to ban the income tax, or do you think that this is not a correct one?
I don't know. It's a very complicated topic. And I think in some cases, we do need to increase tariffs with some countries. And in other cases, I don't think it's a right move. It will just decrease trade and make goods more expensive. So it's a very difficult topic, but not one that's related to immigration per se.
That's absolutely correct. All right. So, Karen, I would like to know another question from you that we have been talking about the H1B workers, right? Now, I would also like to know regarding the international students that how will the proposed changes or the changes that we can see in this year, how is it going to affect the international students in the US who are trying to or who are hoping to have a transition to the H1B status?
I think it's going to impact them based on what job offer they've got and how their degree relates to that job requirement. There's going to be more focus on that. So I think that beneficiaries need to be very careful or selective about the jobs that they take to make sure that the job position is related to the courses of study that they took.
Absolutely. But Karen, what do you think? I mean, can you suggest some jobs that will be beneficial for the H1B workers? Any options regarding what jobs will it be?
I think it depends on what their course of study is. If they have just a general business degree with no computer courses and they've got a job offer as a software developer, that's going to be problematic if they haven't taken any computer courses during the course of their study. So I would say that they would have to have a degree in information technology, computer science, or a related degree, or at least have done some courses in their degree that relate to software development.
Right. But also, Karen, regarding the H1B modernization rule, there has to be a word to word, I would say, worker, right? So, don't you think the H1B modernization rule will make the H1B workers process little difficult or challenging?
I just think there'll be greater scrutiny. I think if you have a well-prepared petition, you should be fine, where it outlines how your courses of study relate to the job.
That's right. That's absolutely right. Okay. Also, Karen, I would like to know some questions regarding the spouses and the family immigrants as well, because it's not only the H1B workers, but it's also their family and their children. So, firstly, I would like to know regarding the spouse that are spouses of H1B visa holders, especially the H4 visa, are they likely to face any changes to their work authorization in this year?
Sorry, you were breaking up. I didn't understand the last part of your question. I didn't hear it properly.
All right, no worries. Okay, so I think now I am a bit clear, right? Okay, Karen, can you hear me now?
Now I can, yes.
Okay, okay, all right. So, yeah, Karen, I would like to know it from you that are spouses of H1B visa holders likely to face any changes on their work authorization?
I don't believe so. I mean, I don't know. I'm just guessing, but I don't think that there will be changes for spouses of H1B workers. Generally, spouses on H4 visas cannot work in the United States unless the H1B holder has an approved I-140 petition. And I don't expect that to change under the Trump administration.
All right. Okay, so I would like to know it again regarding the proposed or maybe the changes that we could see. So, Karen, how do you see that? How might the proposed changes is going to impact the U.S. economy and its global competitiveness?
Well, I think that the H1B allows some of the best and brightest talent to come to this country. And that's why I think market forces should dictate whether H1Bs, how many H1Bs there should be. So I think that impacts the United States competitiveness in the global market. And if we can have the best and brightest educated in the United States, which indirect US taxpayer dollars, it makes no sense that after they have studied here, learned or everything about our education system, that they should not have a job here and they have to go back to their home country. That makes no sense, because all we are doing is educating some of the best and brightest and then exporting them overseas. So again, I believe that market forces should dictate how many H1Bs there are.
I think, yeah, that's very well explained. All right, so thank you so much, Karen, for letting us know about these things. And we do have our viewers' question, but this time, it's a little different because most of our viewers are watching us on Facebook and on LinkedIn as well. And I think so. Let's take up our Facebook questions because their viewers are watching us. So, yeah, Control, I think we got our viewers' question, and this is we got from anonymous member. So here's a question that I have unstamped H1B visa. Can I visit Puerto Rico as it's part of US? Yeah.
Yes, you can visit Puerto Rico because it's part of the United States.
All right. Okay. Can we have the next question, please? Okay, so I think this is the question that we got from Indian applicant, and he is saying, "Admin, please approve the post." Okay, can't we schedule H1B visa interview first time in Chennai? My agent is saying first time H1B interview in person can be scheduled only at Hyderabad. Please let me know. Thanks. I think this is something, what else we can say on this, right, Karen?
Can only be scheduled in. Sorry?
Yeah, please go ahead. Please go ahead.
It's my understanding that it needs to be scheduled in Hyderabad, but I'm not sure. I need to research that for you.
Absolutely. It's a little different question, but that's okay because our viewers are mostly from India, so they have been taking these questions more into their concern or where the interview must happen or where the scheduling part happens. All right, let's move ahead with our next question. And this we got from Priya. So Priya is asking, this is my first time H1B and I traveled to the USA, but no luck. I did not get any job offer. My visa expires by March 2025. I am planning for transfer and extension through different employer. During my extension process, can I come back to India and then go back? Yeah.
You would need to consular process your application, and then go for an interview in India and come back. You can't travel during a transfer unless you consular processing.
Okay. All right. All right. Also, Priya, I think here's a Priya's question that we took. But Okay, let's take the other one. And here's a question that we got from anonymous participant, and it is that I have received email to submit my passport yesterday. However, I am out of country and will take 2 months to go back to India. Meanwhile, can I submit my passport from current location through courier service to India? Yeah.
I guess you could. It's risky, but you can try to do it that way. Generally, you should be in the country when a visa is issued to you. So it's risky, but you could try it.
Okay.
My advice to you would be to go home and be in the country when the visa is issued.
Absolutely. All right. Thank you so much, viewer, for answering this question and putting up this in Karen's show. Next, we have from Vasu Rana, and he is asking that did anyone get their H1B stamping done after 20th January 2025? I'm skeptical after knowing about the recalcitrant country ban imposed by the new administration. Anyone tried stamping in other countries apart from India? Yeah, need to know about your experience for both India and other country. Yeah, Karen.
First of all, I don't know of, or I'm unaware of any recalcitrant ban imposed by the new administration. I'm not sure what the view is talking about. As far as I'm aware, there is no ban. We have had success both with India and other countries in H1B stamping. There hasn't been an issue at all.
All right. Okay. Thank you so much, Vasu, for your question. And in case if you have any follow-up question or any different question that you would like to know regarding our today's topic, then please go ahead and let us know. Okay, so this is another viewer. Puneet is here, and Puneet is asking that my H1B extension was filed with USCIS on January 27, 2025 in premium processing. We bundled H4 for my spouse and one kid, and H4 EAD petition in premium processing for my wife with my H1B extension petition. So on February 4th, we received approval for H1B extension, but H4 and H4 EAD petition status shows that moved to a different office online on USCIS website. So he's currently very confused, Karen, and he is saying that if they moved H4 and H4 EAD cases to a different office under normal professing, not premium, then he checked with his employer's attorney, but they said that they are not sure at this time since the rule changed after January 18th, 2025. So he thinks that most of us may be aware about this thing. So yeah, Karen.
Typically, premium processing, you're paying for premium processing for the H1. So USCIS is entitled to process the H4 under normal processing. The fact that they've moved it to another office is just because there's probably more staff in that office, and the H4 will be processed under regular processing.
Okay. Thank you, Karen, and thank you, Puneet, for putting up this question. And let's move ahead with the next one. Brittany is here. And hi, Brittany. Thank you so much for joining us. And she's asking, hello, everyone. I got my OPT for 1 year and it expires tomorrow. Is there any way that I can stay without problem in my status couple days more in the US?
Well, I mean, I have to advise you that you should probably leave the country, but because you don't want any overstay on your record. Any overstay is going to cause consequences for you when you apply for a visa. Again, you'll have to disclose that you overstayed the visa, and that may impact successful application. However, there are bans on applying for visas for 3 or 10 years. If you overstay by 180 days, then you will incur a 3-year ban to applying for any visa. If you overstay by 181 days or longer, you will incur a 10-year ban. So you need to be careful of incurring any bans, but even if you overstay by a few days, that has to be disclosed in your application, and then you may be denied a visa in the future because they'll think you'll overstay that visa. I would leave as soon as possible.
That's right. Okay, Brittany, thank you so much for putting up this question, and I hope you got your answer. In case if you still want to contact attorney Karen V. Polak, then please go ahead and we'll share the contact details with you as well. And the contact details are on the screen, and let me read out her phone number. That is 214-504-1227. And her email ID is karenlp@polakimmigration.com. And you can also visit her website, that is www.polakimmigration.com. So, friends, I think you can call her or email her or also visit her website to know more about her so that you can understand what different visa applicants, you guys can ask those questions towards any problem or any complexities, that you are having in your immigration journey. So with that, I would also like to know, Karen, that we have almost reached to the end of our episode, and we covered a lot of questions, those questions that I have also prepared and questions that we also got from our viewers. So any last message that you would like to share with our viewers, anything regarding how they can be staying updated, or any message regarding today's episode?
Well, you can always follow our blog at www.polakimmigration.com, where we're always posting updates on various current topics. If you are entering the H1B lottery this year, get with your attorney, get with your entering those accounts with USCIS as soon as possible, and to register your account right now. Start getting all your documents together. The lottery begins on March 7th through March the 24th. So it's very important that you get key documents and information to your employer, attorney, as soon as possible. Good luck.
Absolutely.
Good luck with the lottery this year.
Let's see what happens. Maybe we can't find lottery system this year because Trump is so much, I would say, aggressively, he's putting up those executive orders. So maybe, he can remove those different system that he doesn't like at all. We can't say anything. But that's
I don't
okay,
think
Karen.
we've got
Thank you.
enough time to do that.
Oh, okay.
Oh, you're very
But
welcome.
mhm.
Thank you for having me.
All right. Okay. Thank you so much, Karen, for being here. It was really lovely having you. And as always, it has been really productive and very insightful because we didn't cover only one aspect of today's topic, but everywhere, how international students will be, how international relations will be, the future, how the future will look like, how the past experience also. So we have covered a lot of different subtopics in today's episode. And that was really insightful as always. So thank you so much, Karen. We really enjoyed this session, and we hope to see you soon again.
Okay, take care. Good luck, everyone.
Absolutely. All right. So thank you so much, everyone, for being here. It was really lovely having a very great conversation with attorney Karen Lee Polak. And we'll come back again with another very exciting webinar. So put up all your questions and let us know also what topics you would like to cover in our next webinar. And we'll make sure that we are definitely going to talk about those topics, because I know most of our viewers are really concerned about how the future will be, or what should you expect, or how you can keep yourself secure and protect yourself, especially your immigration status. So don't worry at all, because we are here to make you guys updated regarding the immigration policies and also the global politics around the world. So make sure to like, share, and subscribe to Immigration Talk Show. I'm Sam, signing off for now. Goodbye, everyone, and take care. Thanks for joining.
Bye-bye.
Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm really happy to be here. I'm Napasa Pradhan, your host for today's session. And before we start off with today's webinar and we have our guest join us, I have this very important disclaimer. And that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, thank you so much for joining us. We are live right now on YouTube, LinkedIn, Facebook, and on X. Please feel free to join us by commenting. And another best thing is that you can join us to even have a one-on-one discussion or maybe ask a question to our guest directly by joining us on this phone number. And the number is 425-436-6335, and the access code is 988888. And once you're in, just speak. We will be able to hear you. So, yes, today's webinar is on this very, very important topic about, how is Donald Trump's proposed 2025 agenda and how could it reshape the immigration policies in the US? So it's going to be very nice that, we are going to be discussing further on this, all the way from the stricter border measures to potential changes with work visas and even family-based immigration. So everything about immigration today here and what we can expect this year, 2025. And to help us, make sense of this topic and this discussion, we have a very, very special guest today, and she is none other than attorney Ingrid Perez, who is an experienced immigration expert and an advocate who has guided countless individuals and organizations through the various complexities of U.S. immigration law. So, Ingrid, welcome back. So good to have you back. So good to see you. And it's a pleasure to have you on our show.
Likewise. Thank you for having me again.
Really good to see you. And I wonder, how's everything going at IBP Immigration Law?
We're very busy, starting off the year really well. Thank you for asking. And our team is growing, and we are excited for, a very interesting year ahead for sure.
Me too, me too. And all the very best. Let's hope 2025 is going to be awesome. So all the best to you and everyone out there at IBP Immigration Law.
Thank you.
So coming back to our topic of discussion, Ingrid, if you can just give a short overview, to our viewers out there so that they can stay with us, as in what can they expect in today's session?
Sure, absolutely. Well, I think, based on the first Trump administration, there's a lot that we can predict that is going to happen. For sure, we all know that Trump is a critic of family-based immigration, and we can anticipate some additional scrutiny on requests for waivers, for like that. And I think also heightened scrutiny for visa applicants from certain countries and in certain U.S. embassies. I think we can definitely expect that. There have been, reports of Trump wanting to implement some executive orders on day one, things like ending birthright citizenship, and deportation orders starting day one. So I think that is going to be something that he's probably going to focus on. However, we stand to see what's actually going to happen as a result of these executive orders, because a lot of these orders and policies can often be challenged in court. So although, Donald Trump may want to do all these things, I think there's also legal challenges and procedural challenges and practical challenges, especially when it comes to mass deportation. ICE and our infrastructure can simply not handle the level of deportation that he has promised. So it's interesting, it'll be interesting to see what happens with that promise.
Very, very well said. And this brings me to our first question, which is very similar and about the deportation and illegal immigration. So how do you think, Trump's 2025 immigration plans, especially with which is focusing on illegal immigration and even mass deportation, how's it going to affect work visas as well, like H1B and H2B for foreign workers, especially from India? Ingrid, are you there? Well, I guess there is some connection issue, but yes, we are definitely going to take this up, and we would love you to join us also by commenting if you have any
I'm here.
Yeah. I don't know what happened, but you were frozen for a while. Did you hear me
Oh,
ask
no
the
problem.
question?
Yes, I did. So, in regards to the connection between the illegal or undocumented immigrants and the work visas, that's an interesting question, because immigration is really such an expansive area of, law. And we have work visas, we have permanent residency, and we definitely have a lot of issues at the border. And I think that, the Trump administration will focus on the priorities that he has promised, which is to curb illegal immigration, border crossings, and secure the southern border. A lot of resources have to go into that, right? We can expect a lot of resources from different federal agencies to be put into maybe perhaps building the border wall or implementing new technology to protect the southern border and close it up. So, as far as any direct impact between illegal immigration and visas like H1Bs or H2Bs, I'm not sure if there would be a direct impact, but if his promise is to secure the southern border, and that is going to take a lot of money from government, we can perhaps see longer wait times. And also, I think, in keeping with his promise of stricter immigration, more scrutiny on H1Bs and H2Bs.
Right. And when we talk about H2B, I think Indians are already out of the question. But H1B, definitely yes. So I do hope that it's going to be somehow better. I mean, people in his team, some are supporting it, some are not supporting it, some are against immigration. So what do you think is going to happen?
Well, I think, the conversation around H1B specifically has been really interesting, over the last few months. And I think that there's also a lot of wrong information out there about H1Bs. The conversation seems to be, centered around this idea that H1Bs are only for Indian nationals, which is not true. H1Bs is mostly used up by Indian nationals because of the per country limit on green cards. And unfortunately, Indian nationals have no choice but to be on H1B for years and years because they are lawfully discriminated against when it comes to getting green cards. And the backlogs are, insane. So that is just sort of, a result of this very unfair and unjust system. So we do have some level of legalized discrimination against Indian nationals and other people who fall outside of the rest of the world, column in the visa bulletin for sure. And this conversation around that H1Bs is only for tech workers.
For some reason, we are having a connectivity issue, but I do hope Ingrid is going to be back. And folks out there, please, participate as well. You also can join us by commenting in whichever platform you're watching. And we are live right now on YouTube, LinkedIn, Facebook, and on X. So please feel free to join us. And you can even join us on call by dialing this number 425-436-6335, and the access code is 988888. Today, we are speaking about how could Trump's 2025 agenda reshape U.S. immigration policies. And Ingrid is back. So sorry, Ingrid. Somehow there is some.
We'll deal with it. I mean, it is what it is, right? We'll keep the conversation going. But I think we were talking. Yeah, but going back to that very important conversation where we were talking about the misconceptions that this Twitter war has sort of unearthed, right? This idea that only Indian nationals have H1B visas, which is absolutely not true, and also this idea that only technology workers get H1Bs, which is also not true. It is true that many tech companies do workers and companies, nonprofits, universities, colleges, hospitals that have H1B workers.
Yes, for sure. And starting today, 17th of January, we have some new rules which we are going to discuss a little further, a little later in this show. So stay with us, friends. So, Ingrid, the next question to you is, if you could tell us, what will the impact be, with Trump's proposed immigration crackdowns, which are going to be impacting temporary work visas as well, like H2B, and how will it affect Indian workers who are really seeking opportunities in the US?
Well, I think under Trump 2.0, we can expect a lot more scrutiny in the workplace as well, which is something that I think is important to talk about. The Trump team has talked about workplace raids, making sure that employers are employing people with work authorization. So we may see some of that as well. As far as the H2B, program itself, this program is already very highly scrutinized. Employers have to jump through lots of hoops to get H2B workers. I think that temporary visas like the H1B, the H2B visas, I'm unsure if we're going to see the impact right away, especially because I think that the initial focus will be on undocumented immigrants and perhaps the border. But we stand to see. I think that the tides have turned a little bit about the conversation with work visas, and we see Trump saying some things that are very different than what he said before, that he likes H1Bs and that he, uses H1Bs, even though I think really what he was talking about H2Bs, H2B workers in his hotels. So I think that, if the tides really are turning, there are definitely people within the Trump administration who don't want any immigration at all. But we stand to see, because I think there's lots of competing interests now with this new Trump administration.
Right. Thank you. I mean, yes, from what you have told us, very, very true. And thank you so much for, taking that up. My next question to you, I have is how could Trump's immigration policies, including mass deportations, though we spoke about it a little earlier, but if you could elaborate more, and stricter enforcement, with his team being like, we have the border czar and we have so many others in his team, and how are they going to affect Indian nationals who are already in the US and on work visas or student visas?
So I think Indian nationals in the United States with student visas will definitely be seeking opportunities to stay in the United States. And usually that is done through an H1B. And it is difficult to find an employer who is willing to sponsor you for the H1B. And getting an H1B in and of itself is difficult because we have a lottery that a person has to enter into in the beginning, in March of every year. And if they are, lucky enough to be selected, the employer has to file a petition. There are lots of hoops and jumps, and it is an expensive process that is controlled by the employer. So I think for Indian nationals, they need to be thinking about this transition from F1 to potentially an H1B very early on in their careers, taking advantage of any OPT, or STEM OPT time that they may be able to get, and really start thinking about transitioning to H1B very early on. As soon as they, start working. And I think that mass deportations and stricter enforcement, perhaps not so much mass deportation, but stricter enforcement will certainly lead to greater scrutiny on H1Bs. And this new light that has been shed into H1Bs that unfortunately has a lot of misconception and a lot of, the Trump base upset with H1B workers and the H1B visa, right? We could see higher scrutiny in H1B petitions and perhaps maybe more denials like we've had during Trump 1.0. I think during the first Trump administration, the denial rates were a lot higher, significantly higher. If I'm not mistaken, I think I saw a statistic that in 2020 it was about 26.6%, as compared to the recent years where it was a lot better for H1B workers. So I think that starting early on, ensuring that the work and the employer that you are going to be working with is a legitimate employer, because there is a lot of, H1B fraud, and there is a lot of problems in the system. That is certainly true, and there's a lot of criticisms to be made and a lot of improvements that could be made. So I think ensuring that the student here who's in the United States seeking the opportunity is also very well informed and educated on the process and what they need, so that they can protect themselves from this heightened scrutiny. Because as we all know, the U.S. government doesn't give you a lot of flexibility if you're running out of time here in the United States, and that's really important to keep in mind. And have a plan B. If you're not selected for the H1B lottery, what are you going to do? Are you going to Canada? Or are you going back to school, get back on your F1? Having a plan B is very important, because unfortunately, H1B is just not a reality for everybody. But, another possibility is exploring H1B capped exempt positions. And of course, these are perhaps a little bit harder to come by, and the employment opportunities not so much, but that is a way to circumvent the lottery for those that are able to get a capped exempt job.
Right, right. And we also hear about the cap gap being extended from October fiscal year to the 1st of April the next year. And apart from that, we even heard like, schools are taking measures to not just give out their immigration status to anybody and everybody. Have you heard the news too, Ingrid?
Are you talking about giving I-20s to students?
No, I'm talking about, how the schools are protecting the students who are immigrants. And yes, the school rates. I'm talking about the school rates. And,
Oh, yeah.
yeah.
So, I mean, there are places like historically that, like churches, hospitals, schools, where ICE is not supposed to go in and do immigration enforcement. So we'll see what that looks like. I mean, I think there's a lot of information out there meant to scare people and a lot of talk, but we just don't know. We're really entering a world of uncertainty. And I think that if it plays out in the real world where ICE is going into a place of worship or a school and doing these things, I mean, I think that there's going to be a lot of backlash. At least I would hope that there is a lot of backlash. And if Donald Trump and his administration are serious about, protecting US borders, perhaps they should focus on the border itself, or perhaps enforcing deportation orders for people who are a priority to be removed and not.
Okay, so I think there is again a connectivity issue, but I would really like to say hi to folks out there who have joined us. And hi, Rohan. Hi to Vikas. Thank you so much for joining us. We're going to take up your questions. Please stay with us. And Ingrid is back. So, Ingrid, please carry on.
Yeah, so what I was saying before is, if we see immigration raids in places where, people are worshiping or going to school or hospitals, I think there will be backlash, and I hope that certainly there will be backlash. And I don't think that should be the focus, but we stand to see. There's a lot of competing interests, I think, at least what we've seen with everything that's going on in the news and X and different people with the incoming administration. So we'll see what happens. I certainly hope that immigration raids does not happen in places where people go to worship or school or to get medical treatment. But we'll stand to see.
Yes. It's too early to say, but folks out there, I think, yes, there are a lot of changes coming up, especially with the new administration starting 20th of January, since Trump is hitting office on that day. But it's too early to say. We will need a buffer time. I mean, first off, he will start taking his actions only sooner than later, I think. So we'll just have to wait and watch. But very rightly said, Ingrid, that there's so much news out there, and so many of those news are really scaring people, especially immigrants or people who want to go to the US to live their American dream. All right, now next up, I have another question, and if you could tell us, the new immigration policies under Trump's 2025 agenda. I mean, stricter requirements for H-2B visas, and how could this impact, the Indians and people from other countries as well?
Well, I think anytime you have stricter requirements for any type of visa, the hurdles are definitely going to be harder for anybody trying an opportunity in the United States. I think also a potential impact is employers will be less willing to go through this process and find workers. However, I think if you're unable to hire H-2B workers and other temporary workers, and we are unable to find the American workers that can do those jobs, the economy will take a hit. I think that comprehensive immigration reform is important. However, we have to consider every aspect of our economy as well. And immigration, smart immigration policy really responds to the demands of of the labor market. And I think the H-2B visas are, a great way to supplement the workers that we need here in the United States. I mean, even if you look at, for example, what's happening in California with the wildfires and the fact that California now completely needs to be rebuilt. We do not have the American workers here in the United States to help rebuild California after these tragic wildfires.
Right, Ingrid. Thank you so much for bringing that up. I mean, California is suffering, and there's so much loss. Everybody, celebrities, common men, and people out there. There's just been so much destruction, and it's still going on. I mean, we keep hearing the news updates, and I really hope and pray that that people find strength in all these difficult times. And Ingrid, if you're back, so yes, you
Yes.
were talking about the California wildfires.
I don't know what's going on with my Wi-Fi, so I apologize. But, in regards to California, we don't have the American workers. We don't have enough workers in the United States to be able to reconstruct, and rebuild California. And construction companies rely heavily on H-2B workers to come do these types of jobs. And I think that is, such a benefit and a value to America to have these workers come in, do the job, do it quickly, do it well. And these are temporary jobs that really fill a need. So, that is one example, for example, where, America really only stands to gain from H-2B workers. I hope that the incoming Trump administration can realize that and not, make this process extra burdensome for the employers and the people that would really benefit from H-2B workers, not just the workers themselves, but also the American people that only stand to benefit from their labor.
Yes, so true. And when you just talk about in general, I mean, immigrants are also creating jobs. They're coming to the US, creating, I mean, I'm talking about entrepreneurs, they are creating jobs for many others out there. So I think, yes, it should be like a win-win for everyone and not make it difficult for both the parties.
Yeah.
All right. So, yeah, yes. And let's go back to my next question, coming back to our discussion. So, how do you think Trump's stance on birthright citizenship and mass deportations affect family reunification for Indian immigrants, especially those who are waiting for green cards? And there has been a lot of backlogs for years
Yes.
now.
Yes. So that's a really great question because Trump has famously said that he's going to end birthright citizenship, even though that is guaranteed in the 14th Amendment of the Constitution. And he said that on day one, he will, issue an executive order ending birthright citizenship for children whose parents are here in the United States without documents, whose parents are here in the United States and are undocumented, which clearly by the language of the 14th Amendment, that is unconstitutional. So I think that is not going to hold up if it's, scrutinized. I also was watching and listening to the Attorney General's confirmation hearings, and she was asked the question, what are her, does she believe that the 14th Amendment protects birthright citizenship? And she refused to give a straight answer. She said that she had to study birthright citizenship in the context of the 14th Amendment, which I think is a very alarming and disturbing question, because if you are getting the job to protect and defend the Constitution, and here you are saying that you have to study birthright citizenship in order to give an answer, I find that alarming. So, I mean, I think that is one of those things that Trump, famously does. He says a lot of things to spark debate and cause a stir. I think if he were to issue an executive order ending birthright citizenship on day one, it will be taken up by the Supreme Court, and I think it will be struck down. So, he will get to say, well, I tried and they, didn't let me. I think that's the strategy behind that. And of course, we'll see what happens. I mean, I don't think that's going to stand. So, what I understand is that this executive order is meant to strip away birthright citizenship from children whose parents are here in the United States without documents, and not necessarily for people here with H-2Bs or H-1Bs or different visas, but we will see.
Yes, we will. It's too early to say. We still have about 3 more days for Trump really joining office. So I wonder how's it going. I know people have been so anxious and especially till before the elections and even after the elections, there's so much news to only make them more anxious. So,
Yeah.
uh, yes. So, do you have anything to say? I mean, 3 days early before Trump joins office.
Oh, wow. We've been down this road before. I think that during the first Trump administration, immigration was very challenging. Practicing immigration law was very difficult. It was very frustrating. So we've been down this road before. I think that the immigration bar is prepared to fight and advocate on behalf of immigrants. I am also perhaps cautiously optimistic that there have been some voices that are emerging and talking about high skilled immigration, H1Bs, and the need for skilled immigrants in the United States. Perhaps there will be some attitude shift on those fronts. I do think, though, that Donald Trump's priority is, undocumented immigrants, the border, and scrutinizing more family-based petitions and visas, and perhaps visa applications from people from certain countries or certain religions. But so I am somewhat optimistic, cautiously optimistic, that employment-based immigration will continue, be stable. However, I think if anything has taught us that over maybe the last six months or so, we have seen so many a request for evidence for people applying for, petitioning for EB1A visas. We had this really great 2022 executive order on STEM from the Biden administration that really was supposed to be a way to attract more STEM workers in the EB2NIW category. And it was great for a little while. And I think the floodgates opened and immigration perhaps had a little bit of buyer's remorse. And the last 6 months or so has really shown us to be very challenging when it comes to EB2NIWs and people trying to file self-petitions because the perm is taking so long, or perhaps because, people are here on H1Bs and they need an approved I-140 to be able to extend the H1Bs. And I see that USCIS has been very unfriendly to people in technology and especially people who work for big tech companies. So there has been, some shifts that were not necessarily, in my opinion, in the positive direction, in the way that the STEM guidance was supposed to, make EB2NIWs more friendly for STEM professionals. And we have to learn to adapt. So just the same way that we learn to adapt, in an administration that was supposed to be friendly towards immigrants, we'll learn to adapt again in an administration that is, not so friendly to immigrants.
That's so true. That's so true. But I do hope that they are going to be at least how to say, they will have change of minds, change of ideas with Elon Musk also in the team, and yes, Sri Ramakrishnan and so many others in the team. So I do hope that he will change his ideas, and let's hope for the best for sure. All right, Ingrid. My next question is also, what changes in green card allocations could occur in Trump's 2025 immigration plan, particularly for skilled workers in sectors like IT and healthcare?
That's a great question. I mean, one way to perhaps, improve the system is to get rid of the per country cap. For sure, that would delay other nationalities' ability to get a green card, but I think it would even the playing field for a lot of people, especially Indian nationals, who's stuck in this backlog that is really absurd. So that is something that could happen. For skilled workers in IT and healthcare, I think those are just two very distinct fields. For healthcare, for sure, there's a lot of shortage and different opportunities for people in healthcare to perhaps get cap exempt H1Bs, and maybe explore other avenues for permanent residency. For IT, I think that is a more challenging industry because we see a lot of layoffs for people in technology, and we see a lot of people in IT and their positions being sent offshore. So I think for IT professionals, it's a lot more challenging. especially, a lot of IT professionals work as consultants for, one company that hires a lot of employees on H1Bs, and then they subcontract these people out to different customers or different companies. So it is a completely different industry with lots of challenges. And I think, self-petition options like EB1As or EB2NIWs, if an employer is unwilling to sponsor that professional for permanent residency, becomes a little bit more challenging, especially I think now that we saw the EB2NIW policy update, or the policy guidance update from a couple of days ago, that talks about people in technology, and how the benefit, for example, for an EB2NIW really cannot be for the employer. The benefit for an EB2NIW really has to be broader. And I think it makes it a little harder for IT professionals and people in technology to perhaps self-petition and be able to get their green cards on their own.
So true. Thank you so much, Ingrid. And IT and healthcare, these are two sectors where we see a lot of immigrants coming in and who want to work and live their American dream. So before we go on to our next questions, I would really like to take up some of our audience's questions because they have been waiting. So let's take up Rohan's one first. This is on YouTube. And Rohan is saying Trump has talked about tightening immigration laws and reducing the number of refugees. How would this impact individuals already residing in the US who might be waiting on asylum or refugee status or seeking other pathways to legal residency?
Well, I think the immediate effect will be most felt by people who will be seeking those benefits after Trump implements any changes. During the first Trump administration, we saw people who were applying for asylum get interviews in as little as 3 months. So there was a policy where, if you were applying for asylum, they would give you an interview really quickly. The idea was to get you in and out really fast. And that actually caused a significant backlog for individuals who had filed asylum applications and had been waiting in line for quite some time. So, I talk to people all the time, especially people from Venezuela who came to the United States maybe 8, or maybe 10 years ago, filed for asylum. And before Trump, and after Trump, they were stuck in this queue waiting for their interview because of so many people applying for asylum and getting their interviews earlier. So I think it may have, if that's the policy he's going to go back to, it may have an impact more on the people that will be applying after any policy changes, perhaps not so much the people who are applying before. But of course, if there is greater scrutiny, on asylum applications, TPS, seeking refugee status, then for sure that would apply to people whose cases have not yet been adjudicated. So it's important, I think, to be informed and work with your attorney to keep up with whatever latest policy there is, because these cases take so long to be adjudicated that you want to stay on top of it. You want to stay informed.
So true. Well, thank you so much for taking this up for Rohan. And Rohan, I hope you got your answer. And if you have any more questions, you can keep commenting. And why don't folks out there who are watching us, why don't you join us on call? Our phone number is 425-436-6335, and the access code is 988-888. All right. So now let's take up Vikas's comments. This first one is on Vikas is also on YouTube. And Vikas is asking, I've been working on an H1B visa for several years and have reached the 6-year limit. However, my employer is unwilling to sponsor my green card application due to company policies. Meanwhile, I received a job offer from another company that's willing to sponsor my green card. Yes, but it would require me to take a significant pay cut. What are my options for staying in the US? And how can I weigh the pros and cons of each choice to make an informed decision about my career and immigration future?
So if you're in your 6th year and you don't have an approved I-140 yet, it's going to be very difficult to have an employer file a perm for you and get an approved I-140 so you can take advantage of, an extension that goes beyond the 6th year. However, if you are somebody who may be able to get an EB2, have an EB2NIW filed on your own behalf, you could perhaps consider filing an EB2NIW petition not premium process, and let it take the slow toll, and perhaps you can take advantage from 1 year increments of your H1B. I think that's perhaps a strategy that you could explore. However, this is not legal advice. I really would encourage you to talk to an immigration attorney to see if that is a possibility for you. But there is a section of our laws that says that if you have a pending I-140 and you're in your 6th year of H1B, you may be able to get extensions at 1 year increments. Aside from that, it's very difficult to perhaps stay in the United States longer without an approved I-140. You may have to explore perhaps, a different visa, but it sounds like you perhaps are coming towards the end of the road. So, I would weigh the pros and cons between, seeking an EB2 NIW on your own, so you can take advantage of those 1 year increments, or, considering the job that your employer is willing to sponsor you for perm, see what that is going to look like, right? And consider perhaps taking the pay cut so that you can stay in the United States. I think it's a fine balancing act, and you have to really understand the options you have to make the best decision for you.
But there you go, Vikas, and I hope you've gotten your answer. Thank you so much for commenting, and please keep commenting if you have more questions. Let's take up Kavya's question now. Hi, Kavya. Thank you for joining us on YouTube. And Kavya is asking, given the current immigration landscape, do you anticipate any changes or updates to the IR3, IH4, IH3, IR4, or IH4 visa categories in the near future? And I'm asking because a family member is considering adoption, and I'd like to understand any potential implications for their planning process.
So I think that what Trump is, he does scrutinize immediate relative or immigrant family visa petitions. So I think that there may be greater scrutiny on those petitions to perhaps establish the relationship between the petitioner and the beneficiary. I don't see any significant changes in the way right now that the visa categories will be perhaps affected in the future. I do think that there probably will be significant delays, because if people are outside of the United States waiting for, these visas, their priority dates to become current in order to apply for the visa, there may be some significant delays. So I think people need to manage their expectations and not, sell their house and pack up all their belongings to move to the United States. It's going to be a waiting game. It's going to be a waiting game at the U.S. embassies for sure. It's definitely going to be a slow process.
Yes, yes. And with all these new changes, I think, anytime there's a new change, a new rule, or maybe even a form update for that matter, I think it takes a little buffer time so that things are, again, followed the correct way, seeing that, the forms are right? Ingrid, what do you have to say from past experiences?
Yeah, for sure. And I think that, like, for example, today there's a new I-129 form that goes into effect without any real buffer time, right? So I think that you need to stay on top of this stuff to know what's going on with immigration so that you're not causing delays because you're just not aware of any changes. So I think that's really important. I think it's also really important to make sure that your information is correct in every piece of any form, any documentation that you submit to any government agency, because they will be cross-checking and using a lot more technology to make sure that your information matches everywhere, because I think they're going to be looking for a lot more fraud and a lot more misrepresentation and doing a lot more scrutiny and perhaps using technology to do so. So I think it's really important to be incredibly detailed oriented and take your time up front so that you're not wasting time later on trying to correct errors.
EPS, right, from Sudan, Ukraine, and even Venezuela. So that too, I think we have new updates. So folks, I think I would always appeal to you to, do your research and stay updated with all these latest new rules, new updates, so that, you don't miss out on them. You're on time. And yes, I think that's it for now. So, Ingrid, let's come back to some of our questions since we have a little more time, and I do have more questions actually from our Facebook. And I would also like to say, folks out there who have joined us, you can even contact Attorney Ingrid Perez from IBP Immigration Law, and her phone number is 407 906 0068, and her email address is info@ibplaw.com, and go visit www.ibplaw.com. So, Ingrid, coming up, my next question to you is, how will Trump's proposed visa vetting process impact Indian workers who are applying for US visas or permanent residency, and what could this mean for, their chances of approval?
I think similar to what I was saying before, we can expect a lot more technology and scrutiny in any visa application. So I think that people that are applying for any visa, no matter whether they are abroad or in the United States, or applying for any green card here in the United States, or any petition, anything like that, should really take their time with ensuring that everything is correct, that the information matches everywhere. You don't want to inadvertently make a mistake on your form or on your application or petition, which will cause a delay and a headache later on down the road. And I think that also, plan for delays, and understand that it is going to be probably a lengthy process from now on.
Okay, am I audible? I don't know why am I stuck though.
Can you hear me?
Ingrid, can you hear me?
Yes, I can hear you. It's just you're frozen.
Yes, for some reason I am frozen. I do not know what is the problem, but I can take up this next question, and as you answer, I could join back. So, my next question to you would be, how will Trump's 2025 focus on border security and immigration enforcement affect Indian students who are looking to study in the US?
I think for
Who have-
Indian students looking to study in the US, they're going to be applying for their visas at a US embassy or US consulate. And I think similar to my last answer, it's important to plan ahead, plan for delays, and ensure that all of your documentation, your I-20s, your applications, your DS-160 is done, really, really well. I think those will be scrutinized. Another thing also that is important to note is that the upcoming administration said that they will be denying student visas and kicking people out of the state who perhaps support Hamas, right? So making sure that your social media is not showing anything like that could potentially be used against you, I think is also really important. And unfortunately, that is just where we are right now. I think Marco Rubio said something like that they will be, not issuing student visas or kicking people out of the country who perhaps are friendly to these organizations that the United States do not support.
Okay, very, very interesting. And well, I really want to just say, just don't be scared. I really hope that you are abiding by the rules and the laws, and there should not be anything to be so worried about. So, thank you so much. Yes, and folks out there, you can join us, and I think we will take a short break for now. But before that, I just want to tell you that you can also connect with us, and for that, you can call us on our number, and the number is 425-436-6335, and the access code is 988-888. And once you're in, you'll be even able to speak with Attorney Ingrid Perez directly, since we are here for a couple more minutes. So why don't you join us to ask your questions? The line is on, and yes, we'll be very happy to have you. And also, you can contact Attorney Ingrid Perez, and you can do that by dialing her number 407-906-0068. That's her number. And her email address, in case you want to contact her for your case, you can email her at info@ibplaw.com, and go visit www.ibplaw.com to get to know more about Attorney Ingrid Perez and IBP Immigration Law. And well, another thing is, you can also contact me. You can WhatsApp me on my number, and you can even call me on my number. And my number is 408-335-6444. And my email address is nipa at staffingly.com. So please feel free to join us and call me, tell me about yourself, tell us about your case, and we can direct them to our attorneys directly. So, yes, coming back to our questions, and Ingrid, we also have some more questions from people who have joined us on Facebook. So, Control, if you can display them, please, we can take them up. So, this question is from an anonymous member saying, "Hi, all. Is it worth doing day one CPT if H1B is not picked in all three attempts?"
Oh, that's a tough question. That's a tough question to answer without really knowing your individual situation, because day one CPT can be beneficial for many people, but you also have to be very careful with day one CPT because it is, it does sometimes cut into any other work authorization time that you may have in the future. I would perhaps not be in the best position to answer this question without really understanding your specific situation and what your future plans are, because I think if you're planning on doing day one CPT, you really have to have a vision for the future as well. And it's unfortunately a little hard to answer this question without really knowing a lot more about your situation.
Yes, yes, I feel that. Yes. So, folks, whenever you tell us about, whenever you have a question, it would be really nice to get more details about yourself, your case, where you're at, and more details, basically. So, all right, let's take up this next one. Control, please. So, my immigration team mentioned that nowadays there is lead time of 4 to 6 weeks to receive the RFE after USCIS sends it. Wonder if that would eat into the response time of 60 days. Is there a way to know the nature of the RFE? According to them, they can't tell until it is received in mail. I was in Canada at the time they received the petition amendment. Curious if it could be related to that.
So I don't think that it could be related to the fact that you were in Canada, but for sure, getting receiving an RFE 4 to 6 weeks after it is issued will cut into your time, and it does disadvantage you significantly, especially if immigration is requesting a lot more information on your petition. So I'm surprised if something like that happens. I would definitely work with your attorney to make sure that you respond to that RFE as soon as you can, and document all the attempts that perhaps you have made to contact USCIS to get a faster RFE in the mail, so that you can take advantage of all the time that you're given to perhaps respond to the RFE. And yeah, it's difficult to know what's in the RFE until you actually get it. But I think that if you don't get it within, if you look at the USCIS website and it says they sent you an RFE and you don't have it within like a week, I would definitely be contacting USCIS to request a second copy and documenting all of my efforts that I've made to contact USCIS and get that RFE. I would definitely do that.
Thank you so much, Ingrid. I mean, I'm sure that would be very helpful. I wish we knew the name, but it was an anonymous person. So, yes. Let's take up our next one. So, I had recently traveled to US on H1B and only in few days got laid off, and today returning back to my country. I have few questions. How can I know if my H1B is cancelled or revoked? And the second is, in future, can I transfer or renew H1B with other employers? And the third is, will I get salary and pay slips for these few weeks? And if I am eligible to apply again for H1B, what documents required for me? What documents are required?
Okay, so let me try to answer as best as I can some aspects of this question. Should you be getting paid? Yes, you should get paid for the time that you worked for your employer, for sure. If you don't, you should seek an attorney to help you recover the money that you were not paid. Those are unpaid wages that you earned. So you should definitely be getting paid. Usually when you are let go from a position, you have a 60-day grace period. Sounds like in this case, you left the United States. So you don't have that 60-day grace period to be here in the United States and look for another H1B position. If you have an H1B, you can, if you have H1B time left, you can get another employer to file a petition on your behalf so you can get another H1B position. You can certainly do that. As far as documents that you need, I mean, that is going to be very specific to your case, but usually when an employer is filing an H1B petition for an employee and it's a specialty occupation, we need the employee's diplomas, evidence of maintaining lawful status when you're here in the United States, information from the employer, for ability to pay, things like that. So you need a whole new petition, from a new employer, and you can get back to work on H1B.
Right. Anything else you want to say on these questions?
How can I know if my H1B is canceled or revoked? Well, if you have the H1B, you're not going to be able to come into the country later on with the H1B unless you have an employer. If your H1B is revoked, if immigration decides to revoke or cancel your H1B, you'd be getting a letter. But other than that, if you're outside of the United States, definitely maintain and keep all of your H1B approvals so that if you are going to get back on H1B, you can do so.
Okay. Thank you so much, Ingrid, for taking that up. And I think with that, we have covered all the questions from our audience. And also, I would like you to share with us if you have any experiences, especially related to immigration, or any case study from your end that you would like to share. That was very interesting.
Yeah, so recently we did an H1B cap exempt for an Indian national working for a playwright a theater company, which was a really interesting case to work on. This person did have an H1B denied before they came to my office, and we were able to get this H1B approved, the cap exempt H1B, which is really wonderful because she did not have to go through the lottery. I think that, there is this idea that H1Bs is just for a specific type of occupation, or, the most prestigious or mostly high skilled occupations. And it can be, perhaps it should be, I don't know. However, the H1B is really designed for professionals. And I think sometimes that, you can be creative with the H1B strategy in order to really show immigration that the job that you are coming to do is a professional position that qualifies for H1B. So I would just say for people that are, maybe not selected to the H1B lottery, or people who are stuck or perhaps don't know what to do, an H1B capped exempt position may be the solution to your problems. And I would also start thinking about ways to secure your permanent residency here in the United States very early on in your career. And also one on the last note, since we talked a little bit about students, right, wanting to come to the United States, I think for students who want to come to the United States and study here and take advantage of the employment opportunities, it's really important to understand and study the labor market, to understand and figure out an area that, is really in demand. Because what we see is that for a lot of technology companies, there's significant layoffs. And if you're here on H1B, you could be affected. Not only can you get laid off, but your employer may not be willing to sponsor you for the perm if they have mass layoffs. So I think it's really important to, plan your immigration from the very beginning. Beginning with the degree and the area of study that you're going to be focusing on, so that you have the best chances of permanent residency in the United States through your job.
Thank you so much for sharing that. And it was a very, very interesting one. Ingrid, thank you so much. And I think we just have two more comments and we'll just take them. Vikas says, thanks for the information. And thank you, Vikas, for joining. And we have Luwain, if I'm pronouncing it right. Luwain is asking, hello, what kind of changes can we expect on EB1 and EB2 with Trump administration?
Well, Trump famously said that he thinks everybody who graduated from college here in the United States should get a green card stamped to their diploma. So, I'm hopeful that, or I'm, cautiously optimistic that under the new Trump administration, we're not going to see perhaps many new restrictions on EB1s and EB2 and IWs. You know, we saw that through under the Biden administration, there were so many executive orders and guidance meant to make EB1s and EB2s and even O's more attainable for STEM professionals to, you know, maintain America's competitiveness in these STEM fields. And then, you know, the people responded and people applied for these benefits, and immigration sort of had to, you know, a little bit of, you know, recalibration as far as the way that these cases are adjudicated. So, you know, what can we expect? I'm hopeful that, you know, the tides have shifted a little bit. The conversation around employment-based immigration and high-skilled immigration, you know, have shifted. People are a little bit more aware of the benefits that these professionals bring to the United States, and really the need, right? We really need people with specialized knowledge and, you know, advanced degrees, and people here with, you know, EB1 extraordinary ability, you know, achievements and things like that to push so many different industry sectors forward. So I'm hoping that, you know, there won't be any changes. But I mean, you know, I think Stephen Miller, who was in the Trump administration, said that they will be restricting these kinds of, you know, petitions as well. But we stand to see. I haven't heard anything much about this. I think that, you know, we have had some recent guidance, and I think we need to adjust to that a little bit. You know, I won't be surprised if we see something, you know, right away, but we'll just have to wait and see. You know, I think under Trump, EB2s were, you know, they were friendly towards, you know, entrepreneurial endeavors and endeavors of that sort. EB1s received very high scrutiny, and they still do. These are hard visas to get. So, you know, we'll see if anything will change right away. I think it's going to take a little bit of, you know, the dust needs to settle a little bit with the recent changes, especially with the EB2, so that we can see what, you know, what immigration is going to do.
Yes, yes, so true. Thank you so much, Luane, for participating, and Ingrid for your answer. And okay, we have one more who just jumped in just now. Hi, Dio. I don't know, but I hope I'm pronouncing your name right. But this will be our last question for the day, Ingrid, if that's fine. So yes, we have Dio asking, "Hello, I'm an artist from Dominican Republic, and I would like to move to US to continue with my music career. Is there any way to change my visa B1 to B1 B2 to work permit so I can perform in different places?" Yeah.
So artists do have ways to come to the United States and perform. There are different options depending on the type of performance, how long you're planning to stay, what your itinerary looks like. You know, perhaps you could look into an O visa or maybe a P visa, depending on your specific situation. But for sure, I think it requires you to plan ahead, because you do need to inform immigration what your plans are, as far as, you know, the jobs you're going to be doing, the performances you're going to be doing. And you also need to make sure that you qualify for the classification that you were seeking. You're definitely not allowed to come to the United States with a B1, B2 to work, but there are options for artists. And I think it's important to perhaps talk to an immigration attorney and you know, assess your background, the types of evidence that you have to show that you meet the qualification, and then start making your plans here in the United States so you can present your itinerary to the immigration authorities and perhaps get that work visa so you can come and perform.
There you go, Dio. Thank you so much, Ingrid, for patiently taking up all of these questions from our viewers. And Luane says thank you. Thank you, Luane, also, you know, for participating. And I think with that, it's a wrap. And Ingrid, if you have any last notes, you know, to wrap up our show for today.
Well, just thank you for having me. And I really enjoyed having this conversation, and I hope to come back. And, you know, sometimes it's a little difficult to answer individual questions without getting into the details. But for sure, you know, I hope that the information has been valuable. And if people have any questions, they can definitely reach out to me. And I hope to be back.
Me too. And I hope to really see you very soon, hopefully this month itself. But yes, we will see what we can do and when can we have you back. But definitely, folks, you can also contact attorney Ingrid Perez by emailing her, and her email address is info@ibplaw.com, and her phone number is 407-906-0068. And go visit her website, www.ibplaw.com, to get to know more about IBP immigration law and also attorney Ingrid Perez. Thank you so much, Ingrid, once again. And here's wishing you a wonderful day ahead. See you soon.
You too. Take care. Thank you.
Take care, you too. Folks, thank you so much for joining us. And if you resonated with today's episode, please do not forget to like, share, and subscribe to our channel, Immigration and Jobs Talk Show. We are here on YouTube, LinkedIn, Facebook, and on X. Follow us, connect with us, and also you can contact me. You can WhatsApp me or call me on my number. My phone number is 408-335-6444, and my email address is nipa@staffingly.com. So feel free to connect with us. Thank you so much for joining, and don't go anywhere. Stay tuned to Immigration and Jobs Talk Show. Welcome, everyone, to Immigration and Jobs Talk Show, and I'm very happy to have you all join us today. I'm Napasa Pradhan, and I'm going to be your host for this session. And before we move ahead, I have this important disclaimer, and that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, it's really very fantastic to have all of you join us today. We are streaming live right now on YouTube, LinkedIn, and Facebook. And I'm very excited to tell you that this could also be a very participative session. All you have to do is type in whatever questions you have in the comment section, and we'll be very, very happy to take them up in this session later. For sure. And today we are going to dive into this very important discussion on this topic. Can product managers and software engineers qualify for the EB1A visa? And it's a topic that is especially relevant for highly skilled professionals out there in the tech industry. And of course, I am very, very excited today because we are going to have one of our very special guests back with us, joining us after months, really. I think we met last before summer. So please help me welcome attorney Prashanthi Reddy once again back here on Immigration and Jobs Talk Show. Prashant, really happy to see you after a real long time, and really good to have you here. Thank you for joining us.
Yeah, no, thank you. Thank you to the Higher IT team for welcoming me back, right? And having me on another episode, another webinar. Thank you, Napasa, Zayed. Thank you for all the technical work you do in the background. I'm sure I'm going to have one technical difficulty at least. Otherwise, it would not be a webinar where I have participated. So if I pivot to my phone, don't be surprised at some point. But glad to be back.
Very glad to have you back with us, Prashant. And so, yes, today's topic, what can folks out there expect from us today?
Yeah. So today, one of the reasons why I think this webinar specifically around the EB1A is highly relevant, right? I know we've done a series of webinars before on this topic specifically, and it was very high level, right? Can folks in IT qualify for the EB1A, for example? And we talked about the EB1A process, application requirements, how people qualify. And I think this is a really good opportunity to start double clicking on very specific profiles, right? So for example, for today, we're going to be discussing how product managers, how software engineers specifically qualify. And I know behind the scenes we were discussing, doing an episode for like cybersecurity folks, data engineers, that sort of thing. And over the last several months, one of the reasons why I kind of disappeared from these webinars is because this part of my practice has really started to scale. And the reason was pretty straightforward. So since October 2022, EB1As have become a very hot topic, right? Ever since the retrogressions and priority dates happened. And I was working with one or two clients at a time over the last couple of years to help them get their EB1As approved. What happened earlier this year around the May, June timeframe, one of my clients who got his EB1A approved, he works at Meta. He went and posted internally in a Meta forum about his success with our firm, and then things just kind of exploded from there, right? So over the last, I would say 5 or 6 months, I've probably done twice as many EB1As as I did in my first, my last couple of years, where I've noticed this become a trend. Lots of consultations, calls. And so it's a really interesting time, at least for me, and I think the EB1A community, because there's a lot of best practices that I feel like I'm now uncovering as I'm doing this at a much larger scale, and with many, many more types of clients and different profiles and different case studies that I can bring to the table today, right? And of course, there have been some changes as of October in how USCIS is going to be looking at the EB1 criteria, and we can get into that. And then, of course, I know there's a lot of anxiety around, the presidential election and the recent results,
Right.
and we can talk about that too.
I was just coming to that, and I think before we head on to today's topic, maybe you could tell us how Donald Trump being elected the 47th U.S. president is going to affect even this category of visas, and it'll be great your point of view on this as well, Prashant.
Yeah. So there's a couple things to that. One is just like my personal experience, right? So like the very first EB1A I ever filed was for a dentist, and it was during the height of the Trump administration about 4.5 years ago, right? And he got approved just fine, right? I think when it comes to the next administration, what I saw previously between 2016 and 2020 was that there was impact for EB2 and EB3 candidates, right? Even H1B candidates. Reason being that there are different areas of that process where they can really influence what's happening, right? And what I mean by that is in EB2 and EB3, you have things like the prevailing wage determination, right? So they can slow that down. You have things like the recruitment process, right, which can really come back and hurt you, let's say at the I-140 stage. They have the perm application itself, in which they can increase their audits, right? And those are the types of things that we saw the Trump administration do previously, right? When it comes to EB1As and EB2 NIWs, I think any administration has a very keen interest in keeping the best and brightest people here in the US, right? And if you look at his rhetoric, it is all about, potentially changing rules, regulations as it relates to maybe asylum seekers, people illegally entering the country, right? But when it comes to these merit-based applications or these merit-based benefits like the EB1A, like the EB2 NIW, he really that's not a part of his rhetoric, right? I don't expect there to be a whole lot of impact for my EB1A and EB2 NIW clients, because this is a self-petition, right? These applications go directly to USCIS. You have nothing to do with the Department of Labor, so there's nothing they can influence there. It's just you and the officer and the case you present, in front of them, right? So I'd say from that perspective, I hope people aren't as anxious as maybe they might be coming off for EB1As and EB2 NIWs.
But definitely, I think everyone is anxious, especially immigrants out there, like what's going to happen. Some are really maybe even taking up actions before things get worse for them.
Yeah.
I mean, that's what their thought process is, I guess. So a lot of things are happening. I think people are still processing the whole
the whole information, Prashant.
Yeah, and I'm seeing it too, right? Like I've got clients who are like, can you take my case now? And I'm like, the earliest I can take it is at least January, right? Like I'm working with a cohort of people, that sort of thing. And I'm seeing a sense of urgency where people want to try and apply right away. And like our timelines are just not matching up, right? And that's okay. But I am seeing that sense of urgency where people are worried. But I think it might be a little overdone.
For sure. But let's head on to today's topic, and I got some questions prepared. So, Prashant, if you could just tell us, how might product managers and software engineers qualify for the EB1A visa? And this requires evidence for extraordinary ability in their fields. And what impact might Trump's previous stance on merit-based immigration have on their chances?
Yeah, I think that second piece I kind of covered in the first response, right? I think based on his rhetoric, whether it was the previous, from 2016 to 2020, or let's say 2024 or 2025 and, moving forward, I don't see an impact on merit-based applications, right? Especially not EB1As and not EB2NIWs. Again, any administration has a very high interest in keeping the best and brightest here in the US. Now, when it comes to qualifying, right, for the EB1A, for example, for product managers and software engineers, let's take the product manager profile first, right? Product managers are very interesting individuals because they sit at the intersection of IT and business, right? So one advantage that product managers have is that they can very easily and often, do very easily communicate the business outcomes that are driving their projects, right? The KPIs associated with it. What is the organizational impact? What kind of impact is my work having on the industry, right? And when you sit at that intersection, it's really important for at least two of the criteria: critical and leading role for a distinguished organization. Second one is original business contributions, right? Because we want to be able to prove that the work that somebody's doing is important at an organizational level, right? We want to be able to prove that the work that they're doing is innovative and also influential in the industry. So I think for those criteria, right off the bat, product managers are really well situated to satisfy those requirements. I recently had a product manager that I worked with. He's at Meta. He works specifically with networking technologies. Okay. And for him, we argued on 4 criteria: critical and leading role, original business contributions, judging the work of others, and then salary, right? And I often see for product managers, those are the 4 criteria that they are satisfying, that they are hitting, right? Most commonly. There might be others like memberships, awards, authorship, depending on the makeup of the profile. But at a baseline, those are the 4 that I typically see come across my desk, right? And, it's important, I would say, for critical and leading role to raise your projects that you've worked on to an organizational level, right? What was the organizational impact? What was the dollar amount impact? How much cost savings did you achieve? How many manual labor hours did you reduce, for example, right? And then for original business contributions, one of the things I want people to think about is raising it to an industry level. So not only, what you worked on was innovative, but how was it adapted maybe by other organizations, other companies out in the field, right? And for that, one of the best ways to showcase it is expert opinion letters. So recently, one of my new best practices is to kind of urge my clients, go and find 1 or 2 individuals out in the industry who are experts in their field. And an expert can mean many different things to many different USCIS officers. For some officers, an expert is somebody who has a Google Scholar profile with over 1,000 citations. Go find that individual. They might already be in your network. They might already be in your chain of command. An expert can also be somebody who is a thought leader, right? They pop up frequently in news media for, comments about what is happening in the industry. And what I'm finding is as my practice has scaled over the last 5 to 6 months, the individuals that, the one or two individuals that, received an RFE for whom I filed versus the individuals who had comparable profiles, right? That we filed and got approved, that was the difference. Those 1 to 2 letters of recommendations from renowned industry experts is what pushed those approvals over the edge, even though the profiles were similar, right? Didn't matter if it was a product manager, didn't matter if it was a software engineer, but that is something I'm seeing is really helping to set people apart, is having those strong letters of recommendations for your original business contributions criteria. For software engineers, it's very similar, right? We still need to prove that your work is critical at an organizational level. We still need to prove that the work you're doing and it's innovative, right? And you can do that in separate ways. Some clients of mine, they have patents. Some of them have papers, research papers or conference papers associated with those projects. Some of them have open source work, right? That they can point to and say, hey, the work I've done is laying the foundation for other developers to build on top of it, right? I sometimes have clients who come in who have done code reviews, right? Technical reviews out in the industry. I've had clients who will maybe go to freecodecamp.org and they will write blog posts about best practices, for example, in C++ programming, right? So there's different ways that you can come at the criteria that are kind of outside the box of just your traditional research, academic, PhD background. So that was kind of the TLDR of that answer.
Thank you so much, Prashant. I mean, that was pretty detailed and what we really need. Thank you so much for walking us through all these highlights that we really need to keep in mind. And at this moment, Prashant, we've got some friends who've joined us and who are commenting. So I'll just quickly say hi to them. It's My Channel says, good morning, Prashant. And then we have Kavya's questions. We have Amarjeet. Folks out there, please stay with us. We are going to touch up on your questions very, very soon. And yeah, thank you so much. Okay, Amarjeet. No, okay. Let's head on with our questions. I have one more question for you, Prashant, and that is, what level of professional achievement or recognition is generally required for software engineers and product managers to be considered for EB1A eligibility?
Yeah. And this is kind of a sliding scales question, right? And what I mean by that is in terms of what qualifies somebody from a recognition perspective can mean many, many different things, right? Recognition can be somebody that has multiple papers and research articles published. It can be somebody that has multiple conference papers, multiple blog posts. It can be somebody that has a very robust GitHub repository, for example, somebody that is very much involved in the Android developer community, for example. And recognition can also be thought leadership. And I like to call thought leadership basically like your speaking engagements, right? I do have clients who are invited to speak to DroidCon, right? Or they are invited to speak at AWS reInvent. These really big industry conferences. Cisco Live is another one of them, right? So recognition can take many different forms. Recognition can also be, how is your work being adapted in the industry? So if you don't have patents, that's fine. But if you have somebody that is talking about how they've taken, your technical work, learnings from you and adapted it in their own workplace or in their own organization, all of a sudden that becomes very impactful, right? But, I always recommend, like, if you want to get recognition in the field, think about in your industry, what podcasts can you be a part of, right? And for product managers, there are multiple podcasts. There's some at the product school. There's one called Exponent. There's a podcast that's done by an individual over at University of Washington. You can participate in those sorts of avenues, if you're a product manager, to really get your thought leadership and your recognition out there, right? And that will help you from a final merits perspective. if you're typically, what I see my developers, what they've done is they're typically speaking at these industry conferences, or even academic conferences about the work that they've done, right? And that will help you build your thought leadership, right? And the type of conference you present at is going to depend on your profile. For example, I had an Android developer who presented at DroidCon, right? I had a machine learning engineering manager from Pinterest who presented at AWS reInvent because he built their machine learning platform in partnership with AWS, right? So it made sense that he was presenting there. In addition to that, he had about 3 or 4 other conference speaking engagements within his industry, within his specific line of work, right? So this is going to be very relevant and kind of particular to the makeup of what your EB1A profile is and the story that you're trying to tell, right? It doesn't make sense to go and present in a conference that's about graphics technologies, for example, if you don't work in that space, right? Or if you're a data engineering doing AI/ML work on recommendation systems, right? Has to be very relevant. You have to find those opportunities that make sense for your story.
Definitely, without any doubt. Thank you so much, Prashant. And, I would really like to take it's my channel's question for now. So let's go for it. 2 design patents, one IEEE paper publication, reviewed or judged 3 technical papers. Can I still qualify in the expert category, or what is your suggestion to make this profile more stronger? And what are
Yeah.
the areas that I can add?
Yeah. So I think with the design patents, right, we would need to learn, hey, do you have any citations associated with them, right? That's going to be important. Same with your IEEE paper. If you have 2 patents and 1 paper, but you have 50, 60, 70, 100 citations, that shows that it's very impactful work, right? So your next step should be the people that have cited your work, cited your patent, cited your papers, identify the individuals that are, really renowned. And what I mean by that, are they academic experts? Is somebody there who has, cited your paper that has over 1,000 citations on Google Scholar, or has a lot of media attention, for example, for the work he's done? And can you potentially get a letter of recommendation signed from that individual, right? I think reviewing and judging 3 technical papers, that's fine. I would always urge you to do more, right? Because, I'm seeing my clients and they're reviewing 30, 40, 50 conference papers, right? So if you think about it, that is who you're going up against, right? So I would say do as much as you can when it comes to the technical review work in as many prestigious conferences as possible. And you can very easily find the prestige of a conference by going to research.com, right? And searching, for example, within the field of computer science, what the ranking is. If they're not even on research.com, you should seriously consider whether it's worth pursuing that opportunity. In addition to that, one more thing I want to mention, don't be disheartened by the fact that you only have a couple of patents, right? Because I had a CRM engineer from Salesforce, 1 patent, 4 citations. That was it, right? But what we went and did was we drafted a letter of recommendation from an individual that cited to his patent, that talked about how they took inspiration from his patent and the work that he did, right? So if you can get a letter of recommendation like that, obviously the patent proves that your work is original. We also need to prove that it's influential, right? And so that letter helped us show that his 1 patent was influential in the industry, and he did end up getting the EB1A approval. So not somebody that had a robust patent or research background, but somebody who was able to prove that the one thing he did in the way of a patent was influential. Somebody did take inspiration from it, right? So just something to think about in terms of how you build your profile moving forward.
Yes, very much. Thank you so much for highlighting that, Prashant. And I think it's very important to make your profile stronger and as attractive as possible, I think. So thank you
Yeah.
for that tip, Prashant. And thank you, It's My Channel, for participating. Please keep commenting if you have any further questions. And now I think we should take up another question, and this is from Kavya.
Kavya is saying, my contributions are mostly collaborative, working as part of a team rather than leading solo efforts. Can I still qualify for EB1A? And does the process amount for team-based achievements, or do I need to show individual recognition? And there's
Yeah,
another
good
question,
question.
but we will take that later.
Yeah, good question. So no one is a one-man army, right? Like none of my clients have ever operated in a vacuum, right? Like you're either a software developer or a data engineer or a cybersecurity person or a product manager, but you're not everything, right? And so you have to keep in mind that what we tried to highlight in an EB1A is your specific contributions, your specific technical tasks, your specific original contributions or innovative contributions, right? Um, if you're an author on a paper, you might be a co-author, right? But that doesn't mean that you didn't contribute to it just because you were in a team-based or collaborative environment. 99% of the time, that is absolutely the case, right? And that's okay. But what we like to extract by way of letters of recommendations is your specific contribution to that project, right? And my job is to make it seem like you did everything, right? As your attorney, as somebody that's going to represent you, right? I'm not here to talk about what your team did, right? I'm here to talk about the impact you had, your specific technical contributions, and then connecting it to an organizational level impact, connecting it to any news publications, any media, anything of that sort that has, like the project you've worked on, if it's gotten that attention, then we leverage those as exhibits, right? And I'll give you an example here. I work with many clients from Meta's AR/VR team, right? Meta's Reality Labs team. You can find a lot of news publications out there about how, Mark Zuckerberg has basically created like a 10-year roadmap or a 5-year roadmap for the Reality Labs team, how it's important to Meta's organizational goals and strategies, right? So automatically we know that if you're working on a project for AR/VR at Meta, it is organizationally important. It is important at a CEO level, right? And we've got news publications to prove that. If you are working specifically, let's say, within the wearable devices vertical of Reality Labs, right? I've had a client who does that. There's news publications out there, right, about the innovative nature of the wearable devices strategy that Meta has, right? So we automatically, can connect it to something that's newsworthy, talking about the fact that your work is innovative and also influential because it's going to impact the millions of customers that are buying the Quest headsets, right? So again, none of this happens in vacuum, right? But our job, my job, is to extract the specific details related to your specific contributions, connect them to those higher level organizational goals, connect them to those news publications that are talking about how this work is important at an industry level, right? So that's what I would say. Anybody can really qualify for the EB1A. We just need to highlight your specific contributions.
Right. And what about this last part of the question that she had, that Kavya had? How can I highlight my role and impact within a collaborative setting? Any
Yeah.
tips?
Yeah. So what I do is I always send my clients a worksheet, right? So like we get on a consultation call, I learn a little bit about you. I either say you're ready to move forward or you have more work to do, right? I'm going to be very transparent about that because the last thing I want is a bad customer experience, right? I don't want you to think you qualify for something you very clearly don't, right? And in that worksheet, I extract those details, right? What were your specific contributions? What were your specific technical tasks? What was the organizational outcome that you were trying to achieve? And we draft letters of recommendations around that, right? Letters of recommendations can come from your managers, they can come from members of cross-functional teams, they can come from peers. If you work with end clients, right? So for example, I've had some clients who are management consultants, let's say at one of the big SI firms. You might get a letter from one of your end clients talking about the work that you've done and how it was impactful, right? So that's how we come at it. In addition to that, I find that my clients are very good at leveraging their performance reviews, right? So if we are talking about a specific project that you've worked on, more often than not, your work on that project is also being captured in a performance review. So we can add that as a layer of an exhibit stating, hey, here's this LOR saying what this person specifically did, how they are furthering these organizational or industry-wide outcomes. And oh, by the way, here's a performance review talking about, in addition, like all the stellar work that they did for this project, right? That becomes another objective piece of evidence.
Thank you so much, Prashant, for the detailed explanation for Kavya. And Kavya, I hope you've gotten all your answers. And we have It's My Channel back again saying, perfect. Thank you so much. And we have Dan Nandan saying his explanation is very clear and sounds like a radio personality for sure. I mean, really, Prashant, for sure. Very, very clear in how you explain. And now we have another question from It's My Channel asking, I would like to ask one more question on the memberships. Do you have any suggestions other than the IEEE or BCS?
Yeah. So here's the thing about memberships. If you don't have a research background, in the sense that if you're not doing journal papers, conference papers, you're not doing blog posts, you're not reviewing conference papers or journal publications, IEEE really doesn't make sense, right? And neither does IET. IET is another technology kind of research organization. And both IEEE and IET only make sense for people if they have that research profile. Otherwise, it just looks like a check the box exercise. And when I see that with a client, I tell them, like, I'm not going to use this as a membership. You need to go do some review work, right? You need to go do some authorship. And that way your membership is going to look good, right? In terms of professional organizations, BCS is obviously the one that I see come across my desk most often. There are others, Royal Society of Arts being one of them. There's one called Sigma G or Sigma Chi, right? XI, that I also see my clients leverage. What I'll say is this: memberships is oftentimes one of the most difficult criteria. Membership and awards is two of the most difficult criteria to satisfy, right? So if you're going after it, just make sure that the organization you're going after fits your profile. If you don't have a research profile, don't do IEEE, don't do IET. If you have a professional profile and BCS might be taking too long, go and explore the Sigma Chi, go and explore, for example, Forbes Technology Council or Royal Society of Arts. That those will help you satisfy the membership requirements. And then high level, one of the things I want to say about memberships is USCIS really cares about the organization's bylaws. Okay. Bylaws are extremely important. Don't go and join an organization that has not memorialized their process into some sort of governance document or some form of bylaws that says this is the criteria that you need to satisfy the membership, right? These are the outstanding contributions we require of our members. In addition, take it one step further. Make sure the bylaws also discuss who qualifies to make those decisions about membership, right? That's very important. Some USCIS officers like to see those details. Where in the bylaws does it say this is the selection criteria? Where in the bylaws does it say these are the people that are going to be making those decisions, and these are the qualifications required for the membership committee, so to speak? And then the third one, what are the qualifications of that membership committee, right? So that information also then needs to be publicly available. So you want to be very careful with memberships because there's many pitfalls there, right? It's not just enough to go and get it. You need to be able to support your membership with bylaws and governance documents and all of those different pieces of information.
Thank you so much, Prashant, for taking that up. And We have some more questions. Let's take up Nirvana's question now. This is next on YouTube. Nirvana is asking, when talking of high salary criteria, how much we are talking of? Does officers go with what is mentioned in the LCA?
Okay. Level 1 to 4 wage means nothing to me in EB1A, and I think it means nothing to a US CIS officer, right? I have had clients who will try to argue with me that you should, include my salary criteria as criteria number 6 or 7, because it's a level 3 or a level 4 wage. It means nothing, right? There's no point of reference, right? And what I mean by that is there is better data out there. Bureau of Labor Statistics specifically talks about what the 90th percentile of software developers, product managers who can be qualified in the SOC code of marketing managers or IT project managers, depending on your role, data scientists, for example, all of the statistics are available on government wage databases, right? So Bureau of Labor Statistics, Career One Stop, ONET. I always start there. If you are not in the 90th percentile in one of those 3, salary is a no-go, right? Because on the USCIS policy manual for salary, those are the 3 that they list right off the bat. Like, this is the starting point, right? In addition to that, we provide commercial wage data. Glassdoor, Indeed, ZipRecruiter, Levels, PayScale, Salary.com, right? Those further substantiate the fact that from a commercial perspective, this person's in the top 10%, right? And they also have those sorts of point of references like top 10%. ZipRecruiter actually takes it a step further and can even get as granular, I think, as like top 3%, which is great. Now, the third layer of exhibits we provide for salary, and this is something I had to learn over the last 5 to 6 months, because I was only doing that level 1 and level 2, which was the government wage data, the commercial wage data. I've now turned it up a notch with the level 3 wage data in the sense, and I use level 3 very interchangeably here. I don't mean level 3 as like the LCA, but I use level 3 as in a third tier of exhibits that we're providing is related to professional organizations, right? So, for example, there are staffing agencies out there that are well reputed. Robert Half, for example, ranked as a top 5 staffing agency by Forbes. Mondo, ranked as one of the best IT search firms in the country. These organizations, they provide wage data based on their placements, right? So now I've been starting to provide professional organizational wage data as well to further substantiate the salary criteria. I don't care what's on the LCA, right? Like, baseline, you got to start with the government wage database first.
Thank you so
How
much for
much
that,
total?
Prashant. And yeah, and Nirvana is saying one more. I see a lot of PR agencies. Is it lawful to take help from them?
I laugh at this one because don't work with the PR agencies. I apologize to all the PR agencies out there, but the problem is they will get you posted on USA Today. They will get you posted on Tech Times. They'll get you posted on Tech Bullion, right? MSN, Benzinga, et cetera, et cetera. The problem is after every article or at the beginning of every article, they put a disclaimer that's there that says, this is not the opinion of USA Today. And that's a problem, right? Because all of a sudden, we're arguing on the publications about you criteria, and it automatically gets discredited by the fact that USA Today is saying, hey, I didn't put this out into the world, right? Like somebody else did. You're going to have a world of a problem, very incremental value, right? So do not pay PR agencies to get you posted somewhere because it will backfire, right? Like those disclaimers are only going to hurt you, and they're everywhere, right? So save your money, spend your time elsewhere.
Okay. And what about, what he asked earlier? How much total criteria should be enough? Well, that is a question. And Does too many of them pose threat of for RFE as well?
Yeah. So like, here's my best practice, right? I like to go in with a minimum of 4, right? I never go in with just 3. I learned pretty early on going in with just 3 puts you at a disadvantage, because if USCIS RFE is one of them, right, you don't have much background, right? If you go in with at least 4, and let's say 3 of them are very strong, right, and one of them is 50-50 or a little weak, you still have a good chance of approval, right? 4 and above, your chances of approval, from what I've seen, go up significantly, right? In terms of having too many criteria, what I would say is, if you can comfortably argue on 6 or 7 because you qualify for them, do it, right? If you can put forth a reasonable argument for 6 or 7 criteria, that's totally, but don't try to do something underhanded, right? So, for example, don't try to make criteria number 6 or 7 salary when the government wage database clearly says you're not in the 90th percentile, right? Don't try to slip something past an officer from a criteria perspective, which is going to discredit the rest of your application, because then they're going to start thinking, oh, they're trying to convince me of something that, like, very clearly they don't qualify for. What else are they trying to convince me of, right? So I think the most I ever argued on was 7. And I even told the client, like, look, 2 of them are pretty weak, 5 of them are very strong, right? And I think those are the 5 that are going to carry you at the end of the day, right? And they probably did, because he ended up getting the approval. And you don't know which criteria you end up satisfying when it's an approval, but you know, I know pretty early on in terms of like which one's actually gonna resonate with USCIS, and which ones are not, right? Argue for as many as you possibly can, as long as it's within reason, right? And as long as you can put forth a good argument.
Mm-hmm. Right. Thank you so much, Prashant. And those were really insightful tips and advices. Also, thank you so much, Nirvana. I hope that you've gotten most of all your questions answered. And if you have any more doubt, you can keep commenting. Well, it's my channel also said that that's a long list, but thank you, Prashant, he says. Anyway, I have a few more questions, Prashant. I think I'll share my screen for now so that we can take them up. I was telling you about some of our Facebook groups, so this will be easier. All right. So let's go with this first one. This is an anonymous participant asking, has anyone here worked with, I'm looking for filing my EB1A petition and would like some thought. Okay, not this, this one. Is the interview backlog different for EB2NIW and EB1A? Does anyone have any idea of which dates are scheduled for EB1A interviews at the Islamabad Embassy or Abu Dhabi Embassy?
Yeah. So what I can say, like, at least speaking from the perspective for individuals within the US, because that tends to be 99% of my clientele, you don't have an interview for the EB1A or the EB2NIW, the EB2 or EB3, right? The only time I've ever seen employment-based petitions get an interview is if, let's say, somebody changes a job, for example, right? And the USCIS officer would like to verify that they are continuing to, let's say, work for that new employer, right? But none of my EB1A or EB2NIW clients have ever gotten an interview from within the US. Now, if you do consular processing and you're doing your interview from abroad, yes, the entire process of consular processing involves a visa interview with a visa officer, right? So it's slightly harder, I would say, when you're doing it from abroad. But in terms of specific timelines for those 2 embassies, would not be able to tell you.
All right. Thank you, Prashant, for taking that up. Now I have this next question. This is, please help on where to publish articles for EB1A, or let me know which journals are eligible. Thanks in advance.
Yeah. So this is dependent on a couple different things. One is just your overall profile, right? Are you a software developer that's working within the Android ecosystem? Are you a data engineer working with AI/ML, right? Are you a developer working with AR/VR technologies, right? And graphics technologies? Are you a UX designer, right? Because the answer is going to change with each of those profiles, right? I recently had a data engineer who got approved for the EB1A just this week, actually. The articles he came to me with was published in an electrical engineering journal. And when we were working on his analysis and all of his exhibits, he called it out. He said, "Hey, you missed this article." And I was like, "I'm not going to include it. It's an electrical engineering journal, right? Has nothing to do with data engineering and the work you've done, right?" And it breaks the continuity of your story. So what I would suggest is if you go to the IEEE website, right? IEEE has a list of conferences that they sponsor. Research those conferences, right? Type in the conference name, type in the word ranking. Research.com will tell you its ranking if it's ranked. Those are the types of conferences or journals that you want to be publishing in, right? The ones that are known, they're reputable, they have a peer review process, for example, right? That is what I would suggest. Now, let's say you feel the journal writing process, the conference paper writing process is very tedious. I've had clients tell me that. Totally fine. There are other avenues out there to satisfy the authorship criteria. For example, freecodecamp.org. Free Code Camp is a nonprofit organization, right? And they teach people how to code for free. And in order to even qualify to be a blog writer on Free Code Camp, you have to go through a vetting process. I think they only accept 30% of their applications. But the great thing about it is if you go to their LinkedIn page, 60, 70,000 people claim that they learned coding from Free Code Camp. And they will also help promote your blog posts, right? And your technical articles. That is another way to satisfy the authorship criteria, right? Doesn't have to be journals, doesn't have to be conference papers. You can get creative with it. I've had clients from Pinterest, from Meta, from Amazon, where these organizations have channels to publish technical blogs, right? And I've had clients participate in those technical blog process, and they're able to show me that, hey, these blogs are getting viewership, right? They reach out to those marketing teams internally, they find the viewership statistics, and we provide that as an exhibit to show that, hey, this person is authoring scholarly articles. It's just not in the traditional sense, right? But it is for individuals that might be, the intended audience is a data engineer, cybersecurity professional, whatever that might be, right? Another way to think about it is trade publications. So I have had folks in cybersecurity who do co-authorship with the Cloud Security Alliance, for example, right? So there's different ways to think than your traditional, journal papers, conference papers. But if that's the route you go, just be sure that those conference papers, those journals, those conferences and journals are like reputed, they're ranked on like research.com, for example.
Awesome. Thank you so much, Prashant, for giving us that insight. And now we have Vibhor asking, my company is 1 year old in Washington. Can I apply for L1A visa via road through Canada and I'm a Canadian citizen? I think the answer is yes. Once I get L1A approved, question is, can EB1C be processed quickly by paying money? And can I get green card within a year? Do you want to take this up? It's not EB1A.
I can answer the question totally fine. So with regards to EB1C and the EB1 categories, right? One of the things you want to keep in mind is the priority dates right now, I believe, are in 2022, right? So if you are coming on an L1A, right, as an executive, you can absolutely apply for your EB1C 1 year, let's say, after you enter the country, and you continue to maintain your managerial, executive capacity and executive duties, right? Or really whenever your company is ready to apply for it. So as long as in the previous 3 years, for one of those years you were employed abroad, let's say in Canada, you come back as an executive to the US, your company can apply for an EB1C for you. Okay. Now, if your priority date, let's say, is January 1st, 2025, just hypothetically speaking, right? If it's January 1st, 2025, in the EB1 category, you are probably not going to be eligible to get your green card within 1 year because your priority date is not, 2022 and before that, right? Or whatever it might be in the future. Chances are, if you get a priority date that is 2025, for example, you might be waiting 2 or 3 years before you can even apply for your 485 applications and get your green card, right? It's just how the priority dates work. In EB1 category right now, they are not current.
Thank you so much, Prashant, for taking that up. And I have one more question from one of our previous shows with you, EB1A, building a profile to qualify for EB1A category. And we had Arjun saying that it was a very good session, and he had one question. How about the applicant had suitable criteria for EB1A 15 years ago, but now he is into different job sector and current situation is not suitable for the criteria? Can this still be a valid case for EB1A petition?
Yeah. So the thing about it is USCIS wants to see it over a sustained period of time, right? If you did something 15 years ago, let's say a whole lot of research, right? A whole lot of reviewing the work of others, but then there's a 15-year gap. One of the things that some very hardline USCIS officers like to see is that the work you did was over a sustained period of time, right? So critical and leading role over a sustained period of time, judging the work of others over a sustained period of time. If there's a significant gap like that of 15 years, I think that's going to be challenging for an EB1A, right? Unless, your authorship and judging the work of others criteria, which I'm just going to assume happened 15 years ago, right? For purposes of this question, if you have 3 or 4 other strong criteria and those 2 are kind of weak because they happened a decade and a half ago, I think you'll probably be okay. But if you only have 3 or 4 criteria and those are 2 of them, you're going to have a problem, right? I don't think that EB1A application would get approved.
Thank you so much, Prashant, for taking that up. And we had more questions, but I think we're good for now. I think I've taken up most of them. So we'll move back to our questions, Prashant, now. And I have this next question for you. So my next question is, what role does professional networking and peer testimonials play in an EB1A application? And are there any best practices for product managers and software engineers to secure strong endorsements? You've already highlighted some how these testimonials or recommendations play a very important role. So if you could just tell us more about the endorsement part.
Yeah, absolutely. So I think there's a few different ways, right? So one way that I use endorsements is like sometimes my clients have LinkedIn recommendations, right? 10, 15, 20 LinkedIn recommendations. And I leverage that from a final merits perspective, right? So I'll give you an example. I have had clients who have participated in those thought leadership engagements, right? So they've been invited to speak at conferences, or maybe they've been invited to speak on podcasts. In addition to that, I highlight the fact that, hey, not only are they getting this industry recognition through these speaking engagements, but they're also recognized by their peers. Look at these LinkedIn recommendations accumulated, right? So I would say if you don't already have them, start thinking about, asking people for LinkedIn recommendations, right? Specifically related to the work you've done, specifically related to the capacity in which you interacted with them, right? It can only help you, certainly will not hurt you. Okay. Another thing is, I would say, folks tend to burn bridges very quickly, right? So you leave a job, you kind of forget about your previous manager, you forget about your previous colleagues, and that's natural. It happens. One of the best individuals, one of my best clients that I've seen really do this well, he built relationships over the last decade. And he was able to go back to his manager, a couple of colleagues from his time when he was an intern at Meta from 2013, when Meta was called Facebook, right? He was able to go back to that time and get letters of recommendations from people from 2013. And it's because his relationship building and maintaining skills were just exceptional, right? So you want to make sure that you are doing them so that when the time is right, when the time comes, people that you have networked with, the people that you have worked with are willing to sign off on those letter of recommendations for you, as opposed to saying like, why are you coming back to me 10 years later, right? Build and maintain relationships, right? If there are think tanks, if there are organizations in your industry that attract the type of professional you are, get involved, volunteer, build those relationships, make sure they get to know you and you get to know them, right? Because at the end of the day, if you can build one or two of those relationships like that from renowned experts in the field, right? Those people that have the media publication, the media attention, the people that have the Google Scholar profiles that are very reputable and very much recognized, those become very powerful LORs for you. So build relationships, maintain relationships, at least for individuals that you identify can help you with your EB1A application later on.
For sure. Thank you so much, Prashant. And do you have any success stories or anything along these lines that you would like to share with us before we leave today?
Yeah. So I send out a monthly newsletter, and in that newsletter, I like to highlight. Nowadays, it's basically just all taken up by EB1A. But I like to highlight in those newsletters, some of the success stories that I've been seeing. And of course, it encourages other people, right? They see other people's profiles who are going through the EB1A process and they become encouraged themselves, for example, right? So I will share a couple of those success stories from this month. So this month, we've gotten 3 new approvals. Those have not gone out in my November newsletter because my newsletter goes out at the end of the month. One of them is a data engineer, right? And one of the things that he did in terms of satisfying criteria for awards, he had the Business Mint Awards and the Global Recognition Awards. I don't think that's one of the reasons why he got his EB1A, though. We also argued on critical and leading role. So he had implemented certain projects, for example, in the state of California, as it related to their electric metering system and modernizing that system, right? So not only was that project important for the organization that he worked for and that he was contracted out for, but it was also innovative and influential, right? Because it was impacting millions of customers in California. Mm-hmm. He had judging the work of others, right? So he had done conference paper reviews, journal reviews, in data engineering related conferences and publications. He also had authorship, right? So he had worked on papers that had accumulated over 170 citations over the last couple of years, right? Salary was not one that we argued on for him, right? So based on that profile, he got approved. I had a client from Meta who got approved this month. He is a AI ML engineer, and this individual was very notable in the sense that he had about 10 patents, I believe, 10 or 13 patents that had been cited over 100 times in the industry. He also had a couple of conference papers that kind of memorialized the work he was doing at Meta. And so for him, critical and leading role, yes, right? We were able to prove that the work he was doing was important at an organizational level, right? Because if you think about it, everything within Meta, is the engine behind it is recommendation systems. So the next reel that you see, the next post that you see, it's all recommendation systems. His patents helped with original business contributions. The letters of recommendations that we drafted for him were from professionals in the industry that had over 1,000 citations each, right? And we had 3 or 4 letters like that. He had salary, he had judging the work of others, he had authorship because of those conference papers, and also original scholarly contributions because those conference papers were well cited. So we argued on about 5 criteria for him, and he also went through the process just fine, right? So I think, to kind of like tie a neat little bow on it, you don't have to have a PhD. You don't need to be an academic to get an EB1A, right? And that individual who I just told you the story about, who had like the 10 or 13 patents, in our consultation call, he was like, I don't think I qualify. And I was like, no, I think you do, right? Like, I think you've been told that this is what a certain profile should be for the EB1A. I think you've been told that 100 citations don't qualify, right? But in fact, it does if we, build everything carefully, if we demonstrate your industry impact carefully, we demonstrate your organizational impact carefully, I think you're going to get this. And he did, right? So there's a lot of misconceptions out there about who qualifies for the EB1A, right? And it's really important to know that anyone can build a profile towards an EB1A. Might take you a little bit of time, but you can do it.
Thank you so much, Prashant. That was really very insightful, and thank you for sharing your. I mean, on the other hand, it's also your success story. Your client success story is also your success story. So
Right.
definitely, it was really good to hear about that. So. Yeah, lovely having you, by the way. It's been a while, and it was such a great and insightful discussion today we had on the topic can product managers and software engineers qualify for EB1A? And it was great having your tips today. Prashant, do you have any end note before we wrap up? I mean, it was already great, but anything else you want to leave our audience with?
Yeah. I would say, my parting thought is, or thoughts. One, Nipasa, I told you we would only get through like 4 of our questions because I take 5 minutes to answer like each of them. But I'm glad we were able to answer more questions from the audience. I think the audience definitely found value from that. So thank you, audience, for asking. Thank you to the higher IT team, right, for hosting me and making this a possibility. And also for anybody out there that's looking to explore the EB1A. I don't care if it's you coming to me or to another attorney, right? But don't be discouraged by the fact that you don't have a certain background or you don't have a PhD or you're not an academic, you're not a researcher, because I would say 50% of my clients are not, and they are still getting the EB1A. It just takes some time. It just takes the appropriate amount of preparation. And that's okay because the EB1A, it's a marathon and it's not a race, right? You are going to save yourself decades of GC processing time if you can qualify yourself for this category.
For sure. Thank you so much, Prashant, really. And we highly recommend getting in touch with a qualified immigration attorney, and why not attorney Prashant Dubey as well. And you've got his email address, and his address is how to subscribe for the newsletter. Is there a URL? It's my channel is asking before we go. Yes.
No, but that gives me an idea. I think I should automate the subscription process because right now I just manually enter everybody's email into the newsletter, and it like builds up my audience. So that gave me a great idea. Just email me, please, right? And
Yes.
I will make sure you get my November newsletter and all my newsletters moving forward.
Perfect. And you can email Prashanth Dubey. His email address is info@dubeylawoffice.com. You can check out the spelling on the screen and note it down. Thank you so much, Prashanth. Really lovely. And since we couldn't cover up most of our questions, we would really love you to join again. And even if not EB1A, we can have many other topics to discuss if that'll be fine. I'm hoping to have you visit us regularly again.
Yes, that's the idea. Thank you for having me.
Perfect. Thank you so much. Have a great day. Have a great weekend, Prashant.
All right. See you. Bye.
Bye-bye. Thank you, friends. Thank you so much. And before we close, just a quick reminder that if you found today's episode helpful, please do not forget to like, share, and also subscribe to us. We are Immigration and Jobs Talk Show. We are on YouTube, LinkedIn, Facebook, Twitter. We're also there on Instagram. Check us out, and it'll be really lovely to have you join us. And your support helps us bring more expert discussions like these. So hit that bell icon as well so that whenever we have webinars like these, you are notified and you can join us. And in case you have more questions on this topic, you can keep commenting because we would love to get back to you. And of course, stay tuned to our channel, Immigration and Jobs Talk Show, because we have more webinars coming up today. In fact, in just an hour. And also at 4 p.m., we have Daily Immigration Dose, which I join with my co-host, Samriddhi, and it's going to be a great discussion today as well. We just started yesterday. I hope you enjoyed it, and I hope to see you later. So thank you so much for joining us today. Bye-bye for now. It's Nipasa Pradhan signing off from Immigration and Jobs Talk Show.